Hey there. Grace and peace, everybody. You saw the thumbnail. You saw the title. You know what we're about to do. We're about to get at this. I need to cut this audio in my ear. All right. We ain't paid the light bill just yet, so we gotta get the light bill paid. Give me a second. Give me a second. It looked good before we went live. I was like, oh, this looks okay. I'll leave one of the lights down. I don't think that's a good idea. Hopefully everybody's having a great morning. Good morning to you all. We got another fun one. I think it's going to be a fun one at least. Now, if you were tapped in on yesterday, you saw all the shenanigans and chicanery with Detective Dennis. And I think there's going to be a lot of problems that come out of that. Just kind of put my ears to the street, listening to other legal minds and such like that. I think Dennis messed up more than we realize, but we'll talk about it. We'll talk about it as I understand what he did wrong. But just it wasn't just that they kicked him out of there and they got rid of the gang expert or the rap lyrics expert. He actually created more problems than we realize. So I'm gonna we I want to make sure I have it properly understood. And I might even tap in some other people. Mo might jump in or Rome King and whatnot. But he actually did he messed up a lot. So before we get into it, because I'm ready today. Producer Jason is ready. We're gonna get it together today. So before we do any of that, if you don't mind, hit that like button, jump into the best live chat on the planet, say what's up to everybody else. Thank you so much to everybody who came to the members only live stream last night, looking at Woody's conversation, most recently on his channel, Woody versus Woody channel. And we had a good conversation about that, Rome King and myself. Excellent conversation. Shout out to Ray, came on and talked a little bit. Good to hear from Ray finally in person, if you will. So it was a good conversation. I want to say thank you all to all of you all for not only tapping in every day, but for just taking the time to watch the videos. Lots of you watch it after the fact, and I appreciate you watching it. I appreciate you commenting, definitely commenting. I appreciate you contributing to all of the shenanigans and chicanery. I'm just going to give you a little snippet. Just going to give you a little snippet so you kind of know what to expect. Like Jason, what are you talking about this early in the morning? Have you had your coffee this morning, my guy? That's a great question. I am coffeeed up, but I want to give you a quick. There we go. I'm gonna pull this in just so y'all can see it real quick. Uh, uh, Tomorrow we're gonna be playing YSL Bingo. YSL. Please forgive me. YSL Jeopardy. And let me tell you already, it is hilarious. So shout out to everybody. Man, I put out the ask and you guys came in droves. There were tons of good questions. I guess what do you ever want to call them? Comments, questions in my email. Thank you all, every last one of you. So tomorrow evening, 8 o'clock, we're gonna play YSL Jeopardy. I'll tell you already, it's gonna be ridiculous. So I want to thank everybody who contributed. But wait. Before you say, well, wait, Jason, I didn't contribute mine. Have no fear. I'm gonna do this more often because this game is gonna be so much fun. There's gonna be no reason not to do it again. So, real quick, the camera is on over in one Charlie. So let's put it on, bring them in. So tomorrow, 8 o'clock, check the community post because I put that up there to let everybody know that we're gonna be playing that tomorrow. So I thought it'd be a fun way to kind of recap some of the shenanigans and chicanery that we've seen in this trial. But definitely thank y'all so much for this. Let's get ready and see what kind of happens. They already got somebody moving in here. They ain't playing games today. She said 1:45. 8:45. We're gonna see what she does. Oh, you have zero idea. It's gonna be ridiculous. And I'm gonna start asking for more so we can start populating for the next one. But I got some specific things I'm gonna ask for. So don't send me anything yet because we're gonna level this up another notch after this. Hey, welcome so much. Rabbit 1969 is a new member. Welcome to the team. Thank you so much for becoming a member, getting slimed out. I appreciate y'all. But this is going to be interesting today because I really think, and I have to give props. I did kind of hear this morning. I was listening to Monica Mo Justice. There she is, grace and peace. I was listening to her this morning, and I was like, yeah, Dennis messed up a whole lot more than we realized. So shout out to Monica. She was dropping some knowledge, and I need to go back and kind of hear what she said this morning on her morning show. But Dennis might have messed up a little bit more than we realized. It might have created a few more cracks. Now it depends on how the prosecution tries to recover from this, if they're able to, rectify some of the things that he did. But we'll talk about it for sure. But yes, thank y'all, everybody who's already tapped in. Thank y'all. Looks like 250 y'all are already watching. That is insane. Thank y'all so much this morning. I appreciate y'all. And I'm just checking to make sure there's nowhere I really want. The audio has been sounding pretty good on theirs, except for whatever was happening with the muting yesterday, which was crazy. But the audio sounds pretty good on Law and Crime. So I'm gonna leave it on Law and Crime today. But I appreciate all 170 of y'all that have already hit the like button. I need to hit the like button myself. There we go. How dare I? How dare I? Real quick, check and make sure we got everything. I need to find out how many of you all are in the metro Atlanta area, because I'm going to be doing a meet and greet on the 16th of November. And have no fear, more information will be forthcoming. But I think I'm going to do a meet and greet in Atlanta on the 16th. I need everybody. I need Antonio to show up. Now, whatever day it is, I need Antonio to make sure he shows up. I need my truck driving brother to come on through so we can actually shake hands. So stay tuned. There'll be more information forthcoming. The 16th of November is a tentative date for a live meet and greet here in Atlanta. Let me just double check, make sure the audio is on. Okay, we're on. All right, they're ready. They be popping in and they just be starting. Page be just getting going. Hey, grace and peace, adventures in Red Man Bone. Good to see you, sir. There it is. Hey, Reed, how are you? Grace and peace. Good morning to you, Dream. I see you, Donna. Thank you so much for stopping on through. Please make sure you email management any concerns, questions, or comments. Absolutely. Bunny, good to see you. Always good to see you. Kristen, did I send you that email? I want to know about this car launch thing that y'all do up in Alaska. I think I sent you my email back. I gotta make sure. I'll check it in a second. Good to see you, Miss Gibbs. Lady Gibbs, good to see you. He was going to do that one to try to tie many things together. Right. That's why they had him. That's why Dennis was there. Ladies and gentlemen, they're ready to go. Let's go. Bati's here. Okay. She looks so tired. Bless her heart.
Yes. So we've got Suri Chada here for Mr. Nichols today. That's CHADA. Is that right? SURI. CHADHA. Sorry. NEZ. Okay, good.
Fun fact, that's the guy that had to buy his coworkers lunch and bought them lunch from Magic City.
Jimenez. That's SURINDER CHADHA Good morning, Your Honor.
Good morning. There was a motion for reconsideration filed by the state yesterday afternoon. Could the defense file whatever response they want to file before Monday at 8?
Good morning, Your Honor.
Morning.
I could do that, or we can just argue it now. I think the state's cases and facts are not lined up with the reality of what happened in our case, and I don't believe that. I think it's specious. So I don't think, if you want, I can respond in writing, but I don't believe that the state's motion in any way should affect our time in this case, and we should move forward. And that's my position. I put it in writing, but.
All right. Well, what I'd like is if there are any post new evidence code cases with similar facts to ours. So I'd rather have something in writing if y'all don't mind.
I will, but there's a ton of
All right. Well,
cases.
you don't have to give me everyone. Just,
So the state is wrong.
okay. I don't want to argue it right now. I want a written response. All right. Appreciate it.
Your Honor, may we
Yes.
approach about another matter?
Yes. So, hello, Mr. Armstrong. I suspect that's why you're here, but can
It's
you
too
come
early.
back on Monday instead? Thank you.
It's too early. It's too early
In
for
and
this.
out.
Yeah, I'll put Mo in the chat because yes, Mo said that there were going to be motions. Motions would be filed. Yes, yes, yes. Yeah, what's up with Mr. Nichols? All of his counsel always has ponytails. And that dude got he got some serious lockage there. I'm jealous, basically. That's all it is. I'm just jealous because I ain't got no hair. All right. So Brian has already said, look, the state's case is specious, is crazy. He's already throwing. Now, I'm wondering, is the strategy since well, I don't know this emphatically today, but since Adrian Love has been kind of distant from One Charlie, I wonder if they're just like piling on the reserve team to really get them discombobulated because Adrian is, Adrian, they can get her discombobulated too, but I'm wondering if they're just piling on and really getting them out of sorts so that they can get those cracks, they can get those small wins that were going to result in larger victories later on. So just a thought. All right, what are y'all saying this fine morning? Yeah, they already need to approach 5 minutes in, 5 seconds in. You're right, 5 seconds, not even 5 minutes, 5 seconds. The very best live chat on the planet, Miss Spiker. Absolutely. Brian Steele has been holding back. He's been super reserved. So I don't wonder if he's been cooking something in the kitchen. I don't know. He's been in the lab working on something, some tracks or something. Absolutely. Good morning to everybody that's jumped in to the live chat. I appreciate y'all. I'm just going to give y'all a heads up tomorrow, 8:00 p.m. We are going to have a lot of fun. This YSL trivia game Jeopardy game is going to be insane. I don't think anybody's done something like this. And if they have, then I'm telling you, this was still going to be better. So I will see you all tomorrow at 6:00 for sure, Eastern Standard Time for that. And good to see you, N Doug. Bless your heart. Good to see you. Love doing a poll today on the buddy. Get revoked today on my do a poll on if buddy getting revoked today on my birthday. Who's getting revoked though? Who's Sledge? I don't want I will do that. Yeah, I'll do that. Happy birthday, by the way. I will do that. I don't want that brother to get thrown in jail. I don't want that to happen to him. I really hate that. And I really hope that now, granted, they probably can say that in fairness that he did violate whatever agreement, but I really hope that he's not thrown in jail. That just seems like such an extra lap. And it only goes to show the pettiness, in my opinion, the pettiness of the district attorney's office and the fact that they are able to wield, they have more power than just if Jay Sneed and I have beef at the current moment, we are equals. We're both men. We're both brown skin. He looks like he might have hair. So that makes me a little bit better than him. But we're equals. I don't have exact power over him, aka I can't throw him in jail. I can't garnish his wages. I can't ruin his credit. Stuff like that, man. That's just dirty, man. And again, maybe he's a low down, dirty, rotten scoundrel. Maybe he's just a terrible dude. I don't know, but it's sad to see and to think that you would throw. They would because when he was on the stand, many of the factual statements that are in his plea agreement, he stated that he did not agree to those, and there was evidence that some of those things he didn't say those. Like there's things in that plea agreement that he agreed that he did not say. Now back to the point, the So because he disagreed with that, that's why they ended up spending so much time going through his plea agreement, ended up having his attorney come up on the stand and all this stuff like that. A lot of that, it didn't net them the success that they thought they were going to get by having him come up and just say, yes, I agree to all of this. And they're all just low down, dirty, rotten scoundrels. Well, he didn't do that. And because of that, they're saying that he violated his plea agreement, AKA, yeah, we're not going to drop that in there, Donna. We're not going to drop the Jeopardy labs in there. So because of that, they said he violated his plea agreement and therefore is in should have his probation revoked. I understand what they're saying. I just don't agree with it. And so that's why I was saying I hope that the brother doesn't go to jail for that, because that's just, in my opinion, that's just a lap too far. But we will see in a minute, soon enough, for sure. His revocation hearing is today at 4 p.m. Eastern Standard Time. So they're going to end this court, and I don't know if it's going to be streamed or made available for us to see. If it is, that's great. But if not, then we'll just see what happens on, new information. And I do know that Thugger Daily has something. I just saw the comment in here that good old Thugger Daily has something. So I'll go check that out. Let's go see. All right, let's look in here. Shout out to Protestia. Always something good going on over there. The Rap Act. Oh, we can read about the Rap Act today. Oh, it's not long at all. And they'll read it to you. Get out of here. The Rap Act has an audio track. If y'all are familiar, the Rap Act is the Restoring Artistic Protections Act of 2022. That's hilarious. It comes in audio form, so you can pull it up and listen to it instead of just reading it. That is hilarious. So it has its own rap. It has its own. is- Sadly, it doesn't have a good beat. So we might have to pull that in. Okay, but I was supposed to be on task. Let me get back on task here. All right, jumping over to Thugger Daily. Let's see what they got over here. On good old Thugger Daily. I see there it's a motion. Where's this motion I saw? Someone said that there was a motion. Oh, look, Calvin. I'm a rap expert. I'm a hoodie expert. Definitely an Adidas aficionado. Okay. I teach classes about Adidas. Definitely, unequivocally, an iced coffee maestro. I'm the Beethoven of beats. I mean, I'm here. I'm here for y'all. I'm the Mozart of music. I'm all things, man. I've trained myself. I've trained myself in all of these areas. So many of them, actually. So many areas. So many. I'm the Bishop of Books behind me. The bearded Beethoven. Come on, man. I'm here. Don't challenge my expertise. Don't sweat the technique. I'm here for it. I shall Vormontung. I don't think so, because uh, I mean it. Y'all gonna take Ashley Merchant and put her on a fax machine and just copy her, aren't you? Um, she's already tending to Mr. Martinez Arnold. I don't think she'll be able to do that. But I'm not going to put anything in the total. It's a possible, but I'm not going to say that it is. I don't think so. Okay, I'm sorry. I'm supposed to be looking for a motion. Y'all got me way off task. But I'm inviting it though too. Let's see here. Looking in good old Mr. Thugger Daly's daily thuggery. Okay, the last thing he has in the folder is the letter to the judge, and we just saw that. It was that 8-pager from yesterday. So we saw that one, or the other day. Please forgive me. Okay, I do have the plea agreement though. Oh my word, it's 38 pages. It's the transcript from the proceedings of his plea agreement. What are they doing? Yeah, this one is going to be, and this is from Martinez Arnold. These are what he admitted to, confessed to, agreed to in order to get his plea agreement. But I want to see. So I'm looking for his factual agreements. I actually don't see them. Now, the reason I wanted to see those is to see what. Okay, here it is. Okay, I think this is interesting. Real quick, let me bring this in. All right. I know that they're in court. As soon as they come back in, I will do so. Okay, real quick, watch this. I think this is interesting. I'm sure Mo will have something to say about it as well. So here's Martinez Arnold's current charges. One count of conspiracy to violate the RICO, and count 57, participation in criminal street gang activity. Okay. Negotiated sentence, 12 years to serve, 2 years commuted rather to time already served, balance of 10 years probation. Count 57, 10 years to serve, 2 years commuted, time already served, balance of 10 years probated, all of which will run concurrently with count 1. Okay, basically 10 years of probation. Here's what he agrees to, and I think this is interesting. I'm just going to run through these very quickly, speed run through them. I'm a member of the Rolling 60s Crips. I became associated with and are affiliated with YSL in the year 2015 at the age of 27. On October 1st, 2015, I was assaulted by members of a rival gang at a local club. After being assaulted, I called Diamante Kendricks, and armed with an AK-47 and a handgun, together we traveled toward Trestle Tree Apartments in Atlanta to search for the rival gang members and that assaulted me. I pled guilty to participation in criminal street gang activity and a conspiracy to commit aggravated assault for my actions during this incident. So we heard about that activity. So we got that. Continue, Jason. On May 9th, 2022, I was present at the home of Jeffrey Williams when a search warrant was executed and the police recovered drugs and guns. I do not claim ownership of those drugs or guns found by the police. I will not possess guns during the terms of my sentence or any time thereafter unless my rights should be restored, and I have committed no criminal acts. I will commit no criminal acts. Got you. Notice he did not say that YSL is a gang. Just something interesting, but watch. All statements below are truthful. Some identifiers of YSL are wearing clothes with the words YSL or slime, wearing appendix display the letters YSL or slat. One of the colors of YSL are green for slime. Again, he's never said that they were a gang. Just says this is what they do. I have seen YSL members use one or more of the following hand signs, wiping the nose, curling the ring finger and the pinky fingers inward toward the palm while extending the index finger and the thumb, index finger and thumb, and the middle finger slightly curved. Okay, well, I just trust your word on that. Language of the members of YSL: slat, slime love all the time, calling each other slime. Symbols of YSL, including green heart, green snake. If I violate the plea agreements of the district attorney, can and will use this statement during my judicial proceedings. Any violation of the plea agreement may result in the remainder of my entire sentence being revoked, and the district attorney will recommend that I serve any remaining portion of my sentence in the Georgia Department of Corrections. And no promises of agreement, no promises, agreements, or conditions have been made other than those that set forth in this document, and none will be entered into unless memorialized in writing and signed by all the parties. Okay, but notice he doesn't call YSL a gang. They just say that this is what YSL is. Now, granted, I'm sure they're going to try to say, well, we're saying they're a gang. We're saying YSL is a gang, and you just tell us what YSL does. But I don't see anywhere that they've actually said or made the case that YSL is a gang. I think that's going to be interesting. We'll come back and look at it. But I just wanted to give y'all that. Let's jump back and see if anything's happening. Nothing's happening. What are they doing this morning? Y'all, this is not good. What are they doing? They've been talking for at least 10 minutes. That's interesting. Hmm. Wait. How dare you, David Young? David Young, shame on you. 0-second timeout, sir. We don't talk in those kind of terms. We don't say that. Never, sir. Shame on you. Go listen to some Run DMC and come back. Thank you, sir. On repeat. She doesn't like rap like that. So, I mean, she could be an expert on musicals, though. Oh my gosh. She's an expert on musicals. Yes, and she's self-taught. I see movement, but I wonder what they're doing. I want to know what they're talking about. Maybe I haven't been posted. Yeah, at the moment on Thugger's um, Google Doc, I don't see it. I don't see any others. I'm sorry. The bald barista. I like that. I can dig it. I can dig it. All right. Lots of good conversation in the chat, which is always good. I appreciate 560 of y'all that already tapped in this morning. Grace and peace to y'all. Good morning. Uh, all right. And there we go. Getting that done. I don't know what they're doing this morning. What are they doing? And that is a great point. If Martinez Arnold is a member of the Blue Gang, why is he an official on the Red Gang? I don't get it. Like, why? How's he speaking on the red team? That makes no sense. All right, let me see real quick. I'm just looking on other channels, see if anybody else is also on the seal. Yep, they're on the seal. Here, I'm gonna try this. I'm tired of that crawler on the other channel anyway. So anyway, they're still now they actually have their audio on. I can hear it, but who was the lawyer at the bottom of this one? I'm not certain. Yeah, apparently they're still on the bench. I don't know. I have no idea what they're doing. They're already doing too much. Maybe so. Maybe this is it. There are a lot of people saying that this is the last day. Okay. Free tamales from Ray if you hit the like button. I agree with that statement. Now, I don't know how he's getting them to you now. Don't hold me accountable for that. Hey, good morning, Shay. Good morning to you. Good morning. I have no idea what they're doing. I don't think they know what they're doing. Hey, lovely. Thank you so much for stopping by. Ashley's in the building. Thank you. I guess somebody said there's an Ashley alert. I mean, technically, Ashley's here. I mean, right? Am I wrong? You just said right here. Yeah, right there. Ashley alert. And now Ashley's here. Go figure. We're winning. We're winning all around. All right. Kat posted the motion for reconsideration. Let me see. Let's see what good old friend Kat is doing over there. All right. Let's see here. So I got the RAP Act. I'm going to come back and look at that. Hopefully for the day is over with. Okay, so I see the motion to revoke his. Actually, I went over this one. If this is what we're talking about, the one that is actually the motion to revoke his probation, we went over this one a couple days ago, and we can highlight it again. Joyce, I was looking to see if there's something new, but no, this is it because then they talk about he's going to have to go to court on today to make his case for why he shouldn't be revoked. Yeah, I went over this one, but we will certainly look at it and hopefully hear something about it today. All right, let's see. All right, let's see. We got it's a hybrid gang. Never go out of style. See, Tracy, you are correct. Can I post the new motion? All right, most certainly. All right, Key, I'm dropping it down in the chat right now. Cat is reading the motion. Let me see what we make sure I'm on the right thing here then. Okay, I'm trying to see what. Oh, sorry, started the wrong day. Here we go today. Oh, this is something I don't have. Where did she get this from? This is the motion. Okay. This is the motion about not throwing out Mr. Dennis. That's what this is. Okay, I don't have this one, so let me grab that. I thought you were okay. Now I'm cooking with you. Now I'm cooking with you. All right, so that was the motion that she's reading right now to not throw out Dennis. What in the world is that? Hey, let me jump back over here because they might be having some technical issues. You're not supposed to go to the window screen in the middle of the trial. Okay, so at the current moment, everybody's tapped in. I appreciate you. Yeah, I'm gonna go over that motion. Yeah, what's happening now is whatever it was that Brian Steele wanted to talk about. I'm gonna bet $1 he probably just he's talking about it as well as with Shard. That's what I'm thinking is happening, but I can't prove it, of course. All right, let's see what we got. All right, where is Hey everybody, I appreciate you. I'm looking to find this motion that Kat just read. I don't see where she got it from. I'm wondering what am I missing? Because it's not in Thuggers. I don't see it on his Twitter. Where did she get it from? All right, if you do have it, feel free to just shoot it to me in email, of course. All right, let's see what we got. I'm just checking through. All right, let's see here. Bang. Big Bot said, I'm filing a motion for mistrial. She dropped the link in her chat. Okay. Jumping over there. All right. Looking for that link that she dropped. Yeah, this is craziness. How are we already in the stream and we've been in penalty box for here? I'm gonna just ask Cat for it again. There's an issue with his stand-in attorney. Really? You can't have a retrial. Wait, you can't have a mistrial until after the elections. Okay, I'm reading it wrong. Sorry. Praying the judge's eyes open. It's very possible. I mean, that could be what they're holding up. The motion is for Mr. Dennis from yesterday. They made a motion to not um, kick his testimony out. All right. Yeah, Dennis, the police officer. That's correct. So at the current moment, I'm looking as well, and I don't see it. I don't know what I'm doing wrong. I don't see the motion that just happened. That was, thank you so much. All right, where am I missing? Oh, that's what she did. She purchased it. I don't see it in my Twitter. I'm sorry, whoever said that they just sent it to me. I don't see it. I'm looking in Twitter right now. Remember um my Twitter handle is at Mr. J Witt. All right, looking good, looking good. I have no idea. It looks like so she probably purchased it. That's cool. I will at the current moment. I don't see it. Can you send an email? I don't see it in my Twitter. I'm looking in Twitter right now. But just saw on X that Whitaker isn't letting Ramirez stand in for Nichols. I wonder why. What's wrong? What did he do wrong? Wasn't he on it before though? They're trying to find somebody to replace him. Yeah, this is going to be wild. So they're looking for that would be hilarious if he was going if he was get a law degree after this. That would be wild. En route. Thank you so much, Dominique. On my way. Oh, now you know what? Yeah, okay. On my way to my email now. And now we got it. Motion to consider. This is not long at all. Let's go ahead and do this. Let's go. Move me out of the way. All right. So this is what are we looking at here, people? This is the state of Georgia versus Jeffrey Williams. State's motion to reconsider oral order striking witnesses' testimony and related exhibits. Come now, state of Georgia, and respectfully moves this honorable court to reconsider its October 7th, 2024 oral order striking the October 17th, 2024 testimony of a witness, retired investigator T. Dennis, and related exhibits and precluding his future testimony as a sanction for an inadvertent, non-responsive answer during his testimony. In support thereof, the state shows the following. All right, real quick, everybody knows that that was when Dennis mentioned about Doug Weinstein's client being in jail. All right, so let's keep it going. All right, so they're waiting for a stand in. Thank you so much, JP Nation. They're waiting on a stand in for Mr. Harvey. Okay, Bruce Harvey. I wonder why though. What's wrong with the guy that's there? During interview, Dennis's testimony. I'm sorry, I guess it's investigator. Dennis's testimony. Investigator Dennis referred to actions defendant Diamante Kendrick performed immediately after his release from custody. Defendant Kendrick's moved for a mistrial, which this court appropriately denied as sanctions for this event. However, the court struck the entirety of investigator Dennis' October 17th testimony, precluding him from testifying in the future, and struck from evidence exhibits which investigator Dennis had authenticated on the 17th of October. I'm not going to keep saying that like that. Okay. So as I said before, I thought there was going to be some problems that came up because of that, and they're not letting me down. Problems have entered the chat. Let's go. The scope of the state's claim. It is appropriate for the court to strike a witness's answer from the jury's consideration when it contains information the court finds the jury should not have heard and should not consider. The state does not contest that part of court's ruling. The state submits, however, that the order striking the entirety of the witness's testimony, precluding the witness from testifying in the future and excluding exhibits which has been admitted through this witness, was inappropriate as an exclusive. As an exclusion of evidence which the law does not permit. The state thus respectfully moves the court to reverse this portion of the court's oral order. All right. Evidence exclusion is an extreme sanction and one not favored in the law. State versus Smith, Georgia Appellate 354, 345, 354, 2, all this kind of good stuff like that. I'm not going to go all through that. This is so strongly a part of Georgia law that even the most well-established privileges are narrowly constructed as the ascertainment of as many facts as possible leads to the truth, the discovery of which is the object of all legal investigations. Burns versus State. There it is. OCGA, squiggly line, 24.4.402, Rule 402, provides an irrelevant part that all relevant evidence shall be admissible except as limited by the constitutional requirements or as otherwise provided by law or by other rules as prescribed pursuant to constitutional or statutory authority applicable in the court in which the matter is pending. That is, Rule 402 forbids a court from excluding evidence unless constitutionally or statutory authority authorizes that exclusion. Here, no constitutional or statutory authority authorized the exclusion of non-offending portions of Dennis's testimony, of his future testimony or related exhibits. So, as I said before, there's a lot that's hinged upon Dennis's testimony yesterday. It's more than I think we probably realized. So, if with Dennis being jettisoned out of the court or out of the hearing, that changes a lot. That introduces a new level of complexity because the state is going to have to work harder. Lord knows they ain't working hard now. So let's finish this up. Let me just double check, make sure this thing ain't started in my background. It is not. So let's bring it back over here and let's go. We're back. Where a purported ground for evidentiary exclusion does not come within the exceptions of enumerated Rule 402, it finds no home in any of the specific or detailed exclusionary rules, including in the new code and unsustainable state versus or, as the Supreme Court of Georgia has said. The universe of specific exclusionary rules is limited by statute. First, Georgia's Rule 402 explains that otherwise, relevant evidence may be excluded based on rules grounded in the Constitution or statutory authority. And we know that that's the OCGA squiggly line 244402. The evidence code specific and detailed exclusionary rules are the obvious example. And I'm going to jump over that down to point E. Grandfathers in old common law exclusionary rules, those rules which predate Georgia's current evidence code. In the rare instance, if there are any, when such rules haven't been modified by statute, see Chrysler Group versus Walden, 303 Georgia, 358, 364, 2A, 812, SE2D, 244, 2018, rejecting the old party wealth evidence rule was abrogated by the new evidence code. That's the list. Under our evidence code, these are the only possible sources of specific exclusionary rules, and see or 305. Explaining that the exceptions in the federal rule 402 are an exclusive list of sources of authority and exclusion of evidence in federal court, State versus Almaz. And if a rule in the new evidence code is materially identical to the federal rule of evidence, we look to federal case law. And so jumping down here, Strockett versus Rogers. Let me see. Like squiggly line. I agree. I think that I understand the argument, but I do think that they're not taking into account how old and how long this man has been on the force. He knows better. And then if you didn't prep your witness, that's not the state. That's not the defense's fault. I think they make a good case. I understand both of them. Strockett versus Rogers. This is consistent with the federal interpretations of. Oh, let me just read this real quick. All right, here we go. Cases in which appellate courts have rejected even well-established rules of exclusion, which were not reduced to statutory form since the adoption of the Georgia's new evidence code and Code 402, include State versus Almez, blanket exclusion of offender identification made during medical examination of child S abuse cases was abolished by the new evidence code. Chrysler Group, supra common law rule excluding party wealth evidence was no longer applicable. Glenn versus State, exclusionary common law regarding identification testimony did not apply under the new evidence code. State versus or supra 305, statutory exclusionary rules replace common law exclusionary rules, and pre-force judge made exclusionary rules that lack even the backing of common law authority. All right, so now I'm finishing up where we were right here. This is consistent with the federal interpretations of the corresponding federal rule of evidence 402, which has a prospective effect in that it precludes trial judges from future creation of new exclusionary rules of general acceptability. So while OCGA squiggly line 24611A, Rule 611, permits the court with control over the mode and order of witness examination, Rule 611 does not authorize an order excluding evidence and thus would not justify the order at issue here. Rule 611 mirrors federal law and of evidence 611 as that rule read in 2011, Smith versus State, 299 Georgia. I'm not going to read all that. Thus, Georgia courts look to federal authority for the interpretation. The state submits that federal courts of appeal are very clear. Rule 611 does not authorize the wholesale exclusion of evidence. Unlike the vast majority of other evidence rules, 611 does not purport to regulate the admissibility of evidence. Instead, the rule gives trial courts broad powers to control the mode and order of what is otherwise admissible evidence. 28 Charles Allen Wright and Victor James Gold, Federal Practice and Procedures, squiggly lines 6162 at 338, 1993. Emphasis added, although decisions that a court makes under Rule 611 may indirectly affect whether proof is admitted, the rule does not provide an independent ground for, let me stay with this, excluding otherwise admissible evidence. And that's United States versus Colum, where a trial court order has an exclusion. The Fifth Circuit held that the court erred as a matter of law and therefore abused its discretion in relying on 611 to preclude the government from calling the witness necessary to present admissible evidence. I do think that they're going to make this case pretty hard, pretty heavy, because if they throw Dennis out, there's a lot of things that he was tying together yesterday or was able to tie together that they're not going to be able to use, or they're not going to have to find another way to bring it in. I think that's why they're going to fight so hard to get him in here. And who knows, they might be arguing about it now. They're going to file an injunction. Wow. Yeah, and I think that's probably right. That's why they don't like the camera. I mean, because think about what we would not be able to see or what we would not know, rather, if we weren't able to see this case in 4K. Let's finish this up, Jason. Let's get done. Further, the matter at hand does not involve evidence which was illegally seized under the federal or state constitutions. And that's U.S. Constitution Amendment 4. And does not involve a violation of other rules which have the statutory provision of exclusion, such as the reciprocal discovery rules. And that's right there. And let's keep going. As there is no constitutional right or statutory provision which authorizes the exclusion of Dennis's testimony or future testimony generally, or exhibits related to it, the order excluding such evidence was in error and should be reversed. Man, they said, man, you don't even know what you're doing, Paige. That's what they're saying. They said, Paige, you don't know what you're doing. But let's see what happens. For these reasons, the state respectfully moves this court to reverse those portions of the court's oral order in which it struck the entirety of Dennis's testimony, precluding Dennis from testifying in the future, and excluded exhibits which had been admitted through Dennis on the 17th of October, 2024. Respectfully submitted, the 17th of October, 2024, Kevin Armstrong, Deputy District Attorney. All right, let's go find out who this Kevin Armstrong fellow is. All right, let's bring this screen back in. They still are not back. What are they doing? That's craziness. All right, let's find out who this Kevin Armstrong guy is, because he's a district attorney. And he's going to probably be the fellow. Okay. All right, let's see. I messed that up pretty bad. All right, so here's Brother Kevin's LinkedIn profile. All right, Deputy District Attorney, Fulton County. So he's going to be the one that's arguing this. Okay, I think that's going to be interesting. I can't zoom in any, but Seemed like okay. It's been Fulton County for 9 years. All right. So that's who it is going to be. He's going to be the fellow that is arguing this case before wherever. So that's going to be interesting. Bring that back in. Yeah. Dennis really buggered up the state's case. He also seemed to be fabricating credentials as a rap lyrics expert so he could testify about specific songs. I agree. I don't know why Paige allowed it though. That's what I didn't get. I don't know. We didn't get a chance to see anybody was in there. They literally were there for like, I think it's fair to say we barely had the camera on for 2 minutes, maybe 5, maybe. But yeah, I don't know if Love was there. I don't think I saw anybody on the prosecution team, really. What did JP Nation say? JP Nation said there's no fun when the rabbit has the gun. Was the problem when Glanny was ruling unjust. There you go. That's who she sent away this morning. Okay, I'm just looking through real quick. And thank you so much for that motion being sent to me, Dominique. I appreciate you, Dominique. Fantastic supporter of the channel, helping your boy out, keeping me right and tight. What are you saying yes about, Mo? Yes, you're gonna send me lunch. Oh, she gonna be fit to be tied. Lee, you know she gonna be fit to be tied today. I won't be surprised they just say, look, we canceling court because she gonna be emotional like that. Irritated. Thank you. Yes. There's a conflict with the stand-in attorney. Dang it. I wonder why. Wit to the prosecution is Glanville to the defense. Wit to the prosecution is Glanville. Okay, that's interesting. Take on it. Okay, I see what you're doing there. Now, the judge could have just declared a mistrial. I wonder if she can, given this motion. I don't know. That's a great question. I'm sure Monica will let us know. But I don't think there's going to be a mistrial. Not anytime soon, at least. He was the lawyer for YSL Polo. Was that the guy that had the was having, I don't want to say he had a mental breakdown, but is that the guy? Yep, that's him. All right, let me all right. All right, this is that brother. Oh no, that was Rondarius. Okay, I'm sorry, that was a Rondarius. I'm gonna bring that in. That was when Rondarius Ryan was he had drugs sewn into his clothes. It was crazy. Okay, this is the gentleman right here.
It's definitely never a good sign when your ultimate defense in a RICO indictment is trying to convince the judge that you are clinically insane. But this looks like the unfortunate reality for YSL member YSL Polo, who has seen having some questionable episodes while in court. Bruh, I swear there's gonna be a Netflix documentary on this trial because they aren't even in the official stage with the jury yet. And there's been so much nonsense, man, from one lawyer getting arrested trying to smuggle drugs inside, to people trying to smuggle perks to Young Thug while in court, to another dude apparently doing a goat sacrifice on the side. This is not even the craziest thing that has happened in this trial. But it's definitely not looking good for Young Thug because these antics are making his whole situation look terrible, man. We're going to get into it right now. But before we do, I'm going to need you to like, comment, subscribe. We're going to run to this video, man. Make sure y'all check out the merch link in the description at staysafeworld.com and tap in the notification gangs whenever I post. Y'all are tuned in right away, man. Let's get into this right now, man.
Okay, I don't know who this cat is, but
So Cordarius Dorsey, also known as YSL Polo, was seen basically tweaking out while at his court live session just a couple days ago. Many felt he was intentionally trying to look crazy, while others were blaming the spastic episodes on, bad prison drugs apparently gone wrong. The crazy thing about all this is Cordarius Dorsey, who's also known as YSL Polo, is pretty much a rap as it is, because Cordarius Dorsey was among one of the people associated with Slaughter Gang and YSL who were accused with killing Solomon Jala at a Marathon gas station on Gresham Road in 2019. And he was sentenced to life for this Decatur gas station murder robbery, man. Basically, the story reads that 2 gang members have been sentenced to life in prison without parole for the shooting death of a 39-year-old husband and father at a Decatur gas station 3 years ago. Cordarius Dorsey, who authorities said is associated with Slaughter Gang and YSL. Surveillance footage showed Dorsey and Jackson waiting at the gas station when the victim arrived. Authorities said Dorsey approached his vehicle. Jala tried to shut his door, but Dorsey forced it open, struggled with him before shooting him in the chest. According to police, that's when Jackson also approached Jala and grabbed a bag from him. Both suspects fled the scene, and Jala died from the injury. While eyewitnesses' accounts and anonymous tips matched Dorsey to the description of one of the suspects, detectives believe that the social media evidence played a huge role in bringing the pair to justice. Both their phones were confiscated upon arrest. In them, investigators said they found photos that connected the suspects to one another and matched their appearance to the men captured on surveillance. They said Dorsey recorded a social media video of himself the day before the murder, and he reportedly was wearing the same sneakers at the shooting was during the crime. They also said Dorsey used his phone to look up articles about the shooting and sent incriminating messages that suggested he knew he was a suspect on the run. And this is the same dude that's trying to pretend that he's insane, man. But he was found guilty on charges of malice murder, 3 counts of felony murder, armed robbery, aggravated assault, possession of a firearm by a convicted felon during a commission of a crime, possession of a firearm during the commission of a crime, SMH. And on top of that, he's also being indicted by Fulton County on RICO charges for his affiliation with YSL as a part of being the gang led by Young Thug. And basically, after being convicted of all this, Mans is trying to be insane, trying to get out of this whole sentence. I mean, if I was convicted with a rap sheet like this, maybe I'd be doing the same damn thing, man.
all right. So, because I don't even know, Young Thug is cooked. I don't know. Let me see. All right, they're not back. Let's finish this up. Y'all want to finish this? I don't know much about this young guy, but it seemed like he has a decent understanding. But let me real quick just point out the reason we're watching this is because the gentleman that's going all crazy and doing all that kind of stuff like that in the chat. Let me know if y'all want me to finish watching this. We don't have to. We don't have to watch it if y'all don't want to. But the gentleman that's acting all crazy, you see the gentleman that's standing next to him. That's the lawyer that Bruce Harvey had stand in for him today. So for whatever reason, this gentleman, the stand-in attorney that's standing in for Bruce Harvey, is not he's person non grata to Paige Whitaker, and that's why we're waiting, because there's some kind of conflict. I don't know what the conflict is. I don't know if this gentleman is still in the process. I don't know if he hasn't. Probably looking to see, has he actually been? Has he been? All right. Looks like the overall consensus I'm gonna take it. I'm not gonna finish it. But what I'll do, how about this? What I'll do, I'll again, I just did a quick search for YSL Polo, so I did not vet what we had here. So I'm gonna find a better one because he was in the news too. Um, that was here's a better one. You can actually see the attorney. Okay, this one's way better. Let me do this because you can actually see the attorney in question because that's why we're watching it in the first place. So, all right, let's go. Let's go.
Tonight, we are following some new details in the ongoing YSL RICO trial. While most of the attention has understandably been on Jeffrey Williams, known as rapper Young Thug, his co-defendants are proving to be just as important in the case.
Yeah, so 11 Alive's Brittany Klein-Peter has more on the latest motion filed to remove one of Young Thug's co-defendants from the courtroom.
Young Thug's attorney Brian Steele gave me this copy of the motion that he filed on Friday asking for Cordarius Dorsey, also known as YSL Polo, to be removed from the trial due to his inappropriate behavior in the courtroom, alleging that his conduct could impact Young Thug's chance at a fair trial.
It took just hours for rapper Young Thug's legal team
Okay, so that's the attorney right here that's standing in for Bruce Harvey today. So let's see what the guy's doing.
to file a motion to remove YSL Polo after he was seen acting like this in court on Thursday. The motion reads that Mr. Dorsey displayed unprofessional and unacceptable conduct in the courtroom. It goes on to say that Mr. Dorsey, during a separate trial, used movements with his hands to threaten the prosecutor as well as the jurors.
It's not just what's legal or the evidence, the lack of evidence. It's the way people act, it's body language, facial expression. All of that makes a difference in a courtroom.
Daryl Cohen is a defense attorney who isn't involved in the YSL case, but says this move could both extend and shorten criminal proceedings in what has already been a months-long process just to seat a jury.
It may shorten this trial by just a little bit, but it will necessitate an additional trial that will take a great deal of time.
Cohen adds that even if the judge denies the motion, it's a strategic move.
If Judge Lanville does not grant the motion to sever, then if this defendant or any or all of the defendants are convicted, then he has another piece of evidence on appeal to say it was not a fair trial.
Jury selection in this case started in January of this year, and still no one has been seated. Reporting in downtown Atlanta, Brittany Klein-Peter, 11 Alive News.
All right, so that kind of adds a little bit of understanding to the scenario real quick. All right, that adds a little bit of understanding to it. So I'm wondering if I appreciate this, Ron. Thank you so much for dropping this in the chat. I'm wondering if the Atlanta Journal-Constitution prosecutors have decided against pursuing charges against Polo's, whose real name is Quandarius Dorsey, because he's currently serving life sentence on murder charges. Isn't that the same thing that's happened with Little Rodarius Ryan? Why are they doing that with Rondarius though? That would be kind of wild. That would be kind of wild. I want to know why. So why is he able to be severed? Well, I mean, he looks like he's wilding out. Little Rod is seeming to be very well maintained, I guess you will, in court. So I wonder what that is. What does she say? She says, I'm an expert at minding my business, expert of minding the business that pays me, and an expert of watching the YSL trial. There you go. There you go. Everybody in this live chat, actually, if you hit the like button, you will get certified in best live chatology. It's a real thing. If they ever need a witness to talk about what it's like to be a member of the best live chat on the planet, you're certified if you hit the like button. There you go. I think they do have I don't think it's even a hidden agenda. They want to. He's He's an albatross around the neck. He's a millstone around the neck to drag the rest of everybody down because he himself is already in trouble. So that's it. I don't think there's anything. I don't think they're trying to be even secretive about it. I don't think, but I totally like your point though, for sure. Welcome, Dominique, a new member. Y'all go ahead. Now she's a new member in Slimeology. That's it. Absolutely. And her name is now turned green. So now you are certified, just like Tina. Tina here, you are certified in Slimeology. You can say, I know what I'm talking about because I have been in the best live chat. I've commented, I've liked, shared, and subscribed, all that kind of stuff like that. You're just as viable as Mr. Dennis. There you go. Kelly says, why is court being delayed? So Bruce Harvey, also known as YSL Ponytail, the older white guy, his client is Mr. Nichols. He is not there today. And I don't think Miss Westmoreland is there either. So he had a stand-in attorney for him, but apparently something has gone south with the stand-in attorney. So they're trying to find somebody else to stand in for the stand-in because that's why that's how I'm understanding it at this moment. Welcome. Absolutely. Make sure you tell Dominic and all of the new members, because we do have, again, Rabbit 1969 is also a certified best live chat on the planet member. Absolutely. Yeah, we call him YSL Ponytail. We got to do something. We got to do something. Absolutely welcome. Absolutely. Yeah, they might as well just go ahead and call this. Like, what are they doing? Calling lawyers or us? Because you can't just have like anybody stand in. I guess that's why they had him. What's going on, President Not Perfect? Good to see you. I have no idea. None whatsoever. But I do have something we can do. We are going to go over. We got to listen to Mr. Dennis, because he's an expert in these streets. Okay. So I know you all are wondering, like, well, why do we keep saying that you're an expert in this, that, and the other? There's no curriculum. That doesn't even make sense. Okay, so they found somebody. I love it. I love it. Wait, hold on. Sorry. Thank you so much, Dominique. So they found somebody, just waiting for them to get there. There we go. All right. Ashley probably is working, getting ready to deal with my Martinez Arnold today. Hey, shout out to Laura Jefferson. She's also Slimed Out member. She knows what it's like to be a member of the best live chat in the world. All right, let's go real quick. I'm gonna jump over very quickly, and we're gonna look at. I'm sorry about that. We're gonna look at why do we keep saying that you're a member, you are an expert at something. Well, I'm glad you asked that question. Let's go.
I want to hone in specifically on your training, right?
Okay.
I heard you say that you've given a presentation about gangs, but I'm asking you about gangs and specifically rap music and rap lyrics as it relates to gangs. What is this presentation that you've given, and are there any literature? Is there literature or any material that you have that you can share with us that you've used in this presentation?
I don't have the presentation with me, but in the presentation, it's my own accumulation of entertainment, music, and presenting. I present to kids, I present to adults and other cops and educating them in the gang unit. A lot of officers don't understand what's happening right before their eyes. And so for myself, I was tasked with educating not only our department, but other departments when I worked for the ATF, them as well as students about this information.
What literature specifically have you used to educate either yourself or other investigators in regards to the relationship to rap and rap lyrics to gangs.
You mean when you say literature, you mean like books, or are you
Yes,
talking
sir.
about magazines?
I'm
Or
talking about books. I'm talking about learned treatises. I'm talking about studies, anything like
Training materials.
none of it?
that. None.
Magazines. We might use any hip hop magazine, or different examples that's in a magazine might be something that we are able to reference because of the wording or something along that. When you reference books, I've read different gang books from other officers. I've read a book out of Compton. I think it's A Lonely Day in Compton or something, and it was written by gang detectives out of Compton, because a lot of they were privy to a lot more information than we were in their own work over the years.
Right. And what specific information? Here's what I'm trying to get to, Detective. I'm really not trying to trick you or anything.
Okay.
But I want to know specifically, is there a book? Is there a training manual that specifically deals with rap lyrics as it relates to gangs?
No.
Okay. You referenced before, I think you used the words, my own background is used to decipher this information. You talked about movies. So are we talking simply about you looking at the movie Menace to Society?
Yes, I've seen it. Yes.
Right. Looking at the movie Boys in the Hood?
Yes.
And you're saying that that is what you have used to form your expertise in regards to rap lyrics and the relationship between rap lyrics and gangs?
What I'm saying is, based on my own upbringing, growing up in a gang-infested environment, my own education, my own training, as well as watching these said movies, is where I formulated my opinion.
Have there, other than what you yourself have experienced in your own personal life, right, have there been any, for example, instructors, professors, or anyone else who have taught you using material or lesson plan in regards to the relationship between rap lyrics and gang? No?
No.
All right. Those are all the questions I have.
Anybody else? Any redirect?
Nothing from the state, Your Honor.
All right. So, and then
Okay, so
has
in a moment, Judge Whitaker is going to ask some questions, because I think deep down in the back of her mind, she knows that this thing is cooked. She knows this guy's not an expert. Just because you've watched Boys in the Hood and you were raised on the block, that makes you an expert? Come on now. You might have some learned experiences and some lived experiences that you can speak on, but you've not been trained. You don't have any kind of knowledge that's unique to you. I mean, I'm sorry, unique to anybody else, because anybody in the jury box could have done the same thing. They could have watched Menace to Society 2 more times than you. They could have been on a block that's 10 times worse than yours. Are they an expert? Come on, man. All right, let's and this is where I think Judge Whitaker, who was born and raised in Aurora, Illinois? Oh my word. I think this is where Judge Whitaker realized, really? Sherry? I graduated from East Aurora in 1992. Just a little behind you, just a little bit behind you. Really? Shout out to Sherry Jackson. All right. Okay, let's get done.
a part of what you have done, how does that intersect with what you know about gangs?
What?
The music and the lyrics.
From listening, I'm a rap fan myself, and from listening to music and watching movies, videos, YouTube, I'm able to understand what is being said and what is being expressed.
Y'all, I'm embarrassed for the state. I'm embarrassed. Now, I forgot this is during the intertestamental period where they were trying to determine if he was an expert. And Judge Whitaker's listening to her. She's going to listen to him, and she's going to eventually say, yes, he's an expert. But wait, he just said, I watch YouTube and read rap magazines. So basically, Word Up magazine. The source is a magazine, a hip hop magazine. And that's what he's used to train himself, to make himself an expert at this. Come on, man. This has got to be. And now I was feeling bad for Paige at one moment, but I'm like, wait, you're in a moment, she's going to certify him as an expert, even with what he's saying. But watch this.
Of my life, it's just like watching anything. I can understand it. And by me being a gang investigator, a regular person might listen and think it's art. And it may be art. But for myself, with my education and my background and investigating gangs for a number of years, I'm able to understand exactly the message that's being kind of, what's the word I'm looking for? That's being given. I can't even think of, but I understand when someone says, I caught somebody down bad. To you, you may look at that and say, oh, they caught somebody down bad. But for me, that means you caught somebody and you were able to hurt them, kill them, or what have you. So I'm able to decipher what is being said. Regular lay person does not understand that. They look at it as just art or a lyric in a song.
Okay. All right. Once again, I'm satisfied that based on his training and experience, he can testify as an expert as to maybe a double meaning within rap lyrics.
Your Honor.
And it's obviously ultimately going to be for the jury to determine whether they,
And
believe and
Okay.
accept as credible.
All right. You know what? I'm going to stop for a second. I'm going to tell Petty Editor Jason to not, Petty Jason cannot clip this video and add that SpongeBob thing in there where it goes 2 minutes later, and then add where she's yelling at him. Petty Jason, you cannot do that, Petty Jason. You cannot do that, Petty Jason. This is embarrassing because in literally like 10 minutes later, she's going to just throw out everything that this man is saying. That is, no, don't incite Petty Jason. Petty Editor Jason, he need to look, Editor Jason, he make sure he got these lights on time, right? And she can tell, like, the dude is selling you horse tickets. Like, literally, I've read. Now, okay, wait. Let me put my foot in my mouth. I do believe if you read books on topics, and I can show you, like, I've read books on various topics, I do feel like I have a pretty good working knowledge on certain topics. There's no way in the world, however, I would tell you, because I've read these books and I can show you these authors and such like that, that I am an expert in it. And I think that's where the problem is. I can tell you, look, I know a lot about some topics, and we can sit down and I can really, really expound on those topics, but I'm not an expert. That's the part I think where really he could have just said, hey, I got a lot of knowledge as a sneakerhead, as a rap fan, whatever like that. He could have said that, but he made himself an expert. And that's where everybody's giving him no duck and no cover, no quarter, because you're saying that you're somebody above and beyond just the average Joe and Jane. And matter of fact, Adams is about to point this out, and then I'm going to get done. I'm taking notes though.
Anything he or any other witness says. Yes, sir.
And Your Honor, that's my issue. I understand the court's ruling. I just asked you to consider what he has testified to. He has no specialized knowledge beyond the ken of any layperson. I understand his saying that what he grew up around. I grew up in Brooklyn too, and maybe there are members of the jury who have the same life experiences as him, but that's not what the purpose of
I understand. I'm not basing it just on where he grew up. It's
Right.
his training and experience as a gang investigator.
But specifically in regard to the interpretation of rap and rap lyrics as it relates to gangs, he has not given the court any information whatsoever to indicate that he has any specialized knowledge that will qualify him as an expert, such that his opinion could go to the jury for them to look at him as an expert in that field. None whatsoever. And I'd maintain my objection. I'd ask that he not be qualified in that particular area.
All right, I understand, and your objection is overruled. I mean, this just happens to be words that are set to a beat. It's no different. All right, let's get the jury in here.
Wow. And shout out to being an expert at tacos. Let me tell you, man, those are real things, man. Hey, everybody's an expert at something following this logic. Then you can sit on a in a witness booth and say, I am an expert. Like that's pretty grandiose, man. That's not just, your average Joe and Jane. That is something different than just saying, I have a lot of knowledge. I'm very passionate about comic books. I've read a lot of comic books. I've collected comic books since I was a young child, and I have a lot of information about comic books. I have a huge working knowledge on the major shifts and turns in the different comic book industries in the big two comic books. I can tell you a lot about them. That's different than saying I'm an expert about Marvel. I'm an expert on DC. That's a whole different game. That's a whole different game of cheese. So, and literally the jury comes in. It might have not even been a full 10 minutes later. And she throws out everything that man said. And I think she knew that she was wrong. I think she's all right, cool. I'm here. I'm ready. All right. Wow. It has been a long morning already. All right. We got the screen up. We are ready. Sylvia says they're about to go live. I'm here. We are here. We are ready because we are the best live chat on the planet. Right. He's an expert at Glanville's chambers being sacrosanct. Matter of fact, as we get ready to go, we got 4 new members that have been slimed in. We got Rabbit, we got Dominique, we got Laura, we got Zipper. If y'all could, in the chat, tell me what you're an expert at. Y'all know right here, your boy is an expert at Adidas. I am an expert. I'm certified. Because I think he says the word certified too. I might have to go back and listen. But I think he said certified. So it's not just that he's that denotes some kind of like somebody has given you some kind of certificate. But anyway. All right. Sherry's legitimate from my hometown. I don't think I've met anybody natively that is from my hometown, but shout out to Sherry. Shout out to you. Grace and peace. What are you an expert at? You're an expert at Groundhog's Day. Sadly, I think we all are experts at Groundhog's Day. That is true. There's no lie detected there at all. Absolutely. Welcome to all the new members. You're an expert at driving, expert at talking, certified of being full of myself. I'm certified smarty pants. I'm an expert at getting my kids to bed by 8:30. Yo, you could probably write a book on it. Hey, if you can, there's a way to monitor. There's a lot of need there. There's need there. You're an expert at cooking. I'm a pen expert. I used to be a pen fanatic when I got out of high school into college in my first couple of years after graduating, I was a fanatic about pens. I don't know why. I still am pretty, but not anything like I was before. I'm a CDL driver. So you are a professional. You're certified. Is that certified drivers? That's what I'm talking about. I'm an expert at medieval, Elizabethan clothing and textiles. That actually sounds serious. Shout out to you, an expert at eating. Certified. Oh my gosh. We're back, ladies and gentlemen. Let's go. Let's see what we got.
All right. So for this morning's representation of I'm on. Mr. Nichols, we have Miss Foster and Miss Anderson. Thank you. All right. And somebody said there was something they wanted to put on the record before we started.
Everything.
Yes, Your Honor. So in one of, and it's not being published today, but I had very fruitful conversations with Mr. Atkins and Mr. Abate. There is, in one of my clients' phone calls, there is a comment where he says, I just went to court and they let everything out. F him, in the context, it's D, Woody, and the other D. In that context, he just came back from a prelim. So to someone that's not a lawyer that practices in Fulton County, you would get the impression that Woody and D and the other D let everything out in court, when I think it's pretty clear he's referring to the detective that testified at the prelim.
Okay.
So we're going to work on a stipulation that lets the jury know that a detective testified at a prelim on that date to add context to that
Okay.
that statement,
That-
if it makes sense. Because otherwise, I would have a 403 misleading objection.
Okay. All right. Anything else before we get the jury in? All right. Let's get the jury in, and y'all can go ahead and be having your next witness make their way in.
Where Rome King at? Anybody seen Rome King? Where Rome at this morning?
Yep.
That is not Sprinkle. Is that Sprinkle back? They need to. If that's Sprinkle, they need a delay a game.
Yeah.
They need a 15-yard penalty if that's Sprinkle. I think that's Sprinkle coming in there. They need a 15-yard penalty. 30-yard penalty. I don't know. Hey, Natasha, we'll go over
All
it
right,
again.
thank you very much. Everybody can be seated, and I see we have Mr. Sprinkle back on the stand. Mr. Sprinkle, I'll just remind you that you are still under oath. Go ahead,
way.
Mr. Abad.
No way.
Thank you, Judge. Good morning. Good morning, Mr. Sprinkle.
Good morning. How are you?
Good, thank you. Can you tell the jurors, I know you have previously testified, and I know you spoke briefly about the fact that you had reviewed.
Excuse me, Mr. Abadi. I'm sorry. Could you use the mic?
Yes, I apologize.
Thank you.
And if you want to move around, that's fine. There's a lapel mic somewhere if you'd prefer to use that, or you can hold one of those mics.
I hate the sound of my own voice, so the lapel mic really bothers me.
Okay.
So, Mr. Sprinkle, so you talked a little bit about the fact last time that you had, I guess, reviewed and gone through some jail calls as it related to the case involving the murder of Donovan Thomas. Do you remember that?
I do.
Okay, so I want to kind of start there and follow up a little bit about how you do that and what system you use.
Okay.
So could you tell me a little bit about the system that you utilize or are able to use in order to preview or listen to jail calls?
Well, in this case, the system would have been Securus. Securus is a private corporation based out of Dallas, Texas. At the time, at the time that's relevant here, they maintained the phones and the tablets that were issued to inmates, with which the inmates were able to place phone calls. And now it's another company, but that's not relevant for our purposes. At the time, the short answer to your question is it was Securus was the system.
Okay, and were you trained in using the Securus system, and is it something that you use regularly as a part of your job roles and responsibilities?
Yes.
And can you tell the jurors when a call is made from the jail, is that call or is every call that's not to a privileged or is not a privileged conversation recorded?
Yes, it's an automated system, or it was, and well, it still is, but it's computers essentially automatically record the phone calls, their voice over IP phone calls. So barring some sort of malfunction in the system, of which I've not seen with the secure call platform, all calls are automatically recorded. There's no human input needed to ensure the call is recorded. It's a
Okay.
computer program.
And can you tell the jurors when a call, I guess when an inmate at the Fulton County Jail is making a phone call, can you tell the jurors a little bit about the recording that plays before the call is connected?
Well, over time, the recording has changed a little bit, but one thing that is consistent is that the recording, it's an automated recording, and both parties to the conversation are advised that the conversation is may be monitored, and it will definitely be recorded.
And can you tell the jurors, are, I guess, each call, I guess, made by an inmate, are they stored then after the call is completed?
They're digital recordings. They're stored on a server.
And is that by the company that you've referred to as Securus, at least back in 2015 and 17 and 18?
Yeah, it's a server that Securus either owns or leases. It's some sort of server that was for Securus's use.
And based on your training, knowledge, and experience with Securus, are those calls then stored in the regular course of business?
They are.
And can you tell the jurors how members of the district attorney's office or law enforcement have access to the recorded jail calls by different inmates?
It's a website, commandcenter.securustech.net to be exact. And I have a login and password. It's a derivative of my first name and my first initial and last name. And on logging in, there's a array of things from which I can choose, and one of them is just a search form where I input various values like phone number, date range, inmate name, inmate account number, etc. And based on those values that I enter into the search form, I can look for the jail calls that look for certain jail calls that meet those criteria.
Okay, and the login that you just described, is that unique to just you as the user?
Yes.
And when you are, in order to log in with your login, you have to, I guess, use a password.
I do.
And once you are able to log into the secure system, can you tell the jurors, I know you referenced searching for calls, and we'll get to there in a second, but if there's a call that you listen to and is of interest to you, are you able to then download that call?
Yes, I may.
And can you tell the jurors how, I guess, you are able to download calls that you intercept or that you listen to that are of interest to whatever you're working or investigating?
There's a variety of ways, but as I testified previously, they're just digital calls. They're either in MP3 format or WAV format, and I just ask the web-based software or the web-based platform to essentially compile the calls that I've selected for me, and I select a button to download them. And generally there's multiple ways to do it, but the most common that I utilized with Securus was I would designate the calls I desire to download, essentially hit download, and then I'd get an email and that with a link that I would then download the calls and in what was an ISO format, which is essentially a zip file. And that would be how I would preserve the calls and place them in the case file.
And can you tell the jurors with the ISO format that you just described, can that format be altered or I guess changed in any way by you?
Well, no, not the ISO that I download from Securus. I'm not sure. There probably would be a way that somebody, if they wanted to be nefarious, would be able to unpack the contents of the ISO and then repack them. But I mean, I didn't do that in this case.
Okay. And can you explain a little bit to the jurors how an inmate who is in the Fulton County Jail is able to utilize the secure system and make jail phone calls?
They enter in their account number followed by a PIN, and then they put the phone number, and I'm not sure if it's in this exact order, but they, in order to place the call, they enter in their account number, then a PIN, unless they're in the booking area or the lobby area. And that's essentially it. They enter in some a numeric credentials.
Okay. And you talked a little bit about searching for calls. Can you explain to the jurors the different ways in which you search for calls that you're looking that it could be relevant to your investigation?
Sure. I search either by phone numbers, if there's phone numbers that I desire to find calls on, and oftentimes I'll do that if I think that there's multiple people that are calling a certain number, I think that there's a certain phone number that the certain inmate may be utilizing another person's credentials to call. Then I'll search by phone number only. I can also search by the inmate's account. So all calls placed from the inmate's account. And those are the two primary ways. There's also ways that you can search on all calls from a certain area of the jail. Like if I wanted to pull all calls from the booking area during a certain date and time, I could do that as well. But for the most part, on doing searches, and I guess I'll speak in the past tense since Securus is no longer the system that is utilized by the Fulton County Jail, I would just run phone searches by either the inmate's account or phone number.
Okay. And if you'll do us a favor, I think Madam Court Reporter's fingers are going to break. So could you just slow down just a little bit when you're talking?
Yes.
Okay. Now, can you tell, I know you explained to the jurors when you testified previously about a number that you located after you reviewed call detail records. It was a number that you found in common with all those records. Do you remember talking about that?
I did.
Okay. And do you remember telling the jurors that the number through your investigation and through, I'm just trying to
I'm
set.
gonna give him a little leeway on that.
Do you remember that you testified that through your investigation and after receiving the call detail records, that phone number belonged to Mr. Bradford?
I do.
Okay. And can you tell the jurors how you utilized that phone number that you found in common as it relates to the jail calls and the jail phone call system?
Well, so as I started to review the case, I found that the phone number 404-957-8008 could be found as a contacted number or a number that was contacted. It appeared in the phone logs of the records for Darius Zachary, Demise McMullen, Kenneth Copeland, and Kelvin Treadwell during the relevant time frame that I was looking at. And so if on seeing that, common sense dictates this is whoever has this number, somebody that those four people know, or those handsets that contacted that number were nevertheless in the hands of somebody that knew that person. It was a number of interest, basically. So I ran 404-957-8008 through the Fulton County Jail call system to find any calls that were placed by anyone at the Fulton County Jail, anybody who is incarcerated at the Fulton.
And when you did that, did you locate any calls that were relevant or of interest to your work on this case involving the death of Mr. Thomas?
Yes.
And can you tell the jurors the PIN that you located as it relates to these calls? Who was the inmate in which the PIN was assigned to?
Are you asking me which inmate placed the calls?
Yes, which PIN number? Yes, which inmate who is, I guess, attached to the PIN placed the calls?
It was Martinez Arnold.
Okay. And can you tell the jurors how many calls did you download any calls as it relates to inmate Martinez Arnold's PIN number?
Yes.
And how many?
I don't recall how many.
Okay. And can you tell the jurors, were there any, I guess, how many specific calls did you listen to and that you determined were relevant as it relates to your investigation?
There to 404-957-8008?
Yes.
Well, there were two that were particularly relevant, two that were particularly relevant, and then there was a third that was also relevant, but there were two that particularly piqued my interest.
Okay, and can you tell the jurors the two calls that you located that were relevant to what you were investigating, what dates were those calls placed?
January 10th, 2015.
And what time were both of those calls placed?
They're within an hour following the homicide.
Okay. And after finding those calls and listening to those calls, did you download them as you described earlier here before the jury?
I did.
Okay. And can you tell the jurors, as you continue to investigate this case, did you search, I guess, for any other calls related to Mr. Shannon Jackson or Shannon Stillwell?
I did.
And can you tell the jurors, were you able to locate calls in which Mr. Jackson's PIN number was being used to place calls?
Yes.
And can you tell the jurors how many calls, if you can recall, did you listen to and download as it relates to your investigation?
Well, as far as the number of calls I downloaded, it was over 700. As far as the number of calls I listened to, that I don't recall. I don't remember.
And can you tell the jurors when you download a large number of calls, like you just described, 700, explain to the jurors how you kind of narrow your search as it relates to such a large number of phone calls?
Well, there's a number of things that I do. For one thing that I do is I try to anticipate when someone may say something that would be relevant to me. If it's the call was placed at around the time of an event that would yield a relevant topic, such as, for example, calls made right after the arrest in the booking area, calls made right after a hearing where the case was discussed necessarily, that I would anticipate that perhaps the inmate would just like to discuss what happened that day with whomever they called. I also look for calls to numbers that aren't contacted very often, thinking that perhaps that indicates there's been some sort of that this is, if it's somebody that's not called very often, then the discussion may not be as mundane as it would be with someone that they speak to 5 times a day. And that's pretty much it.
And you, when you talk about hearings or things of that nature, is a prelim, for example, a type of hearing that you would use as a date for potential calls of interest?
Yes.
Okay. And is that something that you utilized in this case as it relates to phone calls that Mr. Jackson made?
I did.
And can you tell the jurors very briefly, at a prelim, is that a type of hearing in which the detective, typically the lead detective, is the only person who testifies about the facts and circumstances of the case during that hearing?
Generally, yes. It's hearsay is permitted, so generally that's the only witness that would testify at a preliminary hearing, rather.
In your experience, as it relates to phone calls that you pull after the date of a prelim, is it common for you to find calls in which the inmate is describing what happened during the prelim and the facts and circumstances that the detective may have testified about?
Yes, it's very.
And is that something that occurred here, in this case, as it relates to Mr. Jackson after you pulled calls on November 19th of 2015?
Yes.
Okay. Now, specifically, did you also pull calls that relates to Mr. Kendrick?
I did.
And can you tell the jurors, did you utilize the same procedures you kind of just described to the jury when talking about the calls that you pulled and reviewed for Mr. Jackson?
I did.
And I want to show you State's Exhibit. This 590Y. Yes. Mr. Sprinkle, I apologize. Your Honor, may I approach the witness?
You may.
And Mr. Sprinkle, do you recognize the exhibit 590Y?
I do.
And can you tell the jurors how you recognize 590Y?
Was my handwriting on the disc. I created yesterday. It's a selection of jail calls that I downloaded and listened to. And I put them on this disc so that they would be in tangible form for purposes of creating an exhibit.
Okay, and can you tell the jurors the jail calls that you've described that are on that disc, are those the jail calls that you have talked about today as it relates to Mr. Arnold, Mr. Jackson, and Mr. Kendrick?
Yes.
And you said you created the disc?
I did.
And can you tell the jurors, are the calls a fair and accurate depiction of the phone calls you listened to that you've described before this jury here today?
Yes.
At this time, Your Honor, the state would tender what's been marked as State's Exhibit 590Y into evidence.
Your Honor, just reasserting the prior objections that were made, I guess, a week or two
Understood.
ago. Thank you.
Those are admitted. Any objections are preserved.
And Your Honor, permission to publish.
You may.
Just for the court's edification, counsel, and the jury. I'm not going to play all of the calls today, just a very small selection.
Okay.
And while Mr. Atkins is pulling that up, for the record, for counsel, the court, and for the jury, this is a call that took place on November 19th of 2015 as it relates to Mr. Shannon Jackson.
Securus, you may start the conversation now.
Hello. When I was crying, the tears was on the screen and kept pressing phone, so I hung up by itself. I asked the phone, but it kept pressing phone. Yeah, I'm gonna just wrote me, said D said what's your number.
Man, fuck D, bro. Fuck them nigga, bro. Oh, just like that, bro. Fuck you. Straight up, huh? All that fake friend shit, bro. Fuck these folks. Wish I get on tour. Fuck all that pussy ass nigga. I said, I wish I get on tour. So all these fuck niggas, fuck all y'all rat ass niggas, man. Fuck that nigga, man.
I didn't know with D on the phone. He said, what happened to the SG in court because they didn't need multiple charges. They didn't even take on the court.
That fuck nigga, you know what's going on. Pussy ass nigga.
Say it like that.
You fuck.
Okay.
Fuck you.
Okay. I said, fuck D. He know what he talking to the church.
Like all niggas got, bro.
I just said, she just read it. She look like she on it.
You catch no your number?
Huh?
I don't got your number.
Y'all been having enough when you said, what you say?
I don't know.
Some old shit now. Wait, what happened to baby?
That fuck nigga rat. They just went till I had went to court and they just let everything got. Tell that fuck nigga rat him and Woo and the other people. I don't keep going with folks. That fuck nigga know what's going on. Bitch, you in love with a rat hoe. Everything that came out. The shit they bring up, bro, that shit was just weak as fuck, bro. I'm talking like eating their ass up.
Man, do not leave her in here. This is not the time right now. Everybody get out. Everybody get out. Mom, can you get out too? Shut though. I don't know, call the phone. Young said, see, that's why I don't pick up my damn phone. People keep telling me that, tell Shane, keep your head up. He a real one, for real.
That's all you hear. Oh, you're real. Man, that shit don't do nothing for a nigga. That shit don't make a nigga feel good. That shit don't do nothing for a nigga.
I really get out this house.
Oh, yeah. Talking about a do-what name, nut name, yet name. Okay, yeah.
Yeah, get that shit on me, son.
Yeah. I said, yeah, nut, do-what. Oh, man. My head hurt, man.
I'm going to stop it there for the record. There's 41 seconds left in the call from November 19th, 2015. Mr. Sprinkle, are there 9 calls as it relates to Mr. Jackson on States Exhibit 590Y?
Yeah, 9, that sounds about right.
And as it relates to Mr. Arnold, are there 4 calls that were pulled that you downloaded on States Exhibit 590Y?
That sounds right, yeah.
And then as it relates to Mr. Kendrick, as we spoke earlier, are there 3 calls on 590Y relates to him.
Yeah, I think so. I think that all those numbers sound correct.
And when you, I guess, are listening to the phone calls from your computer, is the sound system a little better than what we have here in the great courtroom here in Fulton County?
Yes. So sometimes with jail calls, they've split the inmate side of the call. I don't know if that's what was happening here, but generally that's what happens. They split the inmate side of the call in one, like the right channel or the left channel, whichever one, and then the called party side and the other channel, so they're in stereo. And for whatever reason, the inmate channel is sometimes a lot lower than the called party channel. It sounds like that may have been what was happening just then, because I too was having difficulty hearing him.
And for the court, for counsel, and for the jury, the state's going to play the rest of the calls at a different time when we can utilize a better sound system that I'll bring
Okay,
in.
yeah, because
We were all struggling, I
I'm
think.
not sure anybody heard anything.
Now, Mr. Sprigg, I just want to ask you a couple questions about that call. As it relates to your investigation, was someone with the nickname Little Woody someone you investigated and was a part of this case?
Yes.
And did you hear his name during that call?
Yes.
And did you also hear Mr. Jackson reference doo-wop, nard, and yak?
I did. I heard that part, yeah.
And were those individuals that you also, through your investigation, I guess, were familiar with?
Yes.
Okay. Now, can you tell the jurors the nickname Little Woody, who do you know that nickname to belong to?
Kenneth Copeland.
Okay. And when you received the case file from the Atlanta Police Department, were there a number of recorded statements or interviews inside of the file?
There was.
And when you received it, and as you continued to work on the case, did you review those statements?
I did.
And did you receive a statement as it relates to Kenneth Copeland from June 10th of 2015?
I did.
And can you tell the jurors, did you review it in its full?
I did.
Okay. Now, during that statement, does Mr. Copeland provide his phone number as well as the phone number for his girlfriend?
I believe so, yes.
And can you tell the jurors what is Mr. Copeland's girlfriend's name?
Deshawn Quarterman.
Okay. And after receiving through the interview as well as other means through your investigation, did you request the phone records and receive them for Kenneth Copeland?
Well, by request, I didn't order his phone records. Someone with the Atlanta Police Department did, but I did review them.
Okay. And is it something that you reviewed as a part of this case?
Yes.
And this was previously admitted into evidence at the State's Exhibit 533YA. See that? All right.
Yes.
Okay. Now, can you tell the jury what was the phone number in the records that were related to the handset that was associated with Kenneth Copeland?
What was Kenneth Copeland's phone number?
Correct.
678-278-5991.
Okay. And after listening to the June 10th of 2015 statement with Mr. Copeland.
Hang on just a second. I know that stand isn't great, but I think the jurors in the back row are having a hard time seeing that.
Mr. Sprinkle, while Mr. Atkins is putting up the board, can you tell the jurors, did you review Mr. Copeland's phone records in light of the statement from June 10th of 2015 that you listened to?
Yes.
And can you tell the jurors, when did, I guess, activity on Mr. Copeland's phone or through his phone records, when did it begin in the early evening of June 10th of 2015?
Well, I guess it would depend on what you define as early evening. For me, I started inspecting the records as at 6:20 p.m. Eastern Standard Time.
Okay, and can you tell the jurors, was that an incoming or outgoing call?
His girlfriend, Deshaun Quarterman, called him at 6:20.
Okay, and did Mr. Copeland?
Simply, who called? I understand the handset.
Sustained.
Okay, did the handset of Mr. Copeland's girlfriend call the handset related or associated with Mr. Copeland?
Yes.
And did Mr. Copeland's telephone, the number that was associated with him, did he answer?
He did not at 6:20 p.m.
Okay. Can you tell the jurors when was the next, I guess, incoming or outgoing call that Mr. Copeland made and was connected or answered?
Well, his brother called him at 6:27 p.m.
Did the handset related to Mr. Copeland's brother call the handset related to Kenneth Copeland?
Yes.
Okay. And did Mr. Copeland's handset or telephone that's associated with him, did he pick up?
Well, it appears that he did. It was a 24-second conversation.
Okay. And do you recall during the interview that Mr. Copeland did on June 10th of 2015, what he described as it related to his activity in the early evening?
He said that he was at his house at 178 Maury Avenue. He'd been taking a midday nap at the time.
Okay. And did he indicate during that interview that when he, I guess, woke up, he called the handset that was associated with his girlfriend, Miss Quarterman?
He did.
And is that consistent with what the cell phone records, the call logs for the handset, Mr. Copeland, that you reviewed?
Your Honor.
Yes.
I'm going to object at this point. I believe this is cumulative to the information elicited from Mr. Burney by Mr. Atkins last week. The cell records, the calls, the timing of the calls.
So my response would be Mr. Burney, or Agent Burney, as he testified, he didn't review any sort of statements, so he was not in a position to talk about the consistency of the statement as it relates to the records, which was the necessity. The whole reason we needed to call Mr. Sprinkle back was due to that unfortunate scheduling issue.
All right, I'm gonna.
In Your Honor, I believe those would be juror issues. I don't believe it's Mr. Sprinkle's place to determine what is consistent and what's not.
Well, I'd also say this goes to Mr. Copeland was impeached on multiple occasions by multiple parties before this court and this jury, and this is a prior consistent statements and activity as it relates to his impeachment.
I'm gonna overrule the objection.
You can answer the question. Let me ask it again.
Yes.
What Mr. Copeland, I guess, described during his interview as it relates to waking up and his phone activity to the detectives on June 10th of 2015, is that consistent with the activity that you reviewed and you've described here today as it relates to the handset of Mr. Copeland and his call log detail records?
Well, he called the handset associated with Deshaun Quarterman at 6:58 p.m. So that was consistent with him talking about what he did after his midday nap.
Okay. And can you tell the jurors Did you also, as a part of your investigation, plot different calls as it related to the call detail records that you received with Mr. Copeland?
I did.
Okay, if you also had an opportunity to review similar, I guess, plotting of Special Agent Bernie?
I did.
Okay, now during the interview that day on June 10th of 2015, do you recall where Mr. Copeland described, I guess, he went next as it relates to his activities that night?
He went to the Green Store, which
Okay.
is, I believe, at 322 Glen Street. That's what he said, yeah.
And in your review of Mr. Copeland's records, can you tell the jurors, were his records consistent with him going to the Green Store shortly after he called the handset related to or associated with Ms. Quarterman?
Your Honor, I think that this is out of Mr. Sprinkle's expertise, and these are questions for Agent Bernie, which have been asked.
Okay, so if that may be true, if I'm understanding what it is that Mr. Sprinkle's testifying to.
I can lay a foundation.
Okay.
Mr. Sprinkle, do you utilize or do you review call detail records on a regular basis as a part of your job responsibilities and duties with the District Attorney's Office?
Yes.
And can you tell the jurors how often do you do that?
Multiple times a week. I don't want to go so far as to say every day. I'm sure there's days that I haven't, but it's thousands upon thousands of times, thousands of sets of phone record, at least over 1,500 sets of phone records, and that's a conservative estimate. So yeah, I look at phone records all the time and have been doing so since 2012.
And in the phone records, or in many of the phone records, or the call detail records that you receive, do they have longitude, latitude, or cell site location data related to the different phone calls within the call detail records?
Yes, depending on the type of phone logs, call detail records that I have or that they are, yes, they will sometimes have cell site location information.
And can you tell the jurors, as a part of your job responsibilities and duties with the District Attorney's Office, how often do you map or plot different calls as it relates to the cell site location data contained within the call detail records?
All the time.
Another objection on foundation for this part of the testimony as it relates to mapping, foundation for establishment.
As it relates to what, I really need y'all to use the mics. All right, so,
I'm laying the foundation.
okay, he's in the midst of it.
So how often do you plot and map different call detail records, cell site location data?
Very, very often. Maybe not on every single case, but on many, many, many cases. How often? I would say at least once a week. Again, that's a very, very conservative estimate, but most cases have cell phone records, and I will generally, if there are cell phone records, want to look at those to make sure that the data is what we believe it to be.
Okay, and can you tell the jurors a little bit about your experience in the sense of how many years have you been utilizing cell site location information to map or plot different sets of phone records and specific phone calls within different sets of records?
Since 2012.
Okay, so roughly how many years? We're looking at what, over 10?
Yes.
And within those 10 years, can you tell the jurors how many sets of phone records do you believe that you have mapped or plotted cell site location information related to call detail records?
That would be hundreds. I don't keep a tally, but the number of cases that I deal with a year since that time, it would just be in the hundreds. A lot of cases.
Okay, and in the cases that you have done what you just described, do you often work in tandem or in conjunction with different members of law enforcement, such as the Atlanta Police Department or other agencies within Fulton County?
Yes.
Okay. And have there been times that you also have worked with members of the FBI or different task forces as it relates to mapping and plotting call detail records?
Maybe like consulted with. Work would imply that I was like part of the team, or with respect to the FBI, that is. No, I mean, I've consulted with them.
Okay. So as it relates to this case, did you utilize cell site location information to map different calls for Kenneth Copeland after you listened to his recorded statement on June 10th of 2015?
I did.
And can you tell the jurors, as it relates to the mapping or the plotting that you did for Mr. Copeland's records, were they consistent at times with being near the green store?
Yes.
Again, Your Honor, I'm going to get cumulative. Agent Burney has already testified to these matters.
And my response is these questions will be brief, but again, Mr. Sprinkle's analysis is related to the statement that Mr. Copeland was impeached with during his testimony for the statement he gave on June 10th of 2015.
All right, and can you clarify whether whatever this analysis is based on Mr. Sprinkle's own plotting or whatever Mr. Burney had already done?
Yes, the plotting that I've been talking to you about as it relates to Mr. Copeland is this plotting or mapping that you did yourself.
Yes.
And upon doing the plotting or mapping yourself with the cell site location information, well, let's start with, can you tell the jurors what information, I guess, are you inputting or using in order to get specific plots for specific calls?
So basically what I do is I'll have the phone records. So I'll have a set of phone records, and there will be some cell site location information that's in the same row as the date and time and the phone number's called. And I'll use Google Earth. Sometimes some phone records are real easy. If they're from AT&T or T-Mobile, they'll just have the latitude and longitude of the tower actually in the records. Other phone companies like Sprint at the time or Verizon, they just put some sort of number that's unique to them. Like it's a number that identifies the tower for them. It'll be like 14732 or something. That's by no means a lot. That was just a number I just came up with out of nowhere, but it'll be some sort of number, and I'll have to cross-reference another spreadsheet where that spreadsheet will have the latitude and longitude. But long story short, though, I just take the latitude and longitude of the tower, I put it into Google Earth, and then I use a graphic plugin in Google Earth to create I get what I call a pie slice that represents the approximate area of coverage, or basically just points in the direction of the antenna or the azimuth of the tower.
Okay, so that was a long story.
Wow.
So can you tell the jurors in your review of the phone records, what time, if any, was Mr. Copeland's handset in the area of the green store?
So his handset was consistent with was utilizing a tower that was consistent with it being in the area of the green store between 7:26 and 7:27 p.m.
Okay. And can you tell the jurors through your review of Mr. Copeland's June 10th statement, did I guess the location, the McDonald's off of Cleveland Avenue, become a point of interest that was related to the investigation you were doing?
Yes.
And can you tell the jurors in your review of did you review Mr. Copeland's call detail records and the cell site location information in regards to that interest point?
I did.
And can you tell the jurors in your review what time, if any, Mr. Copeland was in the area of, or consistent with being in the area of, the McDonald's off of Cleveland Avenue?
All right, so like I testified previously, his phone gets to the area or uses a tower in the area of the green store from 7:26, 7:27 p.m. It remained in that general area or tower until about 7:47. And then 7:49, it pinged off the tower that serviced the general area of the McDonald's at Old Hayville and Cleveland Avenue.
And you said 7:49?
That's correct.
As you continue to review the records, can you tell the jurors, after continuing to listen to Mr. Copeland's June 10th statement, did the Sky House located in Midtown become a point of interest relevant to the investigation that you were doing?
The Sky House condominiums at 1080 West Peachtree Street, yes.
Okay, and can you tell the jurors why or how did that location become a point of interest relevant to your investigation?
It was the location or a location that Jeffrey Williams resided.
Okay. And in the time that you were, reviewing the records related to Mr. Copeland and reviewing the statement, can you tell the jurors at any point did Mr. Copeland reference during his statement that he communicated with a handset that would be associated with Mr. Garlington?
He did.
And can you tell the jurors, was that something that you attempted to locate within the call detail records of Mr. Copeland as you reviewed them?
I did. I didn't find a number that I could conclude was Mr. Garlington's, though if I remember correctly, I also said he contacted him via FaceTime, so I wouldn't be able to see those calls and call detail records anyway.
Okay, and that's something you talked about and mentioned as to why previously when you testified before this court and the jury, right?
I don't recall if I said that or not.
Okay. Now, can you tell the jurors, I guess, what you were able to determine, if anything, as it related to the call detail records being consistent with Mr. Copeland's handset being in the area of Sky House Midtown?
It was later that evening. His handset, from what I recall, from what I remember, it was after 11 p.m. when his handset utilized a tower that was near the Sky House. So it did utilize a tower at some point that serviced the area of the Sky House.
And can you tell the jurors, the Sky House Midtown, how was that building, I guess, related to or relevant to the investigation that you were doing as you continue to review the statement of Mr. Copeland and other materials that you received from the Atlanta Police Department?
That was the location that was said to be where Mr. Copeland and others converged later that evening on January 10th, 2015.
Okay. Now, I want to talk to you about other statements that you reviewed. Do you recall also reviewing the statement for Mr. Quindarius Zachary from August 5th of 2015?
I do.
And can you tell the jurors, did you listen to that statement, I guess, in its entirety or in full?
I did.
And do you recall that during that statement, did Mr. Zachary reference any, I guess, rental vehicles?
He did.
And can you tell the jurors a little bit about what Mr. Zachary said during that statement as related to a rental vehicle?
From what I remember, that he mentioned there was an Infiniti that was involved, and they believed that the manager for Mr. Williams rented the Infiniti.
Okay. And can you tell the jurors after getting that information from the statement, did you request anything from any rental companies here in the city of Atlanta?
Yes.
Okay. And did you?
Well, it's a small clarification. I requested information from rental companies, and I didn't just specify from their physical locations only in the city of Atlanta. I asked from the rental car companies that they give me records of any rental cars that were rented by a list of people during a time, regardless of where the location was.
Okay. And did you do that in relation to Mr. Jeffrey Williams?
Yes.
And can you tell the jurors, did you receive any information back as it related to any rental vehicles in the name of Mr. Williams?
Your Honor, I'm going to object to asked and answered previously.
I don't know if it has been with this witness, but it's certainly been established.
I can move on.
All right.
Well, I want to show you what's been marked into evidence as State's Exhibit 335Y. And when it gets up there, page 7, 335Y. And as Mr. Atkins is getting to page 7, can you tell the jurors, do you recognize previously tendered and admitted State's Exhibit 335Y?
Okay, is the 335Y what's being displayed on these television sets behind me?
That's correct.
Yes, I recognize this.
What is State's Exhibit 335Y?
These are records that I received from Hertz Rent-A-Car.
Okay, and are these records, I guess, who are these records, I guess, related to and in reference to?
Jeffrey Williams.
I'm going to object. This is cumulative, and it
Sustained.
has been asked and answered.
Well, my response is the specific information as it relates to what's inside State's Exhibit 335Y was not elicited from any witness as it relates to the trial.
Okay, if there's something new on this exhibit, then.
I'll just cut to the chase. In State's Exhibit 335Y was a phone number that was associated with the rental for Mr. Jeffrey Williams located within.
There was a phone number located somewhere within there, yes.
Okay, and can you tell the jurors what that phone number was?
I don't recall. It's somewhere in the, I think, was it the one that ended in 3504 maybe? It should be in the business record though.
And do you see it on page 7?
Yes, 3904, 504-975, 3904. That's right.
And can you tell the jurors, after, I guess, receiving this document and learning of this number, was a request made or a search warrant done for the records as it relates to Jeffrey Williams?
Yes.
Okay, and did you receive those records back related to the phone number associated with the handset of Mr. Williams?
Yes.
All right. Now I want to ask you a few questions about other sets of records that you reviewed in relation to the information you had received from Mr. Zachary and Mr. Copeland after reviewing their statements, okay?
Okay.
Did you request either through search warrant or subpoena the records for Justin Cobb?
I don't know if it was me that did that, but yeah, we did obtain the records for Justin Cobb.
Okay. And
actually, no, I believe it was. I recall drafting a search warrant on that, so yes.
Okay. As well as, did you receive either, whether it was by you or another member of law enforcement you were working in conjunction with, the records for Mr. McMullins?
That McMullen was somebody with the Atlanta Police Department, but I did receive them.
And did you review them?
I did.
All right. And regardless of who requested them, did you also review the records for Kelvin Treadwell?
Yes.
Okay. Now, I want to talk to you about specifically, did you review those records kind of how you've described today as it relates to January 10th of 2015?
Yes.
Now, I want to talk about some of the activity that you saw as you did the review of the records. Specifically, can you tell the jurors, you talked about you received records from Mr. Bradford based on the phone number being a common number called by Mr. Zachary, Mr. Copeland, and Mr. Treadwell, I believe you said, correct?
Yes.
And can you tell the jurors in reviewing the call detail records, did you review the records as it relates to the point of interest of the Texaco off of Cleveland Avenue?
Yes.
And can you tell the jurors, as you reviewed Mr. Bradford's records in relation to that Texaco, what you determined from your analysis?
What I determined from my analysis of Mr. Bradford's tower logs was that his handset utilized a tower that was in close proximity to that Texaco, and therefore 330 McDaniel Street, the incident location, between the hours of 7:11 p.m. to 7:19 p.m.
And I should have asked you this first, but as you were reviewing statements and call detail records, did you also receive and review any video surveillance?
I did.
And is that the surveillance that I think you briefly described previously as it relates to the Texaco off of Cleveland, as well as the barbershop not far from the Texaco?
Right, the barber shop, like between 60 and 100 yards, yes, away. Yeah, that too.
Okay. And I want to show you State's Exhibits 591. 591Y through 598Y. And prior to your testimony, have you had an opportunity to review those photographs?
I did.
And do those photographs contained in State's Exhibit 591Y through 598 fairly and accurately depict the Texaco from July 10th of 2015?
January 10th, 2015?
Yes, I'm sorry.
Yes, they do. These are screenshots. It looks like they're screenshots I took, actually.
Okay. And Your Honor, at this time, the state tender was marked as State's Exhibits 591Y through 598Y.
Admitted.
And while we're at it, Mr. Sprinkle, previously admitted into evidence was 292YL through N. Review those. Do you also recognize those as screenshots from what you've described from the Texaco that you actually took?
Yes.
Now, can you describe for the jurors in State's Exhibit 591Y what we're looking at?
This is a screenshot taken from the video from the Texaco. It was a surveillance camera that captured the exterior of the Texaco station. This would be the gas pumps that were closest to 330 McDaniel Street. The timestamp in the lower on the video is 6:41 p.m. and 58 seconds. Literally, it's 18:41:58, but that's 24-hour time, so it's 6:41 p.m. and 58 seconds.
Okay. And is there a vehicle, or do you see the vehicle, I guess that's in the center of State's Exhibit 591Y?
Yes, I do.
And through, I guess, your investigation, can you tell the jurors what you're able to determine what type of vehicle that is?
2001 Pontiac Bonneville, gray in color.
And in conjunction with all the things that we've described that you've reviewed, the statements, the call detail records, the video surveillance, I know you briefly spoke about it, but did you also review different social media accounts and photographs as it relates to some of the individuals, specifically here, Mr. Bradford, that we've described previously?
Yes.
And can you tell the jurors in your review of Mr. Bradford's social media and contained in previously admitted exhibits, State's Exhibits 360Y through 363Y, what you found in Mr. Bradford's social media that caught your attention?
He often posed in photos with a 2001 Pontiac Bonneville. I mean, he'd be leaning up against it, et cetera. Looked like it was just a car that he was with frequently.
Okay. And prior to your review of Mr. Bradford's social media account and seeing these photographs with him standing next to or near a Pontiac. Had the Pontiac that's contained in State's Exhibit 591 I guess, been an integral part of your investigation at that point?
Well, not integral, no.
Okay. Was it something that you found or didn't find relevant until you reviewed Mr. Bradford's social media accounts?
Sustained. Can you?
Well, let me ask you this question. Just tell the jurors, after reviewing or finding these photographs of Mr. Bradford and the Pontiac, how you were able to use that to forward your investigation.
Okay, so I had the tower data for Mr. Bradford's phone that placed him in the area of the crime scene from 7:11 p.m. to 7:19 p.m. I had calls from the jail to Bradford, Mr. Bradford. I also had these pictures from his social media that I found that showed him with a Pontiac Bonneville. Now, Bradford was not known, he was not in any of the documents that I obtained from the Atlanta Police Department. As far as I knew, he was unknown to the investigation entirely. So I was trying to figure out who this Mr. Bradford was, why I had this data that, this information was made it appear that he was somehow would at least know something about what I was looking into. And so when I went back and looked at the video and I saw this 2001 Pontiac Bonneville pull up to the gas pump, that's when it clicked. And I started paying particular attention to the surveillance video from the Texaco station.
Okay, and I want to show you, Mr. Atkins is going to put on the screen a State's Exhibit 598Y. Now, in State's Exhibit 598Y, can you describe to the jurors what they're looking at and the relevance it was to your part of the investigation and working on this case?
So 598Y is a picture from Mr. Bradford's Instagram page, and it is one of a few photos that showed him next to a Pontiac Bonneville, like I testified to previously. And I obtained that photo around the time that I identified his phone number and got his phone records and tower usage data that placed him in the area of the crime scene, as I testified to previously.
And the photograph that's next to him standing next to the Pontiac, can you describe to the jurors where that's from? There's two photos contained within. How are they relevant to each other?
Well, the one on the right is a still shot from the surveillance footage from the night of the murder.
Okay.
From the Texaco station.
And can you tell the jurors in your review of the video surveillance, you said in State's Exhibit 591Y that Pontiac arrived to the Texaco at what time?
About 6:41 p.m.
And can you tell the jurors in your review of the surveillance how long in total was that Pontiac seen on the video surveillance?
If I may refer to my reports, I get the numbers.
If it will help refresh your recollection, yes, just look up when you're done.
So it was there. The Pontiac was in view of the surveillance cameras at the Texaco station when it pulled up into the pump at 6:41 p.m. and until it drove away from the station at 7:17 p.m.
So fair to say, reviewing your report helped refresh your recollection as to how long it was there?
Yes.
Okay. And you said it was roughly 40 minutes?
Yeah, about that.
And can you tell the jurors in your review of Mr. Bradford's call detail records, was that consistent with him being, or were they consistent with him being in the area of the Texaco off of Cleveland Avenue for roughly 40 minutes?
Yeah, but his phone traveled to the Texaco off of Cleveland Avenue after it departed the area, or not, excuse me, are you talking about the McDonald's?
No, so you just described to the jurors, let me rephrase my question. So that's you saw the Pontiac remain at the Texaco for roughly 40 minutes. You remember saying that?
Yes,
41 to, I think you believe 7:17?
6:41 to 7:17, correct.
And can you tell the jurors, in reviewing Mr. Bradford's call detail records and the activity on his phone during 6:11 and 7:17, were they consistent with him being in the area of the Texaco during that time period?
At the Texaco at Northside Drive and McDaniel Street, yes. His phone pinged in that area from 7:11 to 7:19. It utilized the tower, so it didn't ping at the tower that entire time. But the time frame that his phone did ping at the tower, off the tower and sector that serviced that general area, was encompassed, by the surveillance footage.
Let me ask you this question. Was his phone, or was there activity on his phone during that entire period of time, or were there times where his phone wasn't utilizing a tower?
Well, his phone, it wasn't connected to the tower the entire time, as if it was like streaming data or something like that. Or if it was, I didn't get any records that indicated that. It was only used, it only connected to the tower to when it was sending or receiving a phone call.
Okay. And as a part of your investigation, did you also review or look into the social media accounts, or the Twitter account for Mr. Kendrick?
Yes.
And can you tell the jurors in State's Exhibit I believe it's 524Y. Was this a photograph that you located from the Twitter account of Mr. Kendrick? Once it gets up there.
Oh, there we go. Yes, it is. There's a, and I don't know that's part of the exhibit, because I seem to remember this gray bar going across the screen with the other exhibits as well. Yeah, now it's moved. But yes, I do recognize that. That's an image from Mr. Kendrick's Twitter account.
Okay. And can you tell the jurors, was there anything about the jacket that Mr. Kendrick is wearing in State's Exhibit 524Y that you, after seeing this and also reviewing the video surveillance, that was helpful to your investigation?
So yeah, the interior surveillance from the Texaco, at 6:41, the Pontiac 2001 Bonneville pulls up to a pump, and the front seat passenger exits the vehicle and walks into the convenience store attached to the Texaco, and in so doing came in very close proximity to an interior surveillance camera. And so this footage revealed the outfit donned by the front seat passenger. And that image from the Twitter page that you just displayed on the monitor behind me, or the television behind me, that man, Mr. Kendrick from the Twitter page, was donning what appeared to be the same jacket as the man from the video, the surveillance video from the Texaco.
And is that what we're looking at? The comparison that you just described that you did in State's Exhibit 593Y?
That's yes.
And can you tell the jurors the photograph, we're looking at it on the left-hand side from the convenience store. Can you tell the jurors the time period in which that photograph or that screenshot would have captured?
It was very shortly after the Pontiac Bonneville arrived on scene. If you would like the exact matter of fact, I've just looked at my report to refresh my recollection about this. It was actually at 6:42 p.m.
Okay. And can you tell the jurors in the photograph to the right from Mr. Kendrick's Twitter account what time that photo of Mr. Kendrick was posted, and on what date?
It was posted on January 10th, 2015. As you can see there, because I testified about this previously, I moused over the date, and that made the time pop up, and the time is 7:35 p.m.
Now, as you continued to review the video surveillance, can you tell the jurors, did the individuals that you saw, I guess, exit and enter the Pontiac later interact with another sedan?
Yes.
And in State's Exhibit 594Y. And here I thought the screenshots would be less difficult than the freezing video.
Objection, Your Honor. This is cumulative of prior testimony that we've had at least once, if not twice, in this case.
Any response?
I mean, there's been no,
Is this going to be a comparison?
yes.
Okay, overruled.
Now, can you tell the jurors, were you able to, I guess using your number of years of experience, able to determine the type of vehicle in which we're seeing depicted in front of the Pontiac in the middle of the screen?
The Volkswagen CC VR6 Sport.
Okay. And when you previously testified, you talked about someone you had, I guess, a name that you had come across during your investigation, Miss Ariel Bax.
Yes.
And can you tell the jurors, from getting her name, were you able to use public databases to determine any vehicles registered in her name?
Yes, I was.
And can you tell the jurors what type of vehicle was registered Ms. Bax's name during this time period of January 10th, 2018?
The Volkswagen CC VR6.
Okay. And in your review of the make and model and year that Ms. Bax had, was the vehicle consistent with what we're looking at in State's Exhibit 594Y?
Yes, it is.
Okay. Now, you also talked about previously an individual, Miss Kenya Morton.
Yes.
And can you tell the jurors why you looked into Miss Morton as it relates to this investigation?
I'll object to the reasoning behind what this witness is doing, otherwise.
Sustained. Can you rephrase?
Yes. In the phone calls that you reviewed and have described today from Mr. Kendrick, did Mr. Kendrick place any calls to Miss Morton?
Yes.
And through your listening of the calls and your investigation, were you able to determine how Mr. Kendrick and Miss Morton were associated or knew each other?
Romantically involved.
This is over hearsay.
It's a review of phone calls that are in evidence.
And also speculation, Your Honor.
Sustained.
It's
Well, without telling me what the association was, were you able to see several calls between Miss Morton and Mr. Kendrick?
Yes.
Okay. And in fact, in a one of the phone calls that you listened to and has been admitted into evidence as it relates to Mr. Arnold, did you hear Miss Morton in one of the phone calls?
Yes.
And can you tell the jurors the date of the phone call in which you heard Miss Morton in the background?
January 10th, 2015.
And what time?
7:42 p.m.
Okay. And that time in relation to, how was that time, the 7:42 p.m. that you heard Miss Morton in the background, related to or the time in which Mr. Donovan Thomas was shot and killed?
Well, the 911 call is placed contemporaneously with the shooting, and that 911 call is placed at 7:22 p.m. So that call was 20 minutes after the night.
stipulation unless there's a foundation.
On the what?
The contemporaneous.
Sustained.
I guess I need clarity. I'm not certain it's the contemporaneous. As I know what it
I
means.
don't know if he is able to testify from anything that it was contemporaneous with the murder. I think that's what the objection is to. Is that right? He can testify to what time the 911 call was.
I'll rephrase.
Sustained.
Agreed. I'll ask a different question. Mr. Sprinkle, you said the 911 call was at one time?
7:22 p.m.
And the call in which you heard Ms. Morton's voice and reference to her name was at one time. What time?
7:42 p.m.
Okay. And during that same phone call, was there reference to Miss Ariel or Ari?
That I don't recall.
Okay. And well, let me ask you this question. Shortly after the Volkswagen in States Exhibit 494Y arrived at the gas station, can you tell the jurors, and previously admitted in, I believe they're before you, States Exhibits 292YL through 292N, can you tell the jurors what time another vehicle that you determined to be related to your investigation arrived at that same Texaco?
7:16 p.m.
Okay. And can you tell the jurors, based on the statement of Quindarius Zachary, why that vehicle was of interest as you watched the video surveillance from the Texaco?
Because it was an Infiniti Q50.
Now, can you tell the jurors during what time did that Infiniti arrive?
7:16 p.m.
Okay. And at the time that you reviewed the video surveillance, can you tell the jurors, did members from the Pontiac interact with the vehicle depicted in this state's exhibit?
Yeah. Yes. The man that occupied the front passenger seat and then entered the store at 6:42 p.m. wearing the coat, he interacted with the person or persons occupying the Infiniti.
And I apologize for the record, that's 292YL. Now, Mr. Sprinkle, can you also describe for the jurors, did an individual get out of the rear passenger area of the Pontiac?
Yes.
And can you explain to the jurors I guess, can you explain to the jurors what you observed that person, I guess, do?
Objection, cumulative, best evidence.
Sustained.
Mr. Sprinkle, how long, based on your review of the video surveillance, did the Infiniti remain within the Texaco gas pump area?
About a minute, if that. It pulled in at 7:16 and pulled out at 7:17.
Okay. And can you tell the jurors, is that what we're looking at in State's Exhibit 596Y?
Your Honor,
Yes,
I'm going to object. Can I, maybe approach?
you may.
Well, I'll ask the question.
All
You know what?
I know what your team was expected to. Now, Mr. Sprinkle, let me ask you this question based on your review of all the information you've kind of described here today. As it relates to times for when a 911 call was placed, times as it relates to, I guess, found within call detail records, and then times like the one you just referenced in the video surveillance for the Texaco. Can you tell the jurors, I guess, through your investigation, how you compared, I guess, times from the video surveillance to things like the 911 call and call detail records?
Well, your call detail records, that's the times in those are going to be pretty consistent with, the atomic clock,
Why is that?
Well, they're a cell phone provider and they're computerized records, and they're just going to be synced up because they're on a computer system with like an internet time protocol, or which is synced up with the atomic clock. So that's a good gauge as to the exact time of something. Also, the 911 call system. I found in my experience that 911 calls, the timestamps on those are accurate. Surveillance videos can be a little less so. But what I found here was that knowing when the 911 call was placed, comparing all of that with cell phone records and tower logs and all that, when comparing, for example, the 911 call, the surveillance video from the Texaco in particular, you can see the events that are consistent with the shooting on the Texaco, which people ran inside the store, if I remember correctly. I do remember correctly, they did. And from that, you can place a pretty good timestamp or time when the drive-by shooting occurred.
Would it be your testimony today that all of the times are, I guess, synced up exact as it relates to each other? For example, the call detail records and the Texaco video surveillance.
No, I can say that they're linked up exactly. Surveillance videos, it's not uncommon for them to be a minute or two long.
I'm sorry, I didn't hear that last.
Can you speak into the mic?
It's not uncommon for surveillance videos to be a minute or two off. So I can't say that basically the watches of the surveillance video and the cell phone records were synchronized.
Okay. And we talked earlier a little bit about the phone records, or the additional phone records that you reviewed. For example, Justin Cobb and Mr. McMullins. Do you remember that?
I do.
And can you tell the jurors, upon receiving those records, however which way they were requested, did you utilize, I guess, reviewing those records as it relates to the things that we've described previously here today, the video surveillance, as well as the statements of both Mr. Zachary and Mr. Copeland?
Yes.
And I want to draw your attention specifically to the time period, roughly 7:29 p.m. All the way, I guess, 10 minutes to 7:39 p.m. So that 10-minute period, okay?
Okay.
Can you tell the jurors, in your review of that activity, was there any activity as it relates to the handset associated with Mr. McMullins and the handset associated with Jeffrey Williams?
Your Honor, this is cumulative. Agent Burney already testified to all this.
Sustained.
Well, let me ask you this, as it relates to your review of the call detail record, specifically the call logs of between Mr. Williams and Mr. Treadwell. Can you tell the jury how many incoming and outgoing calls there were between Mr. Treadwell and Mr. Williams?
About the same objection.
Sustained.
The specific number of calls between Mr. Treadwell and Mr. Williams, I don't believe was ever discussed.
Pretty sure it was.
It all painfully regarding previously differences.
All right, I'll ask you this question. As it related to your review of the call detail records for Mr. Copeland, okay? Did you, during that time period of 7:29 to 7:39 p.m., locate any calls, whether it be incoming or outgoing, between Mr. Copeland and Mr. Williams?
7:29 to 7:39?
Correct.
If I may look at the logs. No, my short answer is I don't believe so. And that remains my answers on reviewing the actual phone logs. There were no calls between Mr. Copeland and Mr. Williams. That would have been in the phone logs from the company. Again, during Mr. Copeland's statement, he said he called Mr. Williams earlier that evening on FaceTime. FaceTime calls are not going to appear in phone records from the phone company.
Okay. But from your review, is it your testimony you didn't see any calls between Mr. Copeland and Mr. Williams?
That's right.
How about as it relates to Mr. Copeland and Mr. Bradford, Mr. Cobb, Mr. McMullins, or Mr. Treadwell?
Not that I found, no.
Okay, and I'd ask you the same series of questions as it relates to Quindarius Zachary. Did you see any activity on Mr. Zachary's records between Mr. Williams, Mr. Bradford, Mr. Cobb, Mr. McMullins, and Mr. Treadwell?
All right, well, I'm reviewing, and I'm looking at his records right now too, just to make sure I'm not mistaken. What were the names that you just gave me again?
Mr. Williams, did you see any activity as it relates to Mr. Zachary and Mr. Williams?
I do not.
And between Mr. Zachary and Mr. Bradford and Mr. Cobb?
I do not.
And were there any, I guess, incoming or outgoing calls between Mr. Zachary and Mr. McMullins or Mr. Treadwell?
Not that I see, no.
Okay. And I want to ask you lastly about Mr. Antonio Sledge. In your review of his call detail records, did you see any incoming or outgoing calls between Mr. Sledge and Mr. Williams between the time period of 7:29 p.m. to 7:39 p.m.?
Oh, here we go. No, I don't see any.
And what about between Mr. Sledge and Mr. Bradford or Mr. Cobb?
Between what time frame again?
7:29 and 7:39 p.m.
Justin Cobb called Javaris Bradford at 7:31 p.m.
And I'm sorry, I need to be more clear. Did you see any, was there any incoming or outgoing calls between Mr. Zachary and Mr. Bradford?
I'm reviewing Mr. Zachary's records. I do not see any.
And in your review of Mr. Zachary records, did you see any incoming or outgoing calls between Mr. Zachary and Mr. McMullen?
No, I don't see any.
And lastly, for that same time period, did you see any activity, whether it be incoming or outgoing calls between Mr. Zachary and Mr. Treadwell?
No, I don't see any.
And when you are you're reviewing Mr. Zachary's records, which are contained in State's Exhibit 517Y, is that correct? Is that correct? Is the records contained for Mr. Zachary, do you recall those being 517Y?
I don't know the exact, the exhibit number for the records.
Further questions pending redirect.
Anybody have questions for this witness right now that are going to last less than like an hour?
Less than an hour?
Yeah.
Oh, I hope so.
Okay. Come on.
If I'm not done an hour, start throwing things in.
Okay.
Can we,
Is that
can we
just
do
the
that even
court
if
or
it is less than
anybody
an
in
hour?
the courtroom?
Adam, just-
Mr. Sprinkle, good morning.
Good morning, how are you?
I'm good, and of course, we know each other, you know who I represent, right?
Yes.
Okay. I want to start out by talking to you about the jail calls and specifically my client, Shannon Stillwell's jail calls. Okay. I believe you testified that you downloaded, you estimated, I believe, 700?
So, yes, the batch that I downloaded from 2015, maybe the calls descended into 2016 as well. I don't remember. I think it was around 700 audio files. So that would represent 700 calls. It's not 700 exactly, but that's what I remember.
I understand. And you, do you have a ballpark of how many you reviewed?
I didn't review all of them.
Okay.
And a matter of fact, I probably reviewed like maybe 50 to 75.
Okay. And regardless of how many you personally reviewed, when you downloaded them, they are saved onto your computer, your hard drive.
All of them are saved, yes.
Okay, and they would have been passed on to the prosecution team in this case, so they could review all of them, correct?
That's correct.
All right, cool. All right, I just want to, your job actually with the DA's office right now is you do prelims. You cover prelims for cases, correct? Amongst other things.
That's correct.
All right. And I just want to unpack a little bit about what you said about preliminary hearings, is when I say prelims, preliminary hearings. You said typically a lead detective testifies.
That's right.
Okay. And you said hearsay is allowed, meaning the lead detective is allowed to testify about what other people said.
That's correct.
Okay. And you are aware that jail call that was played that was tough to hear, a little bit low, that was from November 19th, 2015, correct?
That's right.
All right. And November 19th, 2015 is the day that Shannon Stillwell had his prelim, correct?
That's what I recall, yes.
Okay. And that's why you had interest in that call.
That's right.
All right. And that call was made later in the day after Mr. Stillwell would have returned back to the jail from his preliminary hearing.
That's right.
All right. In Shannon, in Mr. Stillwell's preliminary hearing specifically, I know you said lead detectives generally are the only ones that testified. Detective Thorpe testified in that preliminary hearing, correct?
Yes.
Okay. Kenneth Copeland did not testify.
No.
Demekion Garlington did not testify.
No.
Quindarius Zachary did not testify.
No.
Okay. And I know it's hard to hear, but we're going to bring some volume to it, okay? Mr. Stillwell on that call said, I just went to court and they let everything out.
That sounds right, yes.
Okay, and that was after Detective Thorpe testified, correct?
That's right, after he heard Detective Thorpe's testimony. Correct.
Okay, he said they threw out, and it was tough to hear, so I want to make sure we're clear. On that call, he said they threw out yak, doo-wop, nard, correct?
I don't recall that they threw out
And I'm not suggesting throughout the case. I'm saying throughout the names.
That sounds right. I definitely heard him mention those names.
Okay.
So yeah, I took it to mean maybe like their names were mentioned, maybe.
Right. And because it was hard to hear, I'm just trying to make it clear. He's not saying, and nowhere in that call did he say he was with those people or anything like that day.
No.
Okay. And again, those names were mentioned by Detective Thorpe, correct?
That's right.
All right, cool. And he was, well, you can't testify to his mind state, but in that call, he said F word D, Woody, and the other D, correct?
I don't know. Yeah, that's not a verbatim quote. It's pretty close. I mean, I think you the spirit of his comment was captured in your quotation there.
Okay, and then he said them F N-words know what is going on.
Something along those lines, yeah.
And then that's the case that was, that's the tape that was played in court today, but there are 8 other calls on that CD, correct?
Correct.
All right. You also listened in on another call that Mr. Stillwell had with that same young lady on November 23rd, 2015, correct?
I think so. That sounds right.
At 16:08, at 4:08 p.m.
That sounds correct.
All right. At 5:07 into that call, Mr. Stillwell says, N-words will say whatever, correct?
That sounds correct. I know that was the general spirit. I don't know if that's an exact quotation as to what he said.
Okay. At 5:15 in that call, Mr. Stillwell said, they just trying to get the heat off their ass.
Again, that sounds like the general, that was something along the lines of what he said, that was the topic of conversation. I just can't say if that was a verbatim quote or not.
And again, Mr. Copeland at that time was facing federal and state charges.
That's right.
And Mr. Zachary, the other D, was facing charges related to the April 28th, 2015 shooting of houses, correct?
That's right.
All right. Mr. Stillwell in that November 23rd, 2015 call said, people will say anything to save their ass.
Best evidence. Mr. Sharp would like to play the calls and
Sustained.
Okay. It is in evidence. Trying to save some time, but
I appreciate that, but if there's a valid objection, I've got to sustain it.
okay. All right.
Thank you.
I twisted his arm. Also in that call, and this is just one more, and then we'll move on. Mr. Stillwell said, they will sit right there and lie.
I don't recall that exact utterance being made, but it wouldn't be inconsistent with the general tone and of the call and the other things that he was saying.
Okay, cool. All right. Regarding Mr. Copeland's cell records and the plotting you did, let me get this right. 722 is the 911 call.
Yes.
Okay. You said at 7:26, you have Mr. Copeland headset pinging on the tower. So 4 minutes later, he's pinging on the tower at the Green Store or in the vicinity of the Green Store.
That is correct. It had moved north to that tower, so it was actually south of that tower seconds prior to, but yes.
Well, you don't actually, cell phone records aren't like a chart where you see, for instance, a cursor moving through a map, are they? You don't see real-time movements during a call, do you?
No.
You just get spots in certain points in time.
Yes, that's
when cell calls are initiated.
That is, well, you get the tower and the antenna utilized by the handset at the time of the call. It's a very big area.
But just at the time, right, vague area, but also just at the time of the initiation of the call.
Correct.
Okay. And so 4 minutes after the purported time of the 911 call, that headset is utilizing the tower near the Green Store.
That's right.
Okay. And we also, the truth is, we can speculate. We don't know how much time passed. We know that 911 call was made at 7:22, but we don't know how much time passed between the shooting and the 911 call, do we?
No, I can't say exactly. From what I recall, it's pretty quickly, but I can't say the exact seconds.
Well, we don't, I mean, people, before they call 911, they can try to hide guns, right?
There's any number of things people can do before they call 911.
They can try to get guns before they call 911.
The possibilities are endless as to what somebody could do before they call 911.
And some people will do certain things before they call the police to where they're at.
Speculation.
Sustained.
Well, the bottom line is we don't know how much time passed. So we're dealing with inexact times.
Yes.
Okay, great. And you would agree that the Green Store is within a minute drive of the barbershop?
It's pretty close. I don't know. I can't say if it's a minute, but it's less than a mile away.
Less than a mile away. Thank you. All right. Finally, I'm just going to ask you about one other matter. Javaris Bradford has come up, aka Tuda, right?
Yes.
Okay. He's the owner of, through your investigator, he's the owner of the Pontiac at the Texaco.
Yeah, from what I recall, he was the registered owner.
Right. And he came up in your investigation, and the fact that Pontiac was on the video piqued your interest.
That's what I said. Yep.
All right. At some point in November of 2018, he wasn't charged in 2015.
He wasn't.
Okay. In November of 2018, he was still in the community, correct? He wasn't in jail or anything.
That's right.
All right. And you determined that you wanted to speak to him.
I did.
All right. And did you reach out to him?
I don't think I reached out to him. It was likely a DA's office investigator. Somebody reached out to him.
Okay. And was he asked to come in? Was he compelled to come into the DA's office? How did that work?
I believe we gave him a grand jury subpoena, if I remember correctly.
Okay, you issued a grand jury subpoena for him to come in and speak to you?
Well, the grand jury was in session that day. Having never spoken to him, I wanted to speak with him before I potentially put him up before the grand jury, and I did end up speaking with him. And at that point, I determined that not to put him up.
Okay, that was November 13th, 2018, correct?
That's correct.
And you had a meeting with him in a conference room in the DA's office, correct?
Right, it was on video. I have it right here, actually.
Yes. And present were you, Investigator Thorpe, at some point came into the meeting, correct?
Investigator Thorpe, I think he was present the entire meeting.
Okay.
It's on video, but from what I remember, he was there the entire time.
Okay, and then I don't want to mess up the young lady's name, so I'm not even going to try, but there was an investigator with the DA's office. Could you say her name correctly?
Cynthia Nwakocha.
Wakocha.
Cynthia, first name, last name, Nwokocha, I believe.
Okay, thank you. And Javaris Bradford showed up, correct?
That's correct.
He did not have an attorney.
He did not.
And he showed up to the conference room without an attorney, correct?
Objections, relevant, asked, answered.
Sustained.
Okay. For this meeting, you had video from the Texaco, or was it stills or video?
There were definitely stills. I think it may have, I can't recall if I played motion pictures of the surveillance video or I just had stills. He was at the very least showed still images.
And you told him, in fact, that you were investigating the homicide of Donovan Thomas.
I'm gonna object for your statement's point as to what Mr. Sprinkle told Mr. Bradford.
Sustained.
To what? I'm not asking what Mr. Bradford told Mr. Sprinkle. I'm asking what Mr. Sprinkle told Mr. Bradford.
Oh, okay. Overruled.
Still an adequate statement.
Well, y'all can ask him. He's right here.
Okay. So you told him that there was evidence against him in this case.
I don't recall exactly what I said. I bet I likely said that to him. I would go so far as to say as yes, I did. That would
report. I'm sorry for interrupting.
Yes, I'm sure I said that to him because there was.
Okay. And you wanted him to speak to you about who was at the Texaco, correct?
I did.
Okay. And you told him that your supervisor wanted to charge him, but you were holding things off to give him a chance to talk.
Yeah, I mean, it is. Sustained.
Okay. Let me ask you this. Was your supervisor Pat Dutcher at the time?
He was in.
Sustained.
Your Honor, may we approach?
You may.
What are we doing? What are we doing? I'm tired of Abati and Shard arguing anyway. So I don't know where they're going. I really don't. Most of the time you can kind of tell where you think they're gonna go, but this one is like, man. Yeah, this one is wild. Anyway, hopefully you all are enjoying it. Thank you so much to everybody who has tapped in with us on today. And I just want to say again, welcome to all the new members. Thank you so much for your support and becoming a member of the channel. It does mean a lot. And I'm glad that you want to hang out with us. So stay in there. Appreciate you. Now, let's see what the kind of good stuff we got going on. That's the thing about a RICO trial is it does allow you to use hearsay. I want to say they can use it more, but they can use it when in other cases you can't. And because you're trying to get the conspiracy, Jay Sneed I heard Jay Sneed tell Dear World Christian, blah, 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 whatever like that. So it's a lot of back and forth and things that really, in my opinion, shouldn't be, but I mean, it's part of the RICO setup. So they're letting them do that. It seems long now. I'm ready for Sprinkle to get out of here. I'm just wondering, was Sprinkle really supposed to be here today? Do they really have intention for him to come in today? That's what I'm wondering, because it just seems like, oh, goodness gracious. All right, let's see. Just cleaning up a couple things. All right, let's see. Let's see where we are. Okay. I think he's dumb, but I also think why do they keep calling him? But okay, they're back. That was good. Oh, look, they're just yucking it up. Homies.
Your Honor, based on the court's ruling, I do not have any more questions, and I'll note with like 50 minutes to spare.
That is correct.
Oh, I see what you did
Is
there.
any other defense attorney going to have questions for Mr. Sprinkle?
Briefly.
Okay. All right. I think we can fit in another one or maybe two.
Oh, Mr.
Good afternoon,
Weinstein.
Mr. Sprinkle, or ADA Sprinkle.
Good afternoon. How are you?
I'm good. How are you doing?
Very well, thank you.
Can I just look at this? You can see this demonstrative, right?
I can.
I'll leave this here. Is that okay?
Mm-hmm.
That's okay. I don't see Mr. Kendrick's phone on there.
That is correct.
So you didn't do any analysis for Mr. Kendrick's phone on January the 10th, 2015.
I was without records to analyze for Mr. Kendrick's phone.
Okay, so you have no records of his phone on that date, correct?
Correct, yes.
Okay, thank you.
Anybody else?
Oh, that was it, Doug? Oh, come on, Doug.
I would like to ask questions, Your Honor.
All right.
Oh, here comes Brian. Yeah, he didn't write on any chart paper though. Is it legitimate if you don't use chart paper? I don't think so. I think it's more than legit. Here comes Brian Steele. Let's see what he's got.
Good afternoon, sir.
Good
Oh,
afternoon.
it is
How are you,
afternoon.
sir?
I'm okay. How you doing, sir?
Very well, thank you.
I'll actually let you know if I'm okay. Can I ask you some questions?
Well, yes, please.
Thank you. So, I want to just go into a few different topics. The way this was set up in your office, and you specifically work in this case, I think you made it clear. I'm going to be very brief, but if I'm wrong, just say I got it wrong. Law enforcement officers with whomever, FBI, APD, GBI, whomever is working the case, eventually your office may get involved and summon, or they give to you their work product or their files on the case. Fair to say?
That's fair to say, yes.
And then what you're doing is, because you're a law enforcement, but you're the arm of the attorneys who come to court, you have to look at everything and prepare it or not prepare it for any type of charges.
That's right.
All right. And when I say charge, I mean formal charge. I know, ladies and gentlemen, know police can issue warrants, but warrants aren't an official charging document. That would be an accusation or a bill of indictment.
Yes.
When you got, and I'm focused only on this case, obviously, okay? When you get the file, you're getting the files from everybody who touched the case, as far as you could tell, from crime labs, from law enforcement, APD, GBI, whomever. I'm not eliminating, I'm not trying to keep out other agencies, but you try to get all those files together.
Well, yeah, I try to get all the documents or whatever media that every agency that investigated the case has. I mean, I want to get as much as possible.
Sure. Now, when you get the APD files, the Atlanta Police Department files, and you start looking at them and reviewing them, I want to ask you if you can remember. Do you remember any notation from Detective Thorpe that he reviewed the McDonald's surveillance video from January 10th, either January 10th, 2015, and he did that on or about January 11th or January 12th, 2015?
I don't, and I feel like I would remember that.
Tell the jurors why you remember that, if you don't mind.
Well, the McDonald's, as they've heard, was the McDonald's at Old Hayville and Cleveland Avenue.
151 Cleveland Avenue?
Yeah, I think that's the address, whatever. It's at the intersection, at or near the intersection of yes, I believe that's the address, what you just said. And that was said to be a rendezvous point, the parking lot of which. So I would have remembered I would have remembered it because, first of all, I've never seen that video. I've never seen any surveillance video from McDonald's. So if I were to read something that said from a law enforcement officer said they did review it, I would have said, well, I would have remembered, that would have been a big thing for me. I would want to have had the video. So no, I don't recall any notations from Detective Thorpe about him reviewing the video and not obtaining it, presumably. So no, I don't remember anything like that.
And if that video, if it's working and if it captures the area that this, what was your word, rendezvous? Is that what you just said?
I think so.
Okay. And the rendezvous, according to Mr. Copeland, let's say, it might be others, but at approximately 8 o'clock at night, January 10th, 2015, approximately.
Mm-hmm.
And you could correct me, if my times are off. If that surveillance at the McDonald's captured people actually meeting, then we would know who was actually there and if Mr. Copeland was being straightforward. Is that fair to say?
I'm gonna object. It's speculation.
Sustained.
Did Detective Thorpe ever tell you, besides his file, did he tell you that he went out and looked at and saw or tried to see the video from the 10th day of January 2015, approximately 8 o'clock p.m. from the McDonald's?
Objection, yes, sir.
I covered this with Detective Thorpe, and I'm impeaching him.
Overruled.
I don't recall him telling me that. It doesn't mean that he didn't, but I just don't recall it. It just seems like something that would leave a mental impression on me because, again, I would have just thought, well, where's the video? I don't have the video. I would have liked to know that. So I don't think he ever did.
In your experience, since I believe you said 2012, but it might have been 2009, with the DA's office in Fulton County, have you looked at and subpoenaed whether or a grand jury or, excuse me, a court's search warrant, surveillance video from stores?
I have, yeah.
Have you found that after a certain period of time, some of the video is erased or deleted?
Yes, that's the practice. The videos are all digital. I don't want to say they're all digital. There may still be people using tapes, but every video I've ever seen has been digital, and they only have so much room on the computer system that's storing the video, and eventually will start overwriting itself.
Explain, first of all, this includes 2015?
Yes.
Okay. Tell the jurors what you mean. I know you're comfortable with it, but overriding itself. Just explain that process from your experience, knowledge, and work with these.
Well, just like every computer surveillance system, cameras are hooked up to essentially a computer. The footage is recorded digitally and stored on a drive, some sort of media in the computer, but that drive can only store so much data, so many ones and zeros, I suppose. And so once the drive is full, the system is programmed to just, it's not like a tape where it starts in the beginning of the tape and starts overwriting it, but it starts writing data to the parts of the drive that already have data on it. And over time, the data just starts to rewrite itself. And eventually, after a certain amount of time, all traces of the footage from a certain date will eventually be gone as they've been overwritten by data from other footage.
So just putting that make it simple on a date. Have you seen a surveillance video that lasts 30 days?
I believe so. I don't want to throw out any names, but there's one place in particular that comes to mind, but it's not relevant here, and I also don't remember exactly, but I do believe that 30 days I have seen before.
Okay. What's a typical days until it starts overriding?
I'm going to just ask an answer and speculation element relates to McDonald's video.
I'm impeaching Detective Thorpe.
I feel maybe 2 weeks. That's always what I kind of mark in my mind as if it's within 2 weeks of an event. I mean, you want to get the video as soon as possible, to be clear. But I really start losing hope after 2 weeks. But again, it depends on it could be a big retail outfit. Now going back to 2015, it may be a little different, and maybe they just have petabytes of storage for their video and it's stored off site. But your typical, like a gas station, particularly in 2015, where it was stored within, probably on a DVR, you're going to want to get that as soon as possible. You can start overwriting after 48 hours.
And when you say then it writes it over. So if it's, I'm just using 2 weeks, okay? January 1, 2015, 2 weeks would go to approximately January 14, 2015.
Right.
On January 15, 2015, does the entirety, in your experience and your dealing with this, does the entirety of everything in those 2 weeks go away, or is it on a rolling basis?
Don't you object to asked and answered on
Not of this witness.
and speculation as to this witness?
He's asking within his experience overruled.
Well, okay, so are we talking about one location and one, if we're talking about surveillance footage, one location and one computer system, or we're talking about in the entire world of surveillance footage?
McDonald's, 2015, January 10th, surveillance, just typical McDonald's, your experience, hypothetically 2 weeks. I want to know on the 15th day, so I'm just after the 2 weeks, what you're explaining to the jury, does day one, January 1 override, or the entirety from January 1 to 2014? That's my question.
To lack of foundation at this point.
Sustained.
In your experience with a 2 week camera, does it override just one day at a time? As the next day comes in, the first day's gone.
Vague as to your experience to a camera in a 2 week period. Any camera? I mean,
Sustained.
When you say override, tell the jurors what you meant by that.
asked and answered.
Sustained.
I don't believe he just
Yeah, he
used the
did.
word.
He explained it in detail.
All right. Did you or any of your members of your team, I'm including the prosecution team, you understand what I'm asking? So prosecution team are all law enforcement, GBI crime lab, your office, whomever, okay? FBI. Did you ever find out from any source that McDonald's, how long, if at all, they had that surveillance video?
The record retention period for surveillance video, if I knew it, I don't remember it now. So no, I can't answer. I don't know what their retention period was back then, nor do I know what it is now.
Did you ever hear from a detective, you know who Detective Gaither, Detective Dennis, they worked together, gang unit in 2015, January?
Yes, I know them.
Okay. Did they ever tell you or put in writing in any way that they went to the McDonald's in June 11, 2015 and inquired about the surveillance?
Objection, hearsay.
I am impeaching Detective Gaither's testimony.
And who are you asking about at this point?
Detective Gaither, January 11th, 2015, going to McDonald's and inquiring about the video.
And that is hearsay, and it's not impeachment unless they specifically confronted Detective Gaither.
I did confront Detective Gaither.
With
yes.
telling Mr. Sprinkle as to whether they got video surveillance footage or not.
I want to know if it's in
the comment.
I want to know if it's in
Detective
the
Gaither
records.
was not confronted with that.
Okay, sustained.
I want to know if it's in the records.
That wouldn't be, then that would, rephrase your question. That question, the objection is sustained.
Do you have any information from any source that you looked at in your records, conversations that Detective Gaither and or Detective Dennis went to the McDonald's on the day after interviewing Kenneth Copeland, June 11, 2015, and inquired about their surveillance equipment?
No, I have no notes that indicate that, and I have no memory of any conversations that I had with them where they told me that they did.
Did you ever obtain personally or have a member of your team, or it was done before you got involved, Sky House, you know, the condominium that Mr. Williams was living at in January 2015?
Yes.
Okay. Any surveillance from there?
No.
How about the Green Store? Any surveillance at the Green Store that Kenneth Copeland states that he was there, personally there, at and around the time of the killing of Donovan Thomas? Any surveillance from there?
No, no surveillance.
Did you or members of the prosecution team, I'm including all law enforcement, ever interview the people or persons that Kenneth Copeland said in June 10th, 2015 that he was with at the Green Store at the time around Mr. Donovan Thomas's murder?
Well, there's a little Rick that he mentioned, if I remember correctly. No, I didn't, nor do I know if law enforcement did. No.
How many cell phones did Kenneth Copeland have access to that he can use on January 10th, 2015?
All I know of is the one that I testified to.
And you do know that Kenneth Copeland testified in this court, and if you don't know, just say I don't know, that he had multiple cell phones.
I'm going to object at the rule of
I
sequestration.
mean, I would hope he doesn't know.
Okay.
Since he's a
Do you
witness in this case.
have knowledge that Mr. Copeland did not have 2 or more cell phones on January 10th, 2015 through your investigation?
Asked and answered. He just answered that question, that he only knew of the one cell phone.
Sustained.
Let me ask you this. Phone records that you talked about at length with the Honorable Mr. Body, through your analysis, and what you were given and subpoenaed more phone records, fair to say?
Yes.
All right. Those phone records give a general whereabout of where a handset is located, if it's working properly, if the records are accurate, I'm assuming all that, where a phone set would be in relation to its cell phone tower. Is that fair to say?
Right, just the area that the approximate area that the phone would be located based on the tower that it utilized.
And in your experience, if you know, and if you don't know, just say, I don't want to testify to this. That area could be how many miles, how many feet, do you know? And we're talking about Atlanta, January 2015. And please, I'm not trying to put you out on a limb. I know you're under oath.
Well, I don't know that anybody could testify as to the exact square footage of the area, but it suffices to say it's not like GPS. It's a large area, probably, like over a mile.
Could be multiple miles.
Could be.
And jurors may not understand what you meant by it's not like GPS. Just explain that.
Well, like a point on a map. Like, in other words, when you get phone records, you don't have a log of the exact locations of a cellular device, like a pinpoint that you could put on the map that the phone was right here. Like, for example, I have a phone on me. If you were to get my phone records, it wouldn't show my phone sitting right here in the witness stand. It would show that it was using the tower next to the courthouse or near the courthouse, down the street, wherever, but it's not exactly.
Now, are you aware from your review of your records as you've been testifying and the recordings that Kenneth Copeland met with Detective Thorpe, Homicide Detective Thorpe, on the early morning hours of January 11, 2015?
Yes, I do recall Kenneth Copeland traveled to the precinct or arrived at the precinct and spoke with Detective Thorpe, yes.
And did you remember seeing that video? Did you ever watch that, and do you have a memory of that video encounter?
I believe so. It's been a while. I don't recall that video being all that important to me. I remember summarizing it, so I must have watched it, yes.
Do you remember Kenneth Copeland had a cell phone on the desk when he was speaking with Detective Thorpe?
That I don't remember. I'd have to take a look at the video.
Well, the jurors have seen it, so we're good. Do you remember Kenneth Copeland explaining that he knew that cell phones can give an area on January 11, 2015, explaining to Detective Thorpe that he was aware that check the cell phone records, check the cell phone, it'll show it's in this area. Do you remember him saying that?
I remember somebody saying that during the, I can't say that I remember if it was him, though.
All right. Let me ask you this. The cell phone records that we have here, unfortunately, don't give the actual communication. They might say handset of Kenneth Copeland, speaks with a handset of Natasha Williams, but we don't know what's being said according to these records. Fair to say?
That's correct.
Now, with regards to Nyisha Williams, N-Y-I-S-H-A Williams, typical
Yes.
spelling. Do you know that person?
I do not.
Okay. Do you remember seeking and obtaining and subpoenaing cellular telephone records for Naisha Williams?
I do remember doing that.
And do you remember why you did that?
They appeared in there was a number that appeared in Kenneth Copeland's cell phone records that evening. And when I say that evening, I mean the evening of January 10th, 2015. And specifically, so I'm clear here, it was 404-621-0102. I'm looking at Kenneth Copeland's records to refresh my recollection. And because of the times that there were phone calls sent or transmitted and received by that number, I thought it was relevant. So I subpoenaed both the call logs and the subscriber information. The subscriber information was the name of Naisha Williams.
And sometimes people can, there's nothing wrong with it, people can use a cell phone that's not registered in their name for various reasons. Is that fair to say?
It's very fair to say. It happens all the time.
So a Naisha Williams, I'm just using that name since we're using it, she could be on the Verizon call as a registered person, but she can freely give me her cell phone and I could use it all the time.
That's right.
But it would come back if somebody like you subpoenaed it, it would look like it's Naisha Williams' call. In the name doesn't mean she's using the phone.
That's right.
And you, through your research, took Kenneth Copeland's statements on June 10th, 2015. And when he said he called Mr. Garlington, you wanted to know what number Mr. Garlington was using then. Is that fair to say?
That's fair to say.
And through your deduction, whether it's right or wrong, you said the Naisha Williams registered phone might have been in the custody, control, and use of Demeke and Garlington.
It's possible, but I do not know.
I'm not saying anyone knows, but that was your deduction.
That's right.
That's why you then targeted the jail records for Naisha Williams' registered phone, because you thought it may relate to Mr. Garlington.
Do you mean the cell phone records for her phone?
Did I say that?
I think you said jail records, but yes, I obtained the cell phone records for
I
her
said
phone.
jail record. I meant cell phone record.
Yes.
Okay. Now, when you obtained those records, you specifically did not request, you testified to this before, you specifically did not request historical cell site location data for Naisha Williams' phone.
That's correct.
And what that means to the jurors who may know what it is, but don't, that means you don't get the longitude and latitude of which tower that phone is employing at the time of the handset speaking with the cell tower, then it goes to switching station.
That's essentially right. You just get a log of incoming and outgoing calls, the times, the numbers, but the columns that tell you the location of the tower that was utilized, you don't get that. You need a search warrant for that.
Did you ever exclude the Naisha Williams cell phone as the phone Mr. Garlington was using on the night of January 10, 2015?
Did I ever conclude that it was not his phone, or the phone that he was using, rather?
I meant the phone is using.
No, I never definitively concluded that he was or was not using that phone.
And if, as you believed or hunched or were doing your work, Mr. Garlington was using that phone registered to Naisha Williams, then you can track at least what calls were being made at what times. Is that fair to say?
Speculation on if it belongs to our job.
All right, go ahead. You can answer.
You mean I can at least see the phone,
Yes.
like the list of calls that were sent and received, text messages sent and received by the phone, the
True.
handset?
Yes.
Yes, I believe I obtained those records.
All right. Now, Mr. Copeland stated on June 10th, 2015, from the McDonald's, that he was in his car at some point, along with Mr. Garlington and along with Mr. McMullen, Demise McMullen's, also known as Nard.
If I remember correctly, I think you said it was his brother, Rontrez Brock's Dodge Charger. But yes, all three of them were at the McDonald's in that car, a car that he had possession of. Kenneth Copeland did, that is.
Okay. And Kenneth Copeland said that I'm not saying it's true, but Kenneth Copeland said on June 10th, 2015, he left the McDonald's. I'm using 8 o'clock. If I'm wrong, just correct my time, but approximately 8 o'clock. He was driving the vehicle, the Charger, along with Mr. Garlington in the front passenger seat and Mr. McMullen or Nard in the rear driver's seat.
That sounds right, yeah. I don't recall if, what the exact seating arrangement was, but the occupants of the vehicle, that sounds correct.
And then he has that car, the Charger, going up, following another vehicle, a Nitro, white Nitro, to around Jeffrey Williams' Sky House condo.
That's what he said.
And did you look, when analyzing the calls from Naisha Williams, records rather, from Naisha Williams, and realize that during that relevant period of time on the supposed drive from the McDonald's to the Sky House, the Naisha Williams call that's potentially with Mr. Garlington and the Mr. McMullen calls, the number associated with Mr. McMullen, were in communication with each other?
Are you asking me, did Mr. McMullen and or the phone subscribed to by somebody named Naisha Williams communicate?
At the relevant time of when supposedly Mr. Copeland is driving them together in the same car to the Sky House? Yes, that's my question.
I don't recall. I do recall Mr. McMullen was a very frequently contacted number within the Naisha Williams phone records. I don't but I don't have, well, I do have Mr. McMullen.
If you could check it, I'd appreciate it. And just tell the jurors whether at the time they're supposedly in the same exact car, these two phone numbers of the Naisha Williams and the Mr. McMullen are communicating together according to phone records.
Okay, so we have what?
Mr. McMullen's exhibit, what exhibit number?
Can you use what exhibit you're using?
Is that an exhibit, or
It's already in evidence.
does he know what exhibit number it is?
Do you have an exhibit number? Are you looking at an actual?
I think he may, well, y'all can clarify it, but is there an exhibit number on what you're looking at?
No, I just brought
No,
the phone, I printed them out and brought them to court.
This
so
is, what is it that you're looking at?
the phone records for 470-217-6080, Demise McMullen.
Okay, does anybody know what exhibit number that is?
Yes, 464Y.
Thank you.
Mr. Steele requested it during my direct.
Okay.
I didn't want it during his cross as well.
Okay, so what I see here is at 7:59 p.m. on January 10th, 2015.
Just do me a favor, because you're looking down. Can you just go a little slower?
Yes, yes. What I see.
Actually, let me stop. How much longer is your examination of this witness going to be?
45 minutes.
All right, let's stop and break for lunch.
2 an hour and a half, because I don't want you to.
All right, I'll see y'all back at, let's be back at 1:45.
Thank you, Your Honor.
All right, unless there's anything we need to take up, I'll see everybody back at 1:45.
Thank you.
All right.
Right.
Hey guys, it's me. Jason had to step out for a few. I'm going to turn my camera on, but I'm warning you, I look rough. So there's me. Hey. So thank you everybody that's gifting memberships. It is so appreciated. It is so appreciated. So let's talk about Steele coming in hot, trying to get everybody, and I'm sorry, I'm still talking rough. Yeah, Mandy, now, yeah, I do. I know I look rough. That's okay. Trying to get everybody thrown under the bus. Thank you for the gifted memberships, guys. Look here. Shay coming in hot. Doug coming in hot. Yeah, I love y'all calling her Dog. Oh my gosh. That made me bust out laugh so hard. Look, when your jaw hurts and it's swollen like this, like a chipmunk, you don't want to put makeup on. I'm just saying. Look at the new members. I am loving every bit of this. Oh, I'm loving it. How much is a membership? $4.99, or it just depends on the level of membership that you want. Yeah. I think he only has one level. What's up with the merchant letter? We read the merchant letter yesterday. Let me see if I can pull it up. So welcome all you new members. It's great to have you. No, I had TMJ surgery and a work on my jaw. It was a whole thing, and then it got infected. It was rough. I had to have 3 teeth pulled. It was a thing. That's why I can barely open my mouth. I can't open my mouth real wide. So it's still swollen, and I still got stitches going on and some sewing back there. Steele was on a roll. He was on a roll, and I think he wants a little bit more time to prepare. He's like, I'm impeaching Detective Thorpe. I'm impeaching. I'm like, whoa, okay, Steele. Okay, Steele. You're a trooper. Oh, Bora, I really needed to hear that. Thank you. Yeah, TMJ is nothing to play with, and it's not really ever caused me very much issue until I kind of got a little bit older, and I had a crack in my jaw that healed badly, and then it started causing me a lot of issue. But so let's and I think that this this guy was really oh, and Gaither too, yeah, was really he seemed intimidated by Steele, first of all, and then he was really I don't want to say scared, but he was standoffish a little bit to say too much that would implicate people that he worked with, which is understandable. But you swore to tell the truth, the whole truth, and nothing but the truth. So, my guy, that's what you got to do. Yeah, Sprinkle's nervous. Yeah, exactly, Sassy. He was nervous. No, thank you for the prayers for the speedy recovery. I appreciate it. Still got a long ways to go. So, let me see if I can pull up that Ashley letter. Because I've seen a new motion this morning. Send it to Jason. Let's see. I don't think he's looked at it yet, though. Just a minute. You had 4 pulled? Yeah, I had 3 pulled. It's not fun. That's not the right one. I think this is the right one. What in the world? Okay, yeah, I think this is it. I'm sorry, I have to talk to myself or things don't work right. Sorry. Okay, I think this is it. I'm going to pull it in. Maybe stop sharing this. And for goodness sakes, let's not make me full screen. All right, percent share. Let's make that bigger. Okay. I'm not going to overuse. I'm going to put on an AI voice reader. Well, let me zoom in. Oh, there we go. I think this is it. State of Georgia versus Jeffrey Williams. Midway through this long trial, Williams and defendant DeMonte Kendrick have each filed a motion to recuse. Oh, this is the recusal of Judge Glanville. My bad. This is interesting, though. Supplemental motions hereafter. The state recognizes that Chief Judge Glanville has reassigned the motions, has been properly reassigned to this honorable court. So this one, this was an 81-page document. Are you kidding me? Supplemental report evidence. The calling of the state's witness, Kenneth Copeland, on June 7th. In response to an inquiry from counsel to the defendant's case, the state announced that Kenneth Copeland would be the state's next witness and would be called to testify on June 7th, 2024. After the announcement, the state received an email from John Melnick claiming to represent Kenneth Copeland and instructing the state to cease communication with Mr. Copeland. Oh, there's something we didn't know. And that Mr. Copeland would be asserting his Fifth Amendment. Oh boy, we found that out the hard way, didn't we? He'd be asserting his Fifth Amendment right, privilege, if called to testify on June 7th. Perplexingly, given that Mr. Copeland was being called to testify against Jeffrey Williams and Shannon Stillwell, who are represented respectively by Brian Steele and Max Shart. Melnick copied Brian Steele and Max Shart on his communication with the state regarding Mr. Copeland's intention not to testify. In preparation for trial, Deputy District Attorney Hilton, along with her investigator, had met with Mr. Copeland on multiple occasions. At no time did Mr. Copeland state an intention to plead the Fifth or say that he was represented by Mr. Melnick. Nevertheless, after receiving Mr. Melnick's email, Deputy Hilton ceased communication with Mr. Copeland on June 7th. Well, that was a little late, wasn't it? After receiving Mr. Melnick's email, the state reps are presented to Chief Judge Glanville a motion to compel the testimony of Kenneth Copeland. See, that's crappy. Saying, I know you're going to plead the Fifth, but here we're going to make you testify anyway. Extending immunity to Mr. Copeland for his testimony and to hold Mr. Copeland in contempt should Mr. Copeland refuse to testify after being ordered to do so by the court. Isn't it funny how Love got upset that Melnick copied the defense team? Yeah, Ashley always does it. I assume it's protocol. Yeah, no kidding, Sassy. the court issued the order granting the state's motion. Shocker. On June 7th, 2024, after the court was called to order, Melnick appeared before the court and informed the court that Kenneth Copeland would be asserting his Fifth Amendment privilege against self-incrimination, and in the presence of each defendant currently on trial and each of the representing attorneys, Chief Judge Glanville called Mr. Copeland to the stand and explained to Mr. Copeland that the state had sought and been granted an order pursuant OCGA 24-50507, directing Mr. Copeland to testify and extending immunity, which I'm not really sure how real that immunity deal was for Mr. Copeland's compelled testimony. Chief Judge Glanville further explained to Mr. Copeland in presence of every defendant currently on trial and each of their respective attorneys that should Mr. Copeland refuse to testify, he would be held in contempt of court and jailed until he purged himself on the contempt by testifying in court. Mr. Copeland therefore ceded in his intention to testify, and Mr. Melnick looked toward Mr. Steele and Mr. Sharp and shrugged his shoulders. This is really in a court document. This is really in a court. I mean, are we being for real? He shrugged his shoulders. So I'm putting this in a court document. How dare he? After motions hearing, the court recessed for lunch. During the lunch hour, Mr. Melnick spoke with counsel for the defendants, but at no time attempted to communicate with the state. After our lunch, the jury was called in. Mr. Copeland took the stand, and Mr. Copeland cheekily that's one way to describe Woody. Mr. Copeland cheekily answered a few questions, and when asked his age in a few years, he responded, "I plead the fifth." The court allowed no further questioning by the state and immediately excused the jury, held Mr. Copeland in contempt of court, ordered Mr. Copeland into custody. Yeah, we all remember that, don't we? I remember when Hilton asked him on trial and he told her, "These are my shoulders." The court allowed, I already read that part. In open court, in the presence of all the defendants currently on trial, in the presence of each defendant's respective attorneys, Chief Glanville informed Mr. Copeland and Mr. Melnick that he would bring Copeland back into court on Monday, June 10th, 2024, to allow Mr. Copeland to purge himself of his contempt by testifying. Mr. Melnick announced that he was going on vacation, would in no way be present on Monday, and would appoint a stand-in counsel, Kayla Bumpus. We know how that went, to represent Mr. Copeland in court the following Monday. B, the June 10th, 2024 meeting regarding contempt proceedings initiated against Kenneth Copeland upon the motion of the state, attended by counsel for Kenneth Copeland, attorneys for the state, Kenneth Copeland, and the Honorable Chief Judge Glanville. On Monday morning, prior to the start of court, the state requested from the court in chambers meeting, that's a nice way to put it too, with counsel for Kenneth Copeland, the court, and the attorney for the state to discuss the contempt proceedings initiated against Mr. Copeland upon the state's motion. The court granted the state's request upon being directed to do so by the court. The court reporter made a record of the entire meeting. Present during the meeting were, we're gonna name everybody present in the meeting. Present in the meeting were CDDA Love, attorney Kayla Bumpus, investigators for the state, the Honorable Chief. I wonder if he still has that title. No, I know he's still being a judge in that court building. Honorable Chief Judge Glanville and later Kenneth Copeland and ADA Hilton. Matters addressed during the meeting concerned only the contempt proceedings against Mr. Copeland, and the topics addressed included Mr. Copeland's rights and representation as it relates to the proceedings Mr. Copeland obligates under OCGA 24-5-507 and answers questions posed by Mr. Copeland regarding matters related to, look, I ain't reading these numbers, such as distinction between purging oneself of contempt as addressed by and perjury as prohibited by, with the exception of times where Mr. Copeland was afforded the opportunity to speak with Mrs. Bumpus alone. The entire meeting was taken down by the court reporter. See, if you have to put it in bold and underline it, then there's questions. See, in the words of Emily D. Baker, I got questions. Who wrote this motion? That's a good question. We're on page 6. Let's go to the last page and see who wrote this motion. Shall we? And I ain't scrolling all the way down the last page. See who wrote this motion. Brian Steele, the law firm of Brian Steele and Keith Adams. So Brian Steele. No. Adrian Love. Adrian Love wrote this motion. Adrian Love wrote this motion. So that's why all this is underlined and put in bold about it pretty much not being ex parte. And then we found out it was ex parte. It was served to these people. Foregoing motion was served to via e-file to these persons: Brian Steele, Keith Adams, Jay Abbott, Katie Higgerty. Is that the person who's Jay Abbott? Is that the person whose name we don't know? Jay Abbott and Doug Weinstein? Maybe that's the person who helped out Doug Weinstein, Jay Abbott. So yeah, Love had it served to Brian Steele, Keith Abbott, Keith Adams. I'm sorry, look, I can't even talk. Brian Steele, Keith Adams, Jay Abbott, Doug Weinstein, and Katie Higgerty. Of course, it was Love. Yeah, I know. I'm surprised she did that much work. She is going on and on about it, and there not being wrong with it. It definitely wasn't ex parte or anything. See, the entire meeting was taken down by the court reporter. Brian Steele's defiance of the court's commands and the subsequent contempt ruling. Oh my gosh. After the meeting. Oh my gosh. After the meeting regarding Mr. Copeland's contempt and obligations under OCGA 24-5-507, Brian Steele stood in open court and demanded a mistrial as he loudly repeatedly hurled at the Chief Judge Glanville accusations of misconduct, because there were. It was an ex parte communication. Don't even try. Hurled at Chief Judge Glanville accusations of misconduct, disturbingly after accusing the court of illegal activity. Mr. Steele repeatedly disobeyed Judge Glanville's commands to reveal the Mr. Steele's source of information regarding the in-chamber matters. After Mr. Steele refused to comply with the court's instruction, the court held Mr. Steele in contempt of court after defiantly and repeatedly disobeying the court and being held in contempt of court, Brian Steele filed the motion and supplement. Oh, here we go again with the bold, italic argument and citation of authority. No fact set forth in defendant's motion or supplement authorizes the recusal of Chief Judge Glanville. Oh, so she wanted Glanville to stay. She wanted Glanville to stay. Glanville puts up with my garbage, and I want him to stay. Interesting. To warrant disqualification of a trial judge, the affidavit supporting the recusal motion must give fair support to the charge of a bent of mind that may prevent or implode impartiality of judgment. To be disqualifying, the alleged bias must stem from, here we go, bold and underline, an extrajudicial source of a result in an opinion on the merits of some basis other than what the judge learned from the participation in the case. Emphasis added. Yeah, we've seen your emphasis. There is a presumption that the trial judge, acting as a public official, faithfully and lawfully performs the duties devolving upon him. Determining whether an affidavit supporting the motion to recuse is legally sufficient and whether the facts asserted authorize recusal present questions of law. That's the whole problem, though, Miss Love. That's the whole problem. Is that he had an ex parte communication without any of the defense being there. That's the whole problem. And he knew he was wrong when Steele called him on it. Exactly, Greg, there was a presumption. When he called him on it, when Steele called him on it, and he got all upset and said, I want to know who told you about it. I want to know who told you about it. When he acted all defensive like that, that's how he knew he was wrong. Let's just be for real. Here, with the exception of the defendant Williams, ultimately allegation regarding a simple instance where Mr. Steele was really? Oh, we're going there. I wish I would have read this before. This is entertaining. Oh, yeah. He wanted to know who told you. Who told you? I love that clip. By the court for not being prepared, defendants' motions and the supplement are based entirely on the defense assertions regarding the June 10th, 2024 meeting regarding the contempt of the proceedings against Kenneth Copeland, the actions taken by Chief Judge Glanville after Steele defiantly refused to comply with the court's repeated request to provide the courts with information. Yeah, you repeated that twice. Sassy, you've been a member for 2 months. Thank you. It is interesting that Love was upset with Melnick copied defense, yet Ashley always does. It's protocol. She makes it sound nefarious. That she does. That she does. But that's kind of what she does. It's kind of her thing. Lord, what doesn't happen now? No, nothing. I'm reading what Love had served to the defense attorneys when Glanville was booted from the bench, and how she didn't want her little supporter booted from the bench. I about called him her boo thing, but I decided that might be inappropriate. But yeah, that's good. That's good, Sassy. And entirely true. Georgia Code of Judicial Conduct 2.9 regarding ex parte communications provides that judges shall accord to every person, here we go, who has a legal interest in a proceeding or that person's lawyer the right to be heard according to law. Emphasis added. However, we in bold again, no defendant on trial in this case had or has any legal interest in or any standing to be involved in the state's motion to compel the testimony of Kenneth Copeland or any subsequent contempt proceedings initiated on motion of the state involving Kenneth Copeland's refusal to testify. He was her little friend. Yes, he was her little friend. Since no defendant in this case had a right to be present in the June 10th, 2024 in-chambers meeting with Kenneth Copeland, why not? Why not? And his counsel regarding the contempt proceedings against Kenneth Copeland, the fact that the meetings provides no grounds for recusal of Chief Judge Glanville, says you respectfully submitted this day, 10th day of July, 2024, Adrian Love. Then what is all this? Oh, exhibits. My concern is for my client had been involved, and I would have demanded a much more specific immunity deal. You need him much more than he needs you. Oh, you have put him in a terrible position where you know his life is in danger. Oh, I can't read this. Whether he is in custody on the street, he's a marked man from this point forward. Go F yourself, it says, if you think I'm doing anything besides protecting my client. Wow, y'all see that? On Friday, June 7th. Wow. 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 Do you see this?
I read it. Absolutely. I saw it. You know, all I want to know is who told you?
Who told you?
I want to know who told you. I'm sorry. This is probably, there's something with this DA's office, and I don't know if it's common, but it's almost like, okay, yesterday, I'm not going to go, I promise y'all, I'm not going to pull out any chart paper, right? But okay, so yesterday, I wrote something on a piece of paper, right?
That was so funny.
And they keep presenting it as if, well, because it's on paper, there's nothing they can do. But you wrote it. And you see, and she's doing it in here. I've seen it in other instances. Well, the indictment says XYZ. Well, ma'am, you're the one that wrote it. And it was wrong. You don't have, no. Or there's something in the indictment that needs to be amended or something of that nature. They keep presenting it as if we can't do anything now that it's written on paper. Or now that it's typed out. Now that it's, you know, ones and zeros, I can't do anything about it. Yes, you can.
Right.
You really, truly can. So looking at this right here, I think it's funny how they present it. Well, first of all, I think it's to the point that you're reading right here. It's funny how they presented it in court, but then when you read it, it's a totally different story. The whole infamous, you know, F in there. You would think that he was just saying it just like flippant, like they be doing when they're just reciting stuff. But no, you can tell that he's, again, I don't approve of it, but he's saying this because he's defending his client. But remember, they said that they didn't know he was his client. But you hear this man saying it pretty clearly that that's not the case. So the way that they present it is just so weird. And it seems, in my opinion, to be very duplicitous. They're not being honest. They're not fair and honest dealers. They're just saying things and kind of present them in different ways in order to get the advantage over somebody. But that's it.
Yeah. Crazy stuff. Crazy stuff.
Uh-oh. Jurors like visuals? Okay, then I'll bring out the chart paper. That's what Tina needs, is some chart paper. I'm bringing out some chart paper to make my case. Let me go get some.
Look above Adrian Love's name. She's got an African proverb.
Because that's her personal email. I hope it is.
If you want to go
maybe,
fast,
maybe it's
go
not. No, it's
alone.
not.
If you want to go far, go together.
Well, they've gotten further without her than otherwise. So hey,
I know
maybe
they do a lot better when she ain't there.
they do a lot better. Now, whether Whether or not they're really moving the numbers, I don't know, but they're getting a lot done without you, Adrian.
Oh
I'm
my
just saying.
gosh. That ain't her email. I ain't slowing down on that or nothing. I'm not. I'm not. I'm going fast. I'm going fast.
No,
Okay.
this is wild. Okay, real quick, I want to say shout out to all the new members. My goodness, in the morning.
I know. Look, I'm telling you.
No, the issue did not resurface. We were just going over.
Yeah, no.
Doing like a little blast from the past. Ladies and gentlemen, we're doing a blast from the past.
Oh, I know I don't look great either, but thank you.
All right, let me see. Thank you so much, Mandy. I appreciate y'all.
Yeah,
Let me jettison you out of here. You gonna hang around? What are you gonna do?
I'm going.
I love
I gotta
it.
rest my mouth. Y'all have a good one.
You got it. Thank you so much. Everybody, thank y'all so much for Mandy covering for me. Could y'all tell Mandy thank you for stopping by, hollering at your boy. All right, we're going to see if this trial gets it moving. Absolutely. Hey, by the way, that's where I was going to go. Thank you to all of the members, the new members. My goodness, in the morning. All right, I don't usually show y'all this behind the scenes. Let's see if I can show y'all this without causing a disruption in the multiverse. Yeah, it's gonna break. Okay, I was gonna show you. All I can see on my end is all of these new members been added to the screen. It is amazing. See, I show you a picture of it while we're waiting. But y'all, welcome to all the new members been jumped in. I see N Doug, the OG, is jumping them in left and right. I love it. I love it. Welcome you all. And if you are a new member, jump over to Dear Woke Christian on YouTube. Go to the community tab, jump under the community tab. There's a community post for new members. Make sure you join the Discord. What was I about to do? I was showing this picture right here. It is not working. Okay, let me see. It might break. Let's see if it looks crazy. All right. I'm gonna show it and see. It's probably gonna look crazy on your end. It does look crazy. Okay. Real quick, on the right-hand side, you see all these green right here? This is all of the new members that have been added to the page today for this live stream. That is crazy. Man, welcome to everybody, all the new members. Shout out to them all. I appreciate y'all. Let me get this before the multiverse breaks or something, and it'd be my fault. So I appreciate y'all. They are not back from lunch. I didn't hear exactly what time they were supposed to come back. Did anybody catch the time? I know yesterday was like 1:15. Won't Whitaker be presiding? I feel like I missed a conversation. Now I know Steele was bringing that noise. He said, "Look, I got some stuff to ask you," and I think Steele was doing a pretty solid job of undermining a lot of the detectives and the police investigation that went into things, because he was asking some questions. I was like, I had not thought about that. Like, again, did you look at the videos? Why did y'all not do that? Those are some very valuable questions. Instead of just relying on, because I didn't think about it. Like, there's probably a security camera at the Sky House, and well, I know there is. I've been there. So there's security camera. Did y'all get that? Why did you not get that? That's key. Instead of relying strictly and solely on something that's not reliable and as accurate as the cell phone data, the cell phone towers that tell you exactly, pinpoint somebody. Well, why not just, if you say that they're at the Sky House, then you probably wouldn't got I feel like this is what Brian is saying. If you say they're at the Sky House, then I'm sure you went and got the surveillance camera to prove that they were there. He wasn't playing games with this guy. All right, let's keep this going. I'm gonna pull this in as soon as it's ready. All right, 1:45. Mercy, what they doing? They getting lunch. What time do they go to lunch? Okay, never mind. And they gotta they're supposed to end at 4. So Brian Steele, he says he's gonna be about 45 minutes to an hour and a half. That's gonna be the rest of the day, right there. Yeah, and I think to shout out to John C. Of course, absolutely. You can have an ex parte meeting. That's not the argument that people are having. However, there in the rules, in the statutes, there's some very clear definitions and who can be in it. A sworn witness is probably not a good idea. That's just not a good idea. And there was no urgency. It wasn't as bad as they were making it to be. And I even showed you the video where Adrian Love actually asked for the ex parte, and there was no rush for it. There was no need for it. So therefore, it's going to put itself they're going to put themselves in a pickle. I don't think I paid attention to that. They weren't. Okay. I guess I wasn't paying attention to what time it was. Yeah, half the day was gone this morning trying to get another attorney. Yes, they are stopping early. So they're going to be done today, Faith, at supposed to be done at 4:00. So we'll see what happens there. But let me see if I can yeah, so this whole back and forth about and I'm finding it interesting also that Fonnie Willis is starting to insert herself into discussions that maybe she doesn't need to insert herself in. All right. And I'm sure you all have already seen the motion in limine where Fonnie Willis has inserted herself in as well. And Adrian Love is writing on her behalf. I'm starting to wonder, if they're realizing that this case is starting to fall apart. And if they're what they thought was going to be a slam dunk, what they thought was going to be an easy payday is going to start turning into an albatross around their neck. And they're trying to, dare I say, rectify and right the ship because the lower decks are starting to fill up with water. I'm wondering, are they starting to say, oh, we might be in trouble. We might need to come up with another plan. Okay, this right here, this is a good question. Okay, because I'm not emotionally, I just can't take the emotions of declaring a mistrial. That's why I don't even use mistrial anymore, because they just run you through the emotional gambit, right? You think it's gonna happen, oh man, it's gonna happen, and then they let you down. They think it's gonna happen and let you down. I'm not gonna do it. However, I do think there's more. Somebody has alluded to it, and I don't remember. It might have been Jay Sneed earlier this week. He said that Judge Whitaker is going to declare a mistrial after the election. And all I'm doing is looking at the comments right here, and that one kind of jumped out to me. I started noodling it in my mind. Well, if she declares a mistrial now, that would look really bad on Fonnie Willis. Fonnie Willis would be on the news trying to explain why she lost this case, and people are on their way to the polls. Now, granted, I don't think it's going to change much. I don't think it's going to unseat her as probably just going to be the presumptive winner, but you don't know that. However, what if she declares a mistrial afterwards? Fonnie Willis is already secured as the DA for the next 4 years, or however, I think it's 4 years. 4 years. And there's nothing, she can't be unseated. So all she has to do now, for lack of a better term, if Judge Whitaker calls a mistrial after the election, and other people have said this too now that I'm thinking about it, it almost clears the slate for Fonnie. All the stuff that she's doing now on this side of the election will almost be done away with. Finish. And she comes in almost new, or relatively new. You got my point. There's still baggage, but this case would be one of those things. If it's declared a mistrial and they say, hey, look, we ain't gonna worry about it. We done got our money. We done got our position, whatever. Let's keep it and run. Again, that's my tinfoil hat. So I don't know if it's as much a concern now, Debo, because I think there's been more than enough. And I've heard other people say it, even people that disagree politically with me and so on and so forth, and are smarter than me, which is not saying a whole lot, but lots of people are saying this should have already gone to mistrial. There's no reason it should have gone this long. But maybe it's just because they're waiting for the election. So we'll see what happens on, was that November 5th, November 6th, whatever, the morning after. We'll see what happens the day after the election. Unless she just gets routed. Yeah, November 6th. If she gets routed, then that's a whole nother game. But if she wins and Judge Whitaker's whole position changes the next day, whole position starts changing the couple days after, maybe that's where she's leading to. I don't know. But I again, it's just a thought, just a theory, just an idea. I don't know it emphatically, of course, because I'm a pre-K law student, but it just seems like, why are they fighting so much for something that truly looks like it's a dead squirrel? Like, what are you fighting for? Why are you calling the ambulance? The squirrel got ran over. Just let it go. Why are you trying to airlift this thing? It's done. It's a wrap. There's nothing you can do. But they keep trying. Why? Maybe they're just trying to hold out to the other side of the election. Shout out to Monica Mo Justice, my sister from another. Shout out to the old timers as well. Can't believe it's been 2 months already. She's been a member for 2 months. Shout out to Monica Mo Justice. It's been a blessing to me. She sends me these scolding voicemail messages. You're getting it wrong. My notebook says this. I love Monica's text messages and her voicemail messages. They're the funniest things because she be chastised. You hear her flipping her pages of her notebook. Yeah, I'm talking about you, Monica, because I'm down here in Georgia. You ain't gonna come fight me. She'll call me and I'll hear her flipping those pages and she's telling me, I'm like, man, I missed that. Yeah, you're right. She was explaining to me why, I'm gonna call him Super Ponytail, why the Super Ponytail guy today was kicked off the case. And I was like, yeah, I guess she's right. But I hear them pages flipping in the background. Shout out to Monica Mo Justice. Don't let me bother you. That is my girl. Absolutely. But yeah, I like what Bitter Lily said right here. When egos go before evidence, I'm sorry, I can't. And my goodness, how did I not? I'm out talking myself. Please understand, this also does help Paige. This is the other part of it, I think, that goes into it that helps Paige as well, even though she's not up for election. She's not up for re-election right now. But if she jettisons this after Fonnie is secured in position, any Fonnie supporters that might have been turned off to her when she declares a mistrial will probably let it go because it won't negatively affect Fonnie's re-election bid. That just a thought. Just a thought. Okay. You know what? Maybe next week we need to start some prediction board. I need a prediction board where everybody can give me what do you think is going to happen, and then we can kind of like update it on a regular basis. That would be so dope. They will declare mistrial after they rest their case. I think you said if. I think that's there's a lot of opportunity. I don't hate that idea. I think that was not a bad one at all. The game Faith, thank you so much. We are playing YSL Jeopardy tomorrow night at 6:00 Eastern Standard Time. I'm going to tell y'all right now, the questions that I got were so good. I think I'm going to have to make two. I'm going to have to make another game because the one I made this morning is outstanding. But I got some more questions. Some more. By the way, I told people if you wanted to email me however you do it, the answers and the questions and the answers for Jeopardy. But don't send any more. Don't send any more because I think I'm going to. I already know that I'm going to elevate the next game because I think we just got to make it more funner. So that's it. I don't care. All right, this is what we do. If you have some clips, and what I mean by clips, less than 30-second clips of some entertaining things that have been said in court. Entertaining things said in court. It could be by the judge, it could be by Glanville or Whitaker, it could be by the attorneys, it could be by the witnesses, whatever. If you have something entertaining that people can get a hearty laugh out of, and I want the actual clips. I'm going to be using the video. in the second game. If you have them and you're like, "Oh, this is fun. I got this little, was it TikTok? I can download TikToks, Twitter posts, as well as YouTube shorts. So if you run across one that you're like, oh, this is really funny, I think this will be a good one. They got to be entertaining. They don't have to be highly academic. This is just fun. So if you have any of those, you can email management, dearwokec@gmail.com. All right. You can email those to me. Just send me the link. So here, Jason, here's a submission for the Jeopardy game, Jeopardy Part 2, and just send it to me. Funner? You don't like funner? Oh my man, hold on now. You gotta now I'm an expert at using the wrong words because I used to work around little people that use the wrong words. I am an expert. I'm trained, certified, bishoped in using the wrong words. I like using the wrong words every now and then. I just want to do it. So any pace, if you have any shorts or clips, you can if you want to clip out of a video and just send it to me, that's perfectly fine. Dearwokec@gmail.com. I'm gonna have time tonight after the dynamic duo finish their school play. I think I'm gonna work on a second one because the one we already have is hilarious. But I think we got to put more people in stitches. It's got to be even better. So I'm gonna add a second game to it. This is gonna be fun. We have a good time. Oh, I'm aware that I use the wrong words. I am aware. I just aware also rhymes with care. I just don't. I don't. But again, now that I'm out of the confines of being a classroom teacher and had to be a responsible adult, I can just say funner. But yeah, that's gonna be good. Wait, you want to send my YSL cards? Okay, send it to me. You can send it to me. That's fine. If it ends up, we're gonna be playing YSL Jeopardy for a while because it's hilarious and it doesn't take that long. So if you send it to me, just send me your category, give it a category and the 5 questions or the answers, whatever you want to call it. Everybody they were really well formatted, by the way. I don't know who told you how to do that, but yeah, they were excellently formatted and it took me no time to make it. So whatever. I want to make it better, but the one I had today was outstanding. The one we're going to play tomorrow, the first one is going to be excellent. So yeah, send it to me. Okay. Yeah, no problem at all. Plans and pins, send it to me. Make it so. Make it so. Tomorrow, the Jeopardy game is at 6 p.m. EST. Tomorrow night, that's the 19th. So we're going to go 10 October 19th at 6 o'clock. There you go. Tina Bonds. Mags, please forgive me. But yeah, I think it just, look, I just want to have some fun. I think this case is kind of draining. It's a little bit nerve-wracking over time when you're watching stuff that just doesn't make sense. When you're watching stuff that's like, I don't know, maybe it's because we're just average Joes and Janes, but because of that, a lot of this stuff is just ridiculous. And so, no, we're not gonna play YSL Monopoly. It would have to be called Rico. No, we don't want to be chasing the money. Do you not remember? Do you not remember that if you chase the money, you're doing something illegal? I might have to pull that back up. That has to be the funniest. That has to be the most Adrian Love moment that Adrian Love has ever had in some time, at least. I mean, I'm pulling it up right now. The winner gets a 3-hour debate with Love. Let me tell you, is that a winner? Is that motivation to win? Or is that punishment? I'm being for real here. Look, Geneva, I don't need to be, look, we're already under RICO. We don't need to be under the Geneva Convention violations too. That's like cruel and unusual punishment. There's no way. I just can't do that to the people. I can't do it to my people. Now, you might not know. Maybe you don't know. I have an entire playlist of funny videos I've made around Lady Love. And if you go, let me just share this real quick. First, I'm trying to find the video. Make sure I actually. Where's my video? Chasing Love video. Where is it? I don't see it. Okay. Any pace. Here we go. Let me show you very quickly. All right. If you jump on over to Dear Woke Christian rather, on the good old YouTube space, I have a playlist called The Lies of Love. And there you'll go. You can find all of my love-inspired videos. I just like making fun of the name. The name is just the best, man. The name just comes in handy. It makes for its own comedy skit. So anyway, there's that as well. Let's do this. Bang. Okay. I don't know why this video is not showing up. Maybe I didn't put it in there. It's the one chasing the money. Okay, we're gonna pull this one in a second because I think it's hilarious. All right, let's see what we got here. I try not to say that Judge Whitaker's doing. I do think Judge Whitaker's doing things that, in my opinion, are not the right things to do. I definitely feel that way. I don't know if they're illegal things. I don't want to go that far. I'm never gonna. I don't like doing that to her, but I don't think that they're the things that she should be doing that are right. And there's so many people, bright legal minds, that have all agree like this case is donezo. Should have been finished. There's no reason to still be here. Why are we here? All right, let me get this out of the way. This has to be the most Adrian Love thing that she's said in a while.
Where he is displaying chasing that money, but his past chasing him, we would argue, reflects at least part of what we are alleging that the gang has done or does in furtherance of the enterprise itself, obtaining money.
Tell them to bring me my money.
And property through a pattern of racketeering activity, him chasing that money.
Tell them to bring me my money.
But his past chasing me further shows how he is furthering the conspiracy.
How
by
is
saying
that furthering the conspiracy?
chasing that money.
Tell them to bring me my money.
But his past chasing him suggests that he not only does things or has done things that perhaps in chasing that.
Tell them to bring me my money.
Money that are not legal. He is continuing to chase that money in ways that are not legal.
What suggests that he is doing anything illegal by chasing that money?
Your Honor,
Isn't that what pretty much all of us who aren't independently wealthy have to do every day of our lives?
You ain't gotta, I don't know where you walking to, but I just need you to walk with a new mindset. I got bread in my pocket. I got bread in my pocket. I don't know who this is for, but I got bread in my pocket.
I got bread in my pocket. I got bread in my pocket. I got bread in my pocket. I got bread in my pocket. Bread in my pocket. I got bread in my pocket. I got bread in my pocket. Bread in my pocket. I got 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 bread in my pocket. Bread in my pocket. I got 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 bread in my pocket. I got.
This is that bomb that's gonna snap a generation from a scarcity mentality. You're not gonna wait for the other shoe to drop. There's always gonna be bread in the storehouse because he trusts you to multiply.
Your Honor.
Isn't that what pretty much all of us who aren't independently wealthy have to do every day of our lives?
Shout out. That was a fun one. I like that one. Bring me my money. The love playlist, didn't I just drop it? I hope I dropped it. Let me see. Here it is right here. Who's that? Anthony Lowe. Sorry about that. My glasses are dirty. I keep saying I'm gonna clean them. Anthony Lowe, here's a here's a playlist right there. Just dropped it down in the chat for you. Yeah, I just have fun picking on Love because she does some stuff, man. Love be teeing them up, man. She just be teeing them. Like, what in the world is wrong with you, girl? And she loved talking. That's the part that I think y'all might not know this about me, so I'm gonna just tell y'all. We're amongst friends, right? Okay. Dear World Christian likes to talk. Okay, that's just it. It's funny because Chief Executive Second Born has she started to talk in her sleep now. So she'll go, she was at a sleepover the other day and her friends told her she talks in her sleep, and I mentioned it to my wife. She said, "Oh yeah, I know she talks in her sleep." Like what does she be talking about? She just wakes up and she'll be having some pretty robust conversation. Like, who is she talking to? She's talking to herself. Um, Dear old Christian, maybe it's possible I might have done that a time or two when I was a child, but I can understand what Adrian Love does. She's like, if I use a flood of words, I'm going to win this conversation because I'm going to use a lot of words. And I no longer believe that to be the strategy of success. I quit doing that many, many, many long times ago. However, I understand what she's doing. She doesn't have a cogent argument. She has a flawed thought process, but she has a storehouse of words. So her thought process is, you know what? I might lose the argument, but I'm going to deluge you with words and I'm going to beat you into verbal submission. There you go. Chief Executive Second Board does it too. I'm like, girl, let it go. You lost. I'm not going to argue with you. No. There you go. But that's what Adrian does, in my opinion. She thinks she can talk herself into victory. Now, if you watch Under Glanville, there's some instances where he said one thing and 15 minutes later, he said, fine, love, whatever, and just goes along with her. So I believe that's what her strategy is, just to talk you into submission. And by talk you into submission, get you to comply with her because you just like, look, just stop. Just stop. But if you notice with Judge Whitaker, she does that with Judge Whitaker too. However, once Judge Whitaker started shutting them down and getting a little bit feisty, a little bit rude, a little bit more, no, stop it, move on. She stopped that stuff with Judge Whitaker. But with Glanville, just rewind, check a couple of instances with her and Glanville. There's one where they're like yelling at each other, shouting at each other in the courtroom. It is crazy about, guess what? Discovery. And she's just talking. She won't stop talking. He literally says, stop talking, Adrian Love. Or I think he says District Love, DA Love, whatever. But I think it's because she feels like I can just talk. If I just give you a deluge of words, it'll drown you. Oh, just drown in all of the shenanigans. Love struggles with confidence, which is typical of some women of color who are competing with women of non-color. She needs to learn to lean in. Okay. What I've learned is, well, okay, let me, I'm gonna take this, Monica, and we got a few minutes. I haven't seen him show up yet. For me, when I was an unconfident, dealing with the Dunning-Kruger effect, meaning that I just knew a very little and I just thought I could talk my way into success. What I found out for me is stop talking. Go find out what you're talking about. Find out what you know and stay in your lane. There's a 0% chance I will, as much as I enjoy watching videos about a particular topic that I might think I know something about, there is a 0% chance that I'm going to go tell an auto detailer how to detail a car. Even though I kind of watch those videos, they're satisfying videos to watch. And I probably know my car can get a little bit of shiny now, right? But I'm not somebody who does this as their profession. I'm not going to come and tell them what to do their job as their profession, because I realize that, yeah, sure, my car is going to be shinier, but they do this as their profession, and I'm not going to get into that. Now, where am I going with that is I recognize that's not my lane. And so therefore, I'm gonna stay in my lane. I can talk about things. There are topics that I know. You don't come for me. Don't come over here for me about these topics. This topic over here, I might be able to hold myself down, but I know that I'm not. But these topics over here, the topics that I know, I also don't have to talk a lot about them. I can give you book, chapter, verse, and context and let you deal with it. I ain't gonna argue with you about that. There's no reason for me to do that. But these other topics over here that I really don't know, there's the problem. So I think, in my opinion, I think Adrian Love would be out over her skis a lot of the time. And she doesn't take the time to become proficient and, dare I say, confident in what it is that she's talking about. I don't think I think part of the problem is this case itself is a walking problem. Oh, it's not walking. This case itself is a problem. So it's not like this case is I just watched about the Attorney General here in Georgia filing gang charges against a gang up in North Georgia near the University of Georgia. And it was a small clip. It wasn't very long. I might find the whole thing. Maybe one day we'll talk about it. But it's the but my point is they didn't do RICO. There's a lot of activities that are akin to what we see here. There's a deletion. There's several deletions actually, but they're not doing RICO. And this is the Attorney General of Georgia, by the way. That's a very interesting point. But they know their lane, and this is going to probably be that case. Though they just indicted these people on Tuesday, it is very possible this case will probably be in the books, and these people will be in jail before the YSL trial is finished. And it's right here in Georgia. She uses gaslight as a tactic. I think a lot of people use gaslight as a tactic because they know they're wrong. That's just my opinion. I'm not an expert at gaslightingology, but every time somebody that I've seen who uses gaslighting, a lot of the time, they're dead wrong. They're telling me today's Tuesday. I'm saying today's Friday. They're gaslighting, and they're wrong. They're just wrong. Now, there have been some people that I'm like, you could maybe be right, or maybe you think you're right, but there's some people that are just dead wrong. And there's the problem. They're not willing to say, hey, you know what? I'm not right here. And I tell people all the time, I'm perfectly fine with having a discussion about theology. I'll use that as my wheelhouse. I got no problem discussing theology. Got no problem discussing my faith and where I stand and why I stand on it. All I ask is that we use the book, chapter, and verse in context to make our point. I'm not going to use any other books. I'm not going to use any other ideas. I'm just going to use the scriptures. That's it. If you can convince me from the scriptures that Jesus was a black man with nappy hair, that's fine. I'll rock with you. If you can convince me from the scriptures that Jesus was a social justice warrior, that he was out there protesting and doing hashtags in first century Jerusalem, that's fine. I'll get down with you. But book, chapter, verse, and context, you must prove it to me. Not from what you're thinking, not your own machinations, not your own thoughts. That's it. But most of the time, these people know they're wrong. They know they're making it up. They're just outright lying. And so therein is the rub. So I appreciate y'all. Thank y'all so much. That was good. Okay. Oh, she's extremely confident, but she's confident in her wrongness. All y'all parents have got kids that be confident. Some little boy think he's looking fly to go talk to some little girl at school, done sprayed himself down with Axe body spray, and he stinks, but he's confident. It's confident. I think so, Ashley. I just don't know if it's going to be I don't know if it's going to be filmed, if it's going to be streamed. Okay, let me see. I appreciate the dissent opinions on love. I watched her confidence diminish when Judge shifted to a non-black female, specifically take Judge Witt's tone toward her as opposed to Hilton. No, I agree. I think she's been knocked down a time or two, but also she's dealt with a couple of setbacks. She's dealing with setbacks, and I don't think she's really good at multitasking. Not like I'm a pro. Don't let me look. Don't let me get over here. Y'all see me over here. Your boy be got a struggle treatment, but I don't think she's good at multitasking, and she's getting a lot of heat from a lot of different directions. But I agree with you, Mo. No disagreement at all. Are we smashing people? I hope not. Are we smashing people? No, hope not. But we are doing smashing that like button. That's what we're doing, Axel Wheel. We're putting that like button in critical condition. Absolutely. And we know what? We adding a whole bunch of new members. Shout out to all the new members, man. That's crazy. Shout out to them all. I'm trying to be gracious, Gemini, but between me and you, just me and you, I kind of agree with you. They always scrambling, scraping. I'm telling you right now, all of their pots and all of their pans at their house are always clean. Why? Because they're always scrambling and scraping. Them pots are always clean. Them things are shiny. Shiny. Oh, no. I hope, my goodness, in the morning, I hope I didn't allude that love is a victim. By no means. Love is her own worst enemy. I'm just saying. Okay, let me see. What we got right here. So Rome King has mentioned this. Somebody's mentioned this before, and they think she probably. I don't think. I'm not going to say that she cheated. I think she probably got her degree with. She worked hard for it. I don't want to take away from it. All I'm saying is I've seen educators who are not good educators. I've seen people, and they've gone through the same courses that I went through, and such of that nature. They're just not good at their craft. I mean, for crying out loud, I don't think I was the best teacher. And I know I did well in school, but I just don't think I was the best at it. That doesn't mean that, you know what it is? If you went to a school where maybe you just had, if you went to college, and let's say your college had a pretty high bar to get into, you get into school, you realize that everybody there at school was senior class president, valedictorian, all that kind of stuff like that. So you're at a school now where there's a lot of people, you're competing with the better of the best, right? But when you go back to your high school, you were the big man on campus, big woman on campus. So I think there's a situation like that where maybe Adrian Love was really good in a place that she was the only one. But you put again, I'm a pretty good basketball player against some second graders. But you put me on a basketball court with some college level students, college level athletes, it's gonna look bad. And my goodness, in the morning, you put me with some NBA players, I might not even come. I might just stay at home. So, which, by the way, where's Adrian been all day? Never mind. So you got my point. Like I think she's just the competition level is rising, and it's really causing her to not be able to rise up to it. So I'm not saying that she cheated or somebody said that somebody took her LSAT for it. Court is back. What do you mean? Oh my goodness. Is this thing?
I didn't mean to be wrong. Just correct it.
Yeah.
Sorry about that, y'all. All right, let's bring that back in. I backed it up a few seconds. Man, they just jumped right in. They came right in, just jumped in. Sorry about that, y'all. Oh no, she has no self-awareness at all. Thank you so much. I apologize for that. Judge Whitaker just has it. I backed up a few seconds so we can catch what Brian Steele is saying. I wish they wouldn't shorty spot, but I think they are. Oh, not his online presence, I think, because of what he said in court. Boy, y'all do not like Sprinkle, boy. Sprinkle is not.
This is stuck, so
I like that.
Thank you, Your Honor. Good afternoon, Mr. Sprinkle.
Good afternoon.
I think we were at a point where you were about to testify, I believe, obviously, tell me I'm wrong, that at 7:59 p.m., according to the phone records, Aisha Williams' associated phone, who may be Mr. Garlington's phone, handset that he had, connected to Mr. McMullen or Nard. And just if I'm wrong, I didn't mean to be wrong, just correct it.
Yes, so I see that actually there's a call at 7:53 p.m.
And just to make sure we're oriented, this is all Eastern Standard Time, and we're talking about January 10th, 2015.
Yes,
All right.
Eastern Standard Time, January 10, 2015. So I see a call from the handset associated with Demise McMullen to the handset associated with a subscriber named Naisha Williams at 7:53 p.m. I then see that at 7:59 p.m., and I believe that's where we left off, that the handset associated with Naisha Williams calls the handset associated with Demise McMullen. And again, that's at 7:59. And then I don't see another call between those two handsets, at least of the variant that would appear in phone records, until 11:01, when Naisha Williams, or when looks like the handset associated with Demise McMullen calls Naisha Williams, the handset.
Now, from your view, the reason we even got Naisha Williams is because Kenneth Copeland gave a statement on June 10, 2015, articulating that he made calls at a certain time to the handset of Mr. Garlington. And you deducted potentially that would coincide with Naisha Williams' handset.
Yes, I thought that was a possibility. But like I said before, he also said that he called Mr. Garlington on FaceTime. Now, he didn't specify if all the calls were FaceTime calls. Some were voice calls that would show up on cell phone records. But apparently there were multiple ways that, according to Mr. Copeland anyway, that he would have contacted Mr. Garlington. So I surmised that based on the time of the calls, that perhaps this 404-621-0102 number that was subscribed to by somebody named Naisha Williams may have been Garlington. But again, I don't know.
I understand. And I appreciate you telling and educating the jurors. Now, Mr. Copeland said around the 8 o'clock time, so 7:53, 7:59, I'm including that time, that he was in a car with Mr. Garlington and Mr. McMullen, also known as Nard.
So I don't recall Mr. Copeland pinpointing the exact times that any of these things happened. We may just have to deduce it based on everything else in the case. So to be exact, I don't know that he ever said, I was in a car with these people at this exact time.
Let me do it a little differently then. From the McDonald's going to the Sky House, he had traveling with him Mr. Garlington and Mr. Demise McMullen, also known as Nard.
Yes.
According to Mr. Copeland.
Mm-hmm.
Okay, but you have the handsets of Naisha Williams and the handset of Demise McMullen, also known as Nard, contacting one another around the times that this Mr. Copeland's car would be traveling from the McDonald's to the Sky House, if he's true.
That is correct.
All right. Do you know of a reason that people would call one handset to another handset in the same car?
Objection, calls for speculation.
Sustained.
All right. Let's go to Mr. Copeland's claim on June 10, 2015, that he traveled with his phone that we have, that he says he had with him, from the McDonald's to Jeffrey Williams' Sky House condominium on January 10, 2015, approximately. I'm using the 8 o'clock time. I understand 7:53, whatever, but around that time. Do you have any phone records to show on Mr. Copeland's phone that he says he had with him that he was ever using a tower near the Sky House of Jeffrey Williams after leaving the cell tower of the McDonald's on the evening of January 10, 2015?
From what I remember, he did use a tower near the Sky House at 11:14 p.m. that evening. But that's what I recall. I mean, obviously the records are in evidence, but yeah, 11:14, short answer.
Okay. But according to Mr. Copeland, he's leaving the McDonald's and driving to the Jeffrey Williams condominium located at the Sky House on the exact date and time that we're talking about, and he went directly there.
I don't know. That's what I recall. He did say, I don't know if he said we went directly there, or if he just omitted that they made pit stops along the way. But my recollection was that the short answer to your question is, I don't know if he said they went directly there or not, or if that's what he meant to say. But yes, the phone didn't travel from the McDonald's directly to the Sky House.
Okay. And Mr. Copeland also told law enforcement on June 10, 2015, that from the McDonald's at the appropriate time that we're talking about and date we're talking about, on the way to the Sky House, he followed the vehicle that contained Jeffrey Williams and Mr. Kelvin Treadwell and others. Do you remember that?
I do.
All right. And Kevin Treadwell's nickname would be OG Bentley. Is that fair to say?
Yes, that's right.
All right. Understanding Mr. Kelvin Treadwell's phone records, does Mr. Treadwell's phone records indicate that he is at or near a tower by Jeffrey Williams' Sky House condominium on June 10, 2015, after being down by the McDonald's area?
Do you mean January 10th, 2015?
What did I say?
June 10th.
No. I'm sorry. Yes, you are correct.
Okay. I do not. I'm referring to my report to refresh my recollection, but I don't recall seeing that Mr. Treadwell's handset pinged off a tower near the Sky House condominiums.
All right. Do you have any, if you're looking, I'll wait for you. I apologize.
All right. Yeah. I'm done.
You stand by your answer?
I stand by my answer.
Okay. Do you have any physical evidence, eyewitness, surveillance video that Mr. Treadwell, Kelvin Treadwell, actually had the killing weapon or the other weapons that were used at the time of the shooting of Donovan Thomas and the other two people, as stated by Mr. Kenneth Copeland on June 10, 2015?
The speculation elements, how the witness would know, phone records would put guns anywhere.
Objection, Your Honor, to the speaking.
Okay, well, he's making a whole lot of objections. So overruled as to relevance, and he's not limited to the phone records. So overruled on that. And what was the other one?
Background evidence,
Sustained.
There's been 10. Okay. Do you remember Mr. Copeland stating that Mr. Treadwell had, or OG Bentley, also known as OG Bentley, had guns that were used in the shooting of Donovan Thomas and the other two people in his car given to him and around the McDonald's 2010 that we're talking about.
Yes, he said that.
Do you have any physical evidence, surveillance evidence, anything to corroborate that those guns were actually in that car at any time or given to Mr. Treadwell?
No.
All right. Now, I want to ask you to educate the jurors if you are aware of what a geofence is. If you're not aware, just say, I have no idea.
Yeah, I'm aware of what geofence is. I'm aware of what a geofence, if we're talking about the variant that Google produces, yes.
If you can you explain to the jurors what is a geofence and how it works and how you use it in your everyday or whenever it's needed in your duties as a district attorney working with law enforcement?
Okay, so basically, Google has compiled over the years the general locations of Wi-Fi signals. And there's a variety of means that they've done this, but it suffices to say that Google has a database that has a set of points that define roughly, or maybe exactly, the boundaries of Wi-Fi signals, maybe cell phone. I mean, this is, I don't work for Google, but this is what I've come to understand. And that based on this, Google, if you have an Android device in particular, with location services turned on, Google can approximate your location because while you may not be connected to a certain Wi-Fi network, your phone can nevertheless see the Wi-Fi network. So if your phone can see a Wi-Fi network, and Google, because like I said, they know where the Wi-Fi networks are generally, then Google has a pretty good idea where your phone might be at a certain time.
In this case, if you know, was a Google fence analysis and search warrant taken out for the phone, targeting the phone of Jeffrey Williams that he had on him on the 10th day of January 2015?
No, no, there was no geofence warrant done for Mr. Williams' phone that I know of.
Let me ask you just to refresh your memory, if it does, refresh your memory.
I know there was a geofence warrant done, but a warrant specific to Mr. Williams' phone, I don't recall that. But if you have something to refresh my memory, maybe that will help.
What number do you have for Jeffrey Williams' cell phone, January 10, 2015, if you don't mind?
Well, there's one that ends in 3904 and one that ends in 9596.
Let me show you, just for purposes of seeing if this refreshes your memory. If it doesn't, tell me. Your Honor, may I approach?
You may.
I'm showing you a document. Do not, may I approach you?
Yes.
Just do me a favor, peek at it. Just tell me if you've seen it before, and if you were involved in it, and if it refreshes your memory, and if it doesn't, tell me that as well. And on the second page, second to last paragraph, you should see that phone number you just articulated.
I have not seen this. I was aware that I know who this investigator is. I was vaguely aware he was working on things like this, but this was not a search warrant that I drafted.
All right. You weren't involved in that part of this investigation?
I recall looking at a warrant that he did for a geofence, but that's not what this is. I know. I don't know. I see what maybe he was trying to do, but I don't recall ever seeing that one.
All right. Your Honor, may I retrieve the document?
You may.
I will not ask you about this then, okay?
Okay.
All right. Let me ask you this. Are you aware in your involvement in this case, whether you, your office, your prosecution team, the whole group, ever tracked the cell phone associated with Kelvin Watts, also known as, do you remember his?
I do remember. I know who Kelvin was.
Shell, same person?
Yeah, I know who he is. Yes.
Okay. Tracking his cell phone historic data related to these shootings in 2015.
Well, for Mr. Watts, the one case that I recall was a shooting of a fatal shooting of a young lady named Tiara Jones. We did have phone tower logs, and that would have been September 2015, but that's the only case I remember.
Did you or your coworkers, the prosecution team, ever analyze the cell phone historic data records for Kenneth Copeland's phone from these shootings in 2014 through 2015?
Well, apart from what we're talking about right here, January 10th, 2015, I don't recall now.
All right. Do you remember on phone records, getting phone records or viewing phone records of a young lady named Alexis Greer, also known either as Max, also known as Dolly? Do you know who I'm talking about?
I do.
All right. And through your investigation, your belief, if you don't know, just say Jeffrey Williams' sister,
Yes.
older sister?
That was my understanding, yes.
All right. Do you remember that at 12:04 a.m. on the 11th day of January 2015, the handset or cell phone associated with Alexis Greer, Max, Dolly Greer, same person, called 911?
I don't recall that. If I ordered her phone records, if it's in there, I'm sure it's true, but I don't remember that specific 911 call. Yeah, I don't remember that.
All right, but let me ask you a different question then. Did you ever get, or the prosecution teams, I'm including everybody, did you, to your knowledge, ever obtain the actual 911 call from a handset associated with Alexis Greer, the actual words?
No, I don't recall anything about this 911 call, so I can't imagine that we obtained it unless this has completely slipped my mind. But no, I don't remember that.
Let me just show you something, see if it refreshes your memory. If it doesn't, just say it does not help, okay?
Okay.
Your Honor, may I approach
You
this
may.
for a minute? It's going to be behind you, Mrs. Spring. I'm going to walk right behind you, okay?
If Brian Steele brings out her paper, we are going to fight. We are fighting. If Brian Steele brings out her paper, I'm crashing out, y'all. I'm crashing out. If he brings out chart paper, it's a wrap, y'all. I'm running in there, and me and Brian Steele are going to fight.
Your Honor, may I just already use as a demonstrative? May I publish?
You may.
For one moment. Mr. Sprinkle, I'm just going to hold this up if that's okay.
If he rolls up with some chart paper, we're going to fight.
Just let you know. Do you see on here, can you read that exhibit number on the bottom for me?
It's exhibit 533YF.
Show that to the jury.
I think that's chart
Jury,
paper.
Your Honor. And I am looking on here specifically at the fourth line there. Do you see that 911 says 104 seconds?
I do, I see that.
And do you see the 1990?
I do.
Do you know if that corresponds to Dolly Greer? I can help you with that too.
Yeah, I might need my memory refreshed. I don't recall.
Oh,
right here.
it's
I'm
not
just gonna
chart
pull
paper.
this back.
Lucky, because I was going to fight him. We were going to fight.
Okay, I see that. Can you just do me a favor, since I'm showing it to you, can you read the exhibit number?
It is 533Y, it's an A.
Okay, and who's the 1990 number associated with?
Dolly Greer.
All right. My question then, does this in any way help you to remember whether you, let me go, I'm gonna yell at you. Does that help you with whether you or your coworkers ever had possession of that 911 call? The actual, I'm talking about, this is 911 and here's a recording.
Right, I don't recall that.
How long are 911 calls kept by APD?
If
If you know.
1 year is what I've always, unless that retention period has changed, 1 year is what I've always known them to keep them.
Okay. I want to ask you, you were asked by the Honorable Mr. Body a couple of questions about listening to or being present at, actually, interviews of Mr. Zachary, also known as Little D.
That's correct.
All right. And there's two Little Ds. Earlier, I was saying Mr. Garlington, he's also Little D. Fair to say?
That's correct.
All right. I'm now talking about Mr. Zachary,
Yes.
also known as another Little D. All right. You were present at the April 13, 2017 recorded interview with Mr. Zachary. Fair to say?
Yes, I was there.
And you were there with other law enforcement, including Detective Thorpe, Detective Dennis, Detective Gaither. I believe if I'm leaving someone out, I'm not trying to.
Yes, that's correct.
You were not present for the August 5, 2015 interview with Mr. Zachary, but you've referenced it today with Mr. Body and you've reviewed that. Fair to say?
That's right.
That's also audio video. Fair?
That's correct.
In the August 5th, 2015 interview that you recorded, that you reviewed, that was recorded that you reviewed, did Mr. Zachary make it clear that Mr. Williams did not know about the killing of Donovan Thomas till afterwards?
From what I remember, yes, he did talk. Yes, the short answer to your question is yes.
In the April 13, 2017 interview with Mr. Zachary, did he say something similar?
I don't recall how much detail we went into him on that, but yes, from what I remember, he said the same thing. He at no point implicated Mr. Williams.
I'm going to ask you the same exact question, the same dates. We'll take them one at a time if it's okay with you. Start with the August 5, 2015 recording that you reviewed first. The tour bus shooting of a gentleman, a phenomenal artist, Dwayne Carter, also known as Lil Wayne. You know who I'm talking about?
I do.
All right, that's April 26, 2015 date, the shooting of the tour bus?
Yes, yeah, April 2015. Yes, that's correct.
Okay. And is it fair to say that Mr. Zachary, at the August 5th, 2015 interview, you were not present for it, but you reviewed, said that Mr. Williams had no involvement in that whatsoever, and Lil Wayne, Jeffrey Williams idolizes Lil Wayne?
I don't remember, since I wasn't working on that case, but so I don't remember exactly what he said, but I do remember him mentioning it, and he did not mention that Mr. Williams was involved.
Same question for you, August or April 13, 2017. If it came up, tell the ladies and gentlemen, jury, Mr. Zachary again stated Mr. Williams was not involved in the shooting bus of that tour bus.
That I don't recall it coming up during that interview.
Okay. Let me ask you this. Do you remember Mr. Zachary stating that Mr. Copeland was responsible for shooting TIG? Do you know what TIG Studios is? You know what I'm talking about?
Metropolitan Parkway?
Yeah, 675?
Mm-hmm.
Okay. Do you remember Mr. Zachary explaining that Mr. Copeland fired bullets into that establishment?
Objection, Your Honor, that's not something.
Okay,
Facts
need,
not in evidence.
I need you to
In-
speak up a little bit.
Objection, facts not in evidence.
It's in the recording that was played for the jury, that was reviewed by Mr. Sprinkle, and Mr. Abadi asked Mr. Sprinkle about that same interview.
It's not my recollection of how.
Sustained.
Yeah.
Do you recall Mr. Zachary stating that Mr. Copeland and Tay, do you know who Tay is? Tay, T-A-Y. I'm spelling T-A-Y.
Which Tay?
Threat.
No, I don't recall this.
You don't remember?
I do not remember this.
Do you remember Mr. Zachary stating that Mr. Copeland and another person were responsible for shooting Rich Homie Kwan's father at the barbershop? Different barbershop, not the January 10th, 2015.
No, I don't remember that.
Okay. All right, let's talk about all the work that you talked about here and your studies, and I'm not mentioning everything, but your interviews, reviewing interviews, cell phone plotting, videos, all your work, okay? Then in some point, do you remember the date in 2018 you interviewed Mr. Kelvin Treadwell, O.J. Bentley? Do you remember that?
Which day was this again?
2018.
Oh, right. Yes, I do remember that. Yes, that was another matter, but yeah, I do remember it.
And do you remember stating that you can't understand why people think that Thug, I call him Jeffrey, had something to do with the killing of Nut, I call him Mr. Thomas? That doesn't make sense? That's the thing that always confused me about this case, because all these rumors started immediately that Young Thug had something to do with it. But yeah, then Young Thug put a picture of him on Instagram, Mr. Thomas. So I'm looking at these people saying, oh, you and Little Woody had something to do with it. The more investigated the case, the more I've investigated the case, I just don't, near as I could tell, Young Thug and Birdman were friends with Mr. Thomas or Nut. So I don't know why people say that he was involved.
Well, I recorded the interview, so I'm assuming that's a verbatim quote. I don't have everything I said during that interview memorized, but I'm assuming that, like I said, since you're reading from a transcript, that yeah, I said that.
Okay. All right. The jurors may not, they're getting insight now into how jail phones work, jail recordings work, things like that. But I'd like you to explain to him, if you know, people who visit people at the jail, 2015, okay? If you know, can you yourself, you're a lawyer, can you actually physically go into the jail, you know, with permission, everything's lawful, it's ethical, I'm not suggesting anything, and actually get up on a floor and meet with someone who, God forbid's, in custody? Have you done that before?
At the Fulton County Jail?
Fulton County Jail, thank you.
No, I've never done it. Now, I don't have clients, I'm not a defense attorney, so, but I can tell you as a prosecutor, I've met with people at the jail, but it's never been in the pods. It's in the library.
Sure. That's what I'm saying. Just get access to the jail and meet with a human being who's, God forbid, incarcerated. You've done that before?
I've done that before.
Do you know whether the jail in 2015 now had surveillance for people walking in and out of the jail? I'm talking about the common area, walking in and out of jail, if you know.
I do not know, because I've never, or I don't recall ever seeing footage, not on this matter or any other matter, from that area. It would seem logical that they would, but I can't say that I have personal knowledge that they did.
How about when a person, we could use you, so your personal knowledge, in 2015, if this happened to you, going into the Fulton County Jail to see somebody, to see somebody in custody, have to sign in any paperwork, show your ID?
Yes, that you have to do.
All right. And to your knowledge, is that saved by law enforcement? The jail?
From what I remember, It was the sort of paper that it would create it was like a carbon paper, the kind of paper that it would make a copy of it when you write on it. So they'd give you a copy and then they retain the copy with the impression left from the original. Now, as to what their record keeping practices are at the Fulton County Sheriff's Office, that I don't know. All I know is they had it set up so they would keep a copy. I can say that, but I don't know what their record retention was after that.
And for people who may not know, who's in charge of, who is constitutionally in charge of running the Fulton County Jail?
I'm going to object to relevance at this point.
Sustained.
All right. Your Honor, may I have just a moment?
Sure.
Do you know whether the sheriff officials ever log? Do you know what Odyssey is?
I do.
Just tell the jurors what Odyssey is.
It's a database. It's just a piece of software made by a company called Tyler Technologies. I believe they're out of Texas. And it's used here by the staff in the Fulton County Justice System, staff at the DA's office, the courts, and the jail. And it's basically just all of the data, all the cases in the system are maintained in this Odyssey database. The DA's office keeps their records, part of their records anyway, in the Odyssey database, and the jail keeps their records in this database.
Does the jail on Odyssey, you can access that?
I'm going to object to relevance again.
Sustained, as far as I can tell.
Okay. People visiting people in the jail, is that also on Odyssey?
Yeah.
I'm going to object to relevance.
It'll come up with the witness in the future.
All right, I'll give you some latitude.
So yes, there is in the what's called the jail module. When you click on a booking number, there will be a tab called contacts, and I've seen entries made. Now, reason why I'm going to hesitate a little bit here is, and I can't remember exactly when, but I from what I remember, there have been times when I knew a visit was made and it didn't get logged. Because everything in Odyssey has to be entered by a human. Well, maybe not everything, but something like contacts would have to be entered by a human. So the data is only as good as the people are tasked with entering it. So yes, I can tell you this. There is in the jail module that the sheriff's office maintains, there is an area for them to enter data regarding the date and time of a contact and who came to contact that person. But I don't know that every single contact they're diligent about logging every single one, or if there are variants of contacts that they don't log, you would have to ask somebody from the sheriff's office about that.
Mr. Sprinkle, as always, thank you so much. Your Honor, I don't have any other questions. Thank you.
All right, are there other defense counsel with questions for this witness? Is there redirect? Oh, you do. I'm sorry. Go ahead.
House is in the building.
ADA, Michael Sprinkle. Good afternoon, sir.
Good afternoon. How are you?
I'm doing well, thank you. I have a few questions for you. When you testified some days and weeks ago, you were giving the jury some background in terms of how long you've been with the district attorney's office, right?
Yes.
And you talked about some of the various roles that you've had in the district attorney's office. You've been in the complaint room, right?
That's right.
And in recent years, I think you said from the last several years, you've had a dual role as both a prosecutor and an investigator, right?
Well, so I haven't been given the title of investigator. You know, I'm not post-certified, so calling me an investigator is more of I guess you can call me that informally, just because because of what I'm tasked with doing for the DA's office. I necessarily am investigating things, but I'm not, as far as my employment is concerned, I'm not on paper an investigator. I'm just a prosecutor, an attorney.
Understood. So you're a prosecutor, but some of your tasks in the prosecutor's office involves some investigations.
That's right.
Fair enough. Okay. Now, you testified in days and weeks ago that Sometimes a detective, a law enforcement officer, when they make an initial arrest, sometimes they'll hand a file over to the prosecutor's office, to the district attorney's office, and you testified that sometimes after they make an arrest, they feel their work is complete. You remember saying that?
I remember saying that, yes.
Okay. In other words, the detective believes that after they make the arrest, based on your statement, that their file is done, they've gotten an arrest, and they'll hand it over to you guys.
I've definitely seen that, yes.
Okay. And when your office gets it, it sounds like either an investigator who's on, who has that official term investigator, or someone like yourself, a prosecutor who informally has the role of investigations, will pick up the file, blow it off, and continue some investigations in the particular file. Is that fair?
That's fair.
Okay. Now, some of the things that you would expect to see when you get a file from the police department, from law enforcement, you would expect to see police statements from witnesses, right?
Yes.
A lot of times you might want to see video surveillance if it's there, if it's available, right?
That's right.
Sometimes text messages, phone records, things of that nature.
That's right.
When it's not there, you'll then.
I'm going to interrupt. I'm the objector to ask and answer.
Sustained.
So when those items are not there, you get the file, or someone in your stead will get the file and continue the work of investigations. Now, in this particular case, I want to talk to you about a specific time frame around April 26 or so, 2019, an alleged armed robbery that is supposed to have occurred at 741 Morosco Drive Northeast, 12:39 a.m. in the morning. Do you know anything about a case involving an armed robbery of supposedly involving Mr. Marquavius Huey concerning that particular time frame?
I don't have that exact date and time memorized. I'm familiar with Mr. Huey. That address sounds familiar, but I don't remember the facts of the case.
Okay. So that being said, without having that memory, so you don't recall you specifically doing any investigations concerning requesting any potential video surveillance of any VIC cameras in that area of 741 Morosco Drive?
No, I'm afraid I don't, unless you have something to refresh my memory. I don't.
I'm not saying you do, or it's not a trick question.
Yeah, no, I don't.
You were involved. I'm asking you if you were. Okay.
Yeah, no, I don't have any memory of that.
Okay. Are you familiar with Google image search capacity?
Yes, when you upload an image into Google and it tries to find like images.
Yes. To your knowledge, well, you didn't take any actions or do any actions on the alleged armed robbery from April 26, 2019. I think you've already indicated that. Is that correct?
Well, I don't want to say I didn't. I just can't. I just don't remember. Some of those dates and the locations sound familiar, but I also have dealt with hundreds of cases, so I could be getting cases mixed up. If just a date and time and address isn't enough to go on. So I just don't remember.
Okay. And so as we sit here today, you can't tell the jury that you specifically, you yourself, were involved with any investigation, to your knowledge, for an April 26, 2019 alleged armed robbery at 741 Morosco Drive. Is that fair?
Sustained.
Okay. Nothing further. Thank you.
All right. Anybody else?
All right.
Redirect.
Good job.
Mr. Sprinkle, back in 2019, were you assigned to the major case division that handles
Use the microphone.
And particular homicides only? Back in 2019, around the date in which Mr. Matthews just asked you about, were you assigned specifically to the major case division that handled homicides and vehicular homicides, or cases involving death?
Yes.
Okay. And in your time working in the capacity that you've described to us now on 1, 2, 3 occasions, have you had cases with phone records and no video surveillance?
Yes.
And Mr. Steele asked you a number of questions concerning video surveillance and the McDonald's. Do you remember all those questions?
Yes.
Do you have any idea if the video cameras at that McDonald's were even operable back in January of 2015?
I don't know.
And Mr. Steele asked you on cross about what Mr. Zachary and Mr. Copeland had indicated about who did or didn't kill Donovan Thomas. Do you remember him asking about that?
Yes.
Can you tell the jurors who did Mr. Zachary and Mr. Copeland both say were involved in the killing of Donovan Thomas? Do you recall?
Yes.
Can you tell the jury?
Diamante Kendrick, Shannon Stillwell, Demise McMullen, and Justin Cobb.
Your Honor, I have no further questions.
All right, any recross?
Well, if they said that, then what are we doing?
Anybody? All right, thank you, Mr. Sprinkle. You are excused. Call your next witness.
Will we see him again ever?
Your Honor,
That's the
state
question.
calls Detective Underwood to the stand.
Oh,
Okay.
not another detective. Oh, my sweet Caroline. Why another detective? Why?
State calls Kim Underwood to the stand.
Oh, okay, so she's with him. I think she was with her witness. Good. Praise God. I'm sorry. She looks so much like Adrian Love.
That's when you give me the truth, whole truth, nothing but the truth.
I do.
Kimberly Underwood, Kimberly, Underwood.
And where are you employed?
City of Atlanta Police Department.
And what do you do for the City of Atlanta Police Department?
I'm actually a recaptured employee, meaning that I retired after 31 years of service. And they called me back, or they let me come back as a contractor with the gang unit because I spent the majority of my career in the gang unit.
Okay. And how long have you been back under the recapture program?
I'm in my second year, so almost 2 years.
All right. And tell the jury a little about what you do now, back in the recapture program, and then when you were at APD before retirement.
Okay, now they brought me back because I'm a senior investigator, I'm an instructor. They wanted me to really kind of mentor the younger investigators. I also teach at the police academy, so the recruits have to take a 4-hour class from me before they hit the streets about gang identification, gang awareness, gang investigations, and so forth. I also assist background and recruitment. We have to screen our applicants because we do have gang members that try to get employment, try to infiltrate the Atlanta Police Department. So I assist with the screening of them. Whenever an investigator have like a warrant or paperwork that they're not sure about, they'll bring to me and I can proofread it or kind of help them with their cases. Before that, like I said, I spent 14 years before I retired in the gang unit. Prior to that, I was in licensing permits as an investigator. I was Zone 3 CID as an investigator. I did most of my career in Zone 3. So I've had, like I said, 31 years of experience with the police department.
And do you hold any degrees or certifications pertaining to law enforcement?
Yes, I have a degree from Columbia Southern University in criminal justice administration. I got my associates in criminal justice from Georgia Military College. I have over 2,000 hours in law enforcement training, and I still go to training even though I'm retired. I have over 1,000 hours maybe in well, maybe hundreds of hours in gang training, because even though I'm retired, I still go to trainings and meetings and stuff like that to stay up on the gang trends.
And are you a member of any law enforcement organizations?
Yes, I'm a member of Georgia, Georgia Investigators Association, Georgia Gang Investigation Association.
Is that short GGIA?
Yes.
And you spoke briefly about presentations. Have you ever made presentations on law enforcement topics to any professional organizations?
Yes, back when I first started teaching, which was back in 2011, I used to do a lot of the Atlanta Public Schools because I was a resource officer as well at Atlanta Public Schools. So I would teach the administrators on what to look for when it came to gangs in schools. I would do block captains in neighborhoods. I would go to City Hall and the block captains would come in and I would kind of give them a gang presentation on what to look for in their neighborhoods. I've done Grady EMS. Whenever they go to calls, they like to know what they're getting into when they're dealing with victims, whether they're gang members or whether there's going to be like retaliation while they're trying to triage a patient or whatever. I've done the military. I've done Atlanta Fire Department. They also want classes about gangs because they're EMTs as well. They have to do first, they're first responders, so they like to know what they're looking for as well. Fire cadets. It's a list of different, groups that I've talked to about gangs.
And if you could tell the jury about, I think you said you had about over 1,000 hours of.
Maybe close to 1,000 hours. It's over 100. I know it's hundreds of hours. Again, I can't tell you exactly. I did probably submit my training from like at my daughter maybe, but it's hundreds of hours of gang training.
Give just a synopsis of some of the courses that you take as a part of that 100 hours of training, over hundreds of hours of training.
Well, I started out, when I first started the gang unit, I had no idea about gangs, even though I grew up here in the city of Atlanta where we really didn't have gangs, I say. But I started out in California. I went to California, did some gang training. It was mostly like gang awareness.
So I need you to slow down for me just a little.
I'm sorry.
Slow down. Okay.
Gang awareness, gang identification, interviews and interrogations of gang members, courtroom testimony, training. So anything that was pretty much dealing with gangs, I have been trained or either have trained people.
Outside of formal training, have you had the occasion to, in your personal experience as a investigator, speak with, interview individuals who identify as part of gangs?
Yes, pretty much my whole career as a gang investigator, I've done that.
And you talked about some of your trainings, talking about the national gang trends. Are those some of the topics that you learned as part of your gang training?
Yes.
Have you had the occasion to study gang trends here in Georgia?
Yes.
Over your 14 years working in the gang unit at APD, can you provide an estimate of how many gangs you have investigated?
Whenever I started the gang unit, we had a bunch of hybrids, like non-traditional gangs. So counting those, it was over 100.
And over the course of 14 years, how many times have you come in contact with individuals who identify as gang members or who are identified as gang members?
I would come in contact with them daily because that was a part of my, duties as a gang investigator. But like I said, I did work for the Atlanta Public School System where I came in contact with them there as well.
Can you even give a number of approximately how many gang members you have investigated or interviewed?
Over the years, I would say hundreds.
And as a gang investigator, did you have your own caseload?
I did. I have had caseloads, but what I did like about working in the gang unit that we did joint investigations. So most of our larger investigations are either, like the smash and grab burglaries or robberies or whatever, we would work as a team or as a group on cases.
Have you ever been a part of sharing information and intelligence with law enforcement other law enforcement agencies?
Yes, we actually, like I said, the GGIA meetings, we meet with other agencies from all over the state of Georgia. I've gone to Cobb and assisted on cases, Clayton, I've testified in DeKalb to assist them. So yes, we do information sharing. I actually have a meeting next week with the Atlanta Public Schools and all the other schools in the metro. We get together and share information about gang trends.
And do you stay current on gang trends, including rivalries, alliances, customs, and habits?
Yes.
In the experience and training that you've just described, have you developed a familiarity with criminal street gangs, their activities, customs, and behaviors, both across the United States and Georgia?
Yes.
Have you received any training on how gangs use music to promote allegiances within their gang?
Yes.
I'm going to object. There's been no downward finding on that. I'll object to that. No question.
That's overruled at this point.
Have you received any training on how gangs use music to promote violence?
Yes.
What about how gangs use music to promote fear in other gangs?
Yes.
What about how gangs use music to promote cohesiveness within their gang?
Yes.
And what about how gang members use music to send messages to rival gangs?
Yes.
Have you ever been qualified as a gang expert here in the state of Georgia?
Yes, in Fulton County Superior in federal court, because I left out the part about me being a task force officer for 6 years while I was doing my time at the gang unit from 2013 to 2020. Federal court, DeKalb County Superior Court.
And you said you were a federal task officer for what agency?
For ATF.
And what were some of your responsibilities as an ATF task officer when you were assigned to that unit?
My responsibilities over there was to mainly focus on the VROs, the violent repeat offenders, who, when I went over there, I really didn't want to go over there, but when I went over there, I was told by my superiors that I could still work gang. I had been in gangs and I wanted to do gangs. So when I went to ATF, I was told that I can actually focus on the violent gang members. So when I was at ATF, that's what I did. All of my suspects that I came across were violent repeat offender that were actually gang members. We kept up with the NIBIN, where I actually went to training to learn about NIBIN and how we were able to match crime scenes with just the casings or firearms that we recovered. The caseloads that we did get were kind of like adopted cases from the police departments around the metro that we worked.
Your Honor, this time the state would like to tender Investigator Kim Underwood as an expert in criminal street gangs and criminal gang activity.
You may, yes.
Okay, this is going to be interesting. Real quick, double check, make sure my audio is working. This is going to be interesting. What do y'all think? What are y'all thinking? All right. I think she definitely knows what she's doing, whether you like her or not. I do think she has more credentials than Dennis did. I think this is going to be problematic because where did they get her from and why did they have her so quickly? Less than 24 hours. And why did you not have her yesterday instead of Dennis? Talking about I listen to rap music and watch and read Word Up magazine. That's crazy work. That's nasty work. So I'm glad they got somebody. At least she sounds like she knows what she's talking about. I think it's still going to be problematic because there's still a lot of questions, but I want to hear what they're saying. Now, I wonder why Brian Steele wanted to come up to the bench, because I think he's the only one that said anything about her. She does have real credentials, which I think is excellent, but why didn't they have her yesterday? Like, well, why did they not have her? Like, she seems like I mean, I think we would have all had a different opinion if she had been up there yesterday versus Dennis. I don't think Dennis added, well, we know Dennis didn't add anything to the equation. He subtracted a whole bunch. So where did they get her from? And why did they not have her yesterday? That's just my question. I'm waiting for I don't think they're going to be on there long because allegedly they're supposed to end at 4 o'clock today. So I don't know how long she's going to be there, but I'm looking. Yeah, this is going to be interesting. I think, yeah, I want to see how this works out. Because again, I think she knows what she's talking about. I'm gonna give her a little bit of grace right there. Dennis referred to her? Really? I don't remember that part. But Dennis, I think everything kind of just went out of my mind when the stuff hit the fan yesterday. But maybe he did mention her yesterday. Yeah, that's gonna be, if that's her narrative, then she's gonna have a problem if all rap just promotes violence. I think that's gonna be interesting. But you also have to, in my opinion, you have to cross the bridge of promoting violence versus talking about violence. So there's a difference, in my opinion. So just because you talk about it doesn't mean you're promoting it. You can be very well just discussing it as, again, social commentary. Or yeah, I don't know if that one's gonna work, but we'll see. Yeah, she's gonna end up. I think that's what's gonna happen. She's gonna end up accepting the witness, tell her to come back on Monday, dismiss the jury, and go over some horse trading. I know Mo doesn't like when I say that. She's gonna go over some horse trading for the last 45 minutes or so. That's probably what's gonna happen. What did Mo say right here? So Dennis will still be out. Let them proceed with the substitute. Then it will mean Dennis was testifying in the capacity of an officer and not as an expert. Right. So are they gonna be able to bring him back as an officer? I don't think they should even worry about Dennis, but well, I do want to shout out Simone, because it's clear she's been sitting with that witness all morning. She's been with that young lady all morning, uh, getting her dialed in. Now, granted, her questions sound like she's reading them, but I'm not going to worry about that. It does seem like Simone has been with this woman all morning, which I think is good, because that's how she's able to answer questions, sound complete, full thoughts, not talking about Word Up magazine and watching Yo MTV Raps. So I'll give her shouts for that. No shade taken from there. But that's what they should have been doing. And also notice that the woman came right in. There was no waiting, there's no sitting around twiddling your thumbs, which I think is the right thing to do. Yeah, I don't think anything's wrong with credentials at all. Well, Lord knows we didn't have any credentials yesterday. My dude was showing his Blockbuster card, like, "Hey, this is my frequent punch card at Blockbuster. I'm an expert." What? Get out of here with that craziness. What did Monica Mo Justice? Yes. But are they going to try to bring him back, though? That's what I hope they don't. Is that what they're going to do? Are they going to bring him back? I thought she said no more of him at all. She had to be on the witness list already. Okay. All right. Well, there we go. Then that makes me ask the question even more. With her, if we just look at her and Dennis's credentials, if they had used Dennis as a officer yesterday versus what he was, a gang expert, they said, remember, they went through all those hoops to get him to be certified as a gang expert. Talking about, again, I watched Yo MTV Raps and Saturday Night Rap Battles. They shouldn't have done that. They should have said, this is Officer Dennis, and now we got investigator gang lady expert coming in. To me, they put themselves in that pickle. Hey, thank you so much, Amethyst, for the wonderful $5 super. What she said, they had to form a GoFundMe to raise money for her consultancy fee. That's messed up. Shame on you, Amethyst Angel. I'm going to put you in 0-second timeout. Yes, they had to get, man, you know they did. You know they did. They had to go say, look, this lady got a little bit too much. That lady got a little bit too much credentials for me. Yeah, that's all I'm saying. Like, if she was on there yesterday, why didn't they just have her be the gang expert? Why did they go through all those hoops and end up failing, by the way? Failing after all of that, the dude gets up there and has diarrhea of the mouth, says the wrong thing, and ruins his whole case. But why not just have him just be an officer? I'm sure he could have still talked about he could have still talked about some of the nuances, but as an officer, not as a gang expert. Because I know Fab Five Freddy. I mean, that's just craziness. But I'm talking too fast, Mo. I don't know what I just said. What did I say? Was it profound? I hope it was. Let me rewind the tape. Yo, you got that blockbuster credentials, man. I can show you my Netflix, man. I've been watching all the gang movies. Gangs in New York, Colors, Boys in the Hood, Menace to Society, Set It Off. And then I even go to Honor Among Thieves and Ocean's 11. I got all the gang stuff. Oh, I do have the witness list. Thank you so much. Let me look. That's why I have you around, Mo. Yeah, but she definitely seems like she knows what she's saying, what she's about a little bit more than Brother Man was yesterday, because he was struggling. I have it somewhere. I just don't know where. Okay, let's jump over here very quickly. Okay, I'm looking real quick to find that witness list. I am doing a terrible job at my having information ready. All right, let's see where we are. Let's see where we are. All right, looking here, looking here. Look at this right here. Look at this right here. Where is my witness list? I'm also getting distracted. Twitter is very distracting. Okay, I also ran into a young lady that is protesting outside of Fulton County Courthouse. Shout out to her. Really? I think Brian Steele did an excellent job of pointing out that he's cast so much doubt. Brian Steele has done an excellent job, and I just think the defense in general has done a great job of casting doubt over the inner workings of this case, to the point that, I mean, I don't see how the jury is going to feel not have some reasonable doubt, just some reasonable modicum of doubt. Here we go. They're back. Let's see what they're talking about. Let's go. She looked like she got her pure hand slapped. She is not happy. All right, let's see what happens. Let's see what happens. Okay, so make sure it's not me. They have not turned on their microphone yet. I think Judge Whitaker's waiting to sit down and start it. Ed Love and Dr. Dre. Come on, man.
Your Honor, may we approach?
No.
Sorry.
Are you for real? That is hilarious, man. They literally just this case is ridiculous, man. This case has got to be the most down bad thing ever in the history of life. They literally just come back. I think that's a great question. I don't think we're gonna find out today, clearly, because it's 3:00. I think we're gonna find out probably on Monday, maybe even Tuesday. But I think it's gonna probably be Adams, but I'm not clearly not sure of that, but just taking a stab. Man, remember Tuesday they got through all those witnesses and we're like, oh man, they're gonna be churning them out, churning them out. Now look at them. Slow dragging, slow moving.
As a part of the gang unit with APD, were you familiar with a gang YSL?
Yes.
And does YSL go by any specific names?
Young Slime Life. I've heard Young Stoner Life.
Okay. And how are you familiar with Young Slime Life?
I'm familiar with YSL. They what happened was I've been in, like I said, the gang unit since 2009.
Your Honor, I'm going to object to broadness of this question.
All right. Let me ask you this. Was there an iteration of YSL prior to the name YSL?
Yes.
And what was that gang called?
Rock Crew.
And were you familiar with Rock Crew?
Yes.
And how were you familiar with Rock Crew?
From gang investigations while I was an investigator in the gang unit.
And around what year or time was there a transition from Rock Crew into YSL?
Apologize. I'm going to object cumulative.
Sustained.
Okay. Let me ask you, are you familiar with another gang, YFN If Gang?
I am.
And how are you familiar with that gang?
They are Inglewood Family Bloods. YFN is a subset of the Inglewood Family Bloods.
And based on your knowledge of gangs, did those two gangs have a rivalry?
Yes.
Jack, that conveyed 704. No jurors can figure that out. We don't need expert testimony.
Overruled. And can you please use your mic? It'll make it easier. Sorry. Thank you. Sorry. Wish it weren't the case in here that this sounds so complicated, but it is.
And just approximately how long has that rivalry been in place?
Asked and answered cumulative.
Sustained.
Have you heard of the term gang war?
Yes.
And how have you heard of that term gang war?
Objection, relevance, and self-explanatory.
Sustained. I mean, not
Wow.
relevance, but it is self-explanatory.
As part of the gang unit, were you familiar with the facts of the Donovan Thomas murder and the retaliatory shooting surrounding Donovan Thomas's murder?
Yes.
And how were you familiar with the Donovan Thomas murder and the retaliatory shootings surrounding Donovan Thomas's murder?
I was assigned to ATF as a task force officer. So operation planners is actually a federal name that we gave the investigation. So whenever Donovan Thomas was murdered, the gang war ensued and several shootings around the city. So APD and ATF came together to investigate those shootings and to try to stop the gang war.
And were you involved in any of those investigations?
Yes.
How were you involved in those investigations?
Like I said, I was a task force officer with ATF. What happened was we all got together, the gang unit at APD and special agents at ATF. We all got together and we would meet like weekly about the shootings because they were rapid and happening so much that we had to do something. So we all used to get together and we kind of divided up the cases between different officers, investigators, agents, or whatever to, like I said, try to stop the gang war.
And did you have any particular focus for you as a part of that kind of collaborative effort?
Yes, because I was a federal agent. I was tasked with handling anybody that was a federal target, meaning that if they could go to federal court opposed to state court, I was involved in those cases because I was a federal task force officer. So I could prosecute a case federally when my partners over at APD couldn't because they were not task force officers.
And as a federal task force officer, did you find that you were involved with more of the YSL side of the gang war or the YFN side of the gang war?
Sustained.
Okay. What were the two entities that were engaged in this gang war?
Answer cumulative.
Sustained.
In preparation for your testimony today, have you had the opportunity to review some of the reports that came in back in 2015?
Yes.
Have you also had an opportunity to review some of the operation planners report that summarized some of the incidents that occurred in 2015?
Yes.
Have you also had the occasion to review a video from Magic City?
Yes.
And we'll speak about this more, but have you reviewed any type of music in this case in order for your preparation for your testimony today?
Yes.
Based on your review of the reports and your knowledge of the events in 2015, in your opinion, was there a gang war going on in the city of Atlanta?
I'm clearly going to object to cumulative 704B, and this is the fourth gang expert that the state has called the same exact events.
All right, well, one of them was, all of yesterday's testimony from that person was excluded, so.
I didn't mean to interrupt the honorable court. Actually, that person testified 3 previous times.
I know, and that was not excluded. But I would imagine, why don't y'all approach?
Oh my gosh. Okay. All right, here's an idea. Here's a theory. Everybody put your tinfoil hats on. Make sure they're nice and secure. Okay, what if because Judge Whitaker, what if the state is fumbling and bumbling and so that they can point out and say it was Judge Whitaker that sped them up by asking them to streamline their case? Just a thought. So let's look at Dennis. Dennis was the fake gang expert, but he was a police officer and he did do investigation closely knit to this gang as well. So what if this gang expert, the true expert, she was on that long list. Remember the long list with like 150, 200 witnesses? And what if they just scratched her off and said, oh, we got Dennis. Dennis will do a good job. And we'll bring Dennis on. So they scratched her off of the list. Just an idea. So they scratched Dennis off of the list only to bring, scratch the woman off the list only to bring Dennis on and think they're going to be sunshine and rainbows, only to realize Dennis fumbles the ball, puts his foot in his mouth, ruins the case yesterday. And so they got to go and call real quick and say, hey, we need you to come back in. Don't do that, please. We need you to come in real quick and help fix it. Since she was already on the list, she's a witness. So she just was kind of redacted, kind of like whited out, but crossed out with a pencil or something like that. So now they're here. Now I'm wondering if that's because they're stumbling and fumbling now. And why? Because Judge Whitaker put all that pressure on us. Judge Whitaker made us move fast. Judge Whitaker, bye, baby. Just a thought. Love you too, baby. And it's been fantabulous. Bye, baby. All right, so we'll see what happens. Just something to think about. Oh yeah, and I got that idea from Monica. I gotta give Monica Mo
Your Honor,
Justice a
believe me,
shout
I
out.
failed to do this, or if I did, I'll just do it again. Your Honor, this time today would like to tender Investigator Underwood as an expert in criminal street gang activities, and an understanding of gang culture and how music can be a part of gang culture.
All right, she is so qualified and may testify as such.
Thank you.
I maintain my previous objection.
Yes, of course.
Of course, of course.
Now, I want to go specifically, Detective Underwood, to the week leading up to Donovan Thomas's death. Okay. And from the review of the records, do you recall Donovan Thomas being killed on January 10th, 2015?
Yes.
Right. I want to go back to that week, earlier in that week. Are you aware of, through your own personal knowledge of what was occurring in 2015, a fight at Club Crucial?
Yes.
Oh gosh. Crucial.
And who was involved in that fight in Club Crucial?
Kenneth Copeland and Kevin Watts.
What does that sound?
After that fight at Club Crucial, did you become, and I'm going to ask just very specifically, about a shooting outside of Club Crucial?
Yes.
Right. And on that same day, Mr. Arnold being stopped by police along with another individual?
Yes.
After that incident on January 6th, were you aware of any other incidents that occurred that week of 2015 before Donovan Thomas's murder, or the killing of Donovan Thomas?
I can't think of offhand except for think over at maybe at a what they call it, it was a gambling spot in Zone 3 where a windshield was damaged, and words were, I guess, exchanged or had about the windshield being damaged between rival gang members.
What about a shooting at TIG Studios?
Yes.
Now, after the death of Donovan Thomas Jr., in your opinion, based upon your understanding of what occurred in 2015 from reports and your own parts of your investigation, after the shooting of Donovan Thomas, was there a main target of individuals associated with YFN or If Gang?
I don't understand the question.
Sure, sorry. Did they have someone that they were targeting, individuals who were associated with If Gang and YFN after Donovan Thomas's murder?
Vague with they, and also
Sustained.
Sure. After Donovan Thomas's murder, was there an individual who was targeted?
Yes.
God bless you.
speculation, calls for speculation of the intent of others.
Sustained, you may rephrase.
Sure. Based on, let me ask you this. After the death of Donovan Thomas Jr., did law enforcement receive information about shootings at several homes after Donovan Thomas's murder?
Yes, we received several 911 calls, and incident reports were made at these locations.
Okay. And in evaluating and looking at those locations, were those locations associated with a particular individual?
Yes.
Who?
Kenneth Copeland.
And the homes that were targeted, that were in relation with Kenneth Copeland, do you know where those homes were located?
One was on Van Ira. I think I remember Deshaun Copeland's girlfriend. That was her mother's house. I remember his sister's house was targeted on Oakland over in Zone 4. And his brother's house was targeted on Hendricks Drive in Zone 3.
Okay. And did those particular shootings happen within the first few days after Donovan Thomas was killed.
Yes.
Now, in January of 2015, were there any shootings that came into the Atlanta Police Department in which the locations involved individuals who were associated with YFN?
Yes.
What were those locations?
I remember Rayshawn Bennett, AKA Lucci's mother's home being shot over on Hill Street in Zone 3.
I'm going to object to previous testimony already given. It's cumulative.
Okay, go ahead and get to whatever point there is.
How many times was her home shot?
Twice.
Okay.
I'm going to ask her about the first time. Were there individuals from YFN who were at the location when police, because that's going to form what I have to ask next.
Same objection.
Your Honor, this is part of what occurred yesterday.
Go ahead. I'll give you some latitude.
Thank you. The first time her home was shot, were there individuals at her home when police arrived?
Yes.
Yes, she did
Who
say
were those
YSN.
individuals?
Kelvin Watts, Jermaine Hardiman, and Jamal Ward. No, Jamal, I can't remember his last name.
Does the name Jamal Bynes sound familiar?
That sounds very familiar.
And were those individuals associated with any gang?
Yes, they were Inglewood family blood members.
And the second shooting of Miss Rayshawn Bennett's mother's house, was that on 1/26/2015?
Yes.
Okay. On that same day, on 1/26/2015, did you become aware of an incident in which Kenneth Copeland was shot at on the highway?
Your Honor, I'm just going to object to hearsay. Unless
Overruled.
Based on your review of the reports, did you become aware, whether it's part of the reports or your own
Yes.
knowledge of the
'cause
investigation?
At the time, we were actually keeping up with and collecting every incident that happened between the two gangs.
And so did you come aware of an incident in which Kenneth Copeland was shot on the highway on January 26, 2015?
He wasn't shot. I think he was shot at. Him and his brother they were fired upon while they was driving down the expressway.
Thank you for that clarification. Did you know that case number, was that for case number, APD case number 150260124?
That sounds correct.
All right. Now, did you also have the occasion to review APD incident case number 150262672?
Yes.
And was that the incident we just talked about when Lucy's mother's house was shot up?
Yes.
And did you also have the occasion to know of and look at APD case number 150262801, the shooting of Trevante Turner?
Yes.
And the location 198 Stanhope Circle, are you familiar with that location?
Yes.
How are you familiar with that location?
During the investigation, I found that whenever I prosecuted Jermaine Hardiman on the federal side, that was his residence.
And Trevante Turner, from your investigation, was he associated with a gang?
Yes, he was a 9 Trey Blood, but he hung out with his bestie, Kenneth Copeland, who was YSL.
All right. And in looking at those three case numbers, 15-026-0124, then 15-026-2672, and 15-026-2801.
Oh man, here we
Would the
go.
0124 incident be the first incident?
I think so. They in chronological, if they're chronological, yes.
All right. And I'm going to put those numbers up because I know it's probably hard for you to remember what I just.
Oh man, here we go again. Lord have mercy. Oh my gosh. Oh my goodness. Chart paper has entered the chat, ladies and gentlemen. Oh my gosh. Now, boys and girls, we're going to work on our strong consonant sounds. And what number do we have here, boys and girls? This is a 5-digit number. What do we have here, ladies and gentlemen? That's right. This is what I cannot believe she's literally writing this out. I am so embarrassed for her, for the jurors, for everybody. Y'all could not put this on. You knew you were going to do this.
Okay, so I think if you permission for investigator Underwood to stand.
Yes, of course.
What's the merciful?
So I believe you just
Lord,
testified
please
that
be
0124,
merciful and forgive us.
there's
Please
another
forgive us for
when
being dumb.
Mr. Copeland was shot and on the house.
Is she doing picture pages again?
Associated with YSL. Yes.
Oh my goodness.
Then on 15-026-2672 is that when Lucci's mother's home was shot. Yes. And Lucci, what, if any, gang was he associated with? YSL and Underwood then. And then 15-026-2801. You said the location was in YSL, near YSL member's home? Yes.
A struggle. This is some struggle litigation.
But the individual who was shot was YSL. And you put him with another name? Not regular.
I'm sorry.
Now I want to ask you about some incidents that occurred in February of 2015. February 10th specifically. Do you
Bird.
recall looking at an APD case report where there was a shooting of Kelvin Watts? Yes. Do you know where that shooting occurred? It was over in Zone 3 on University Avenue, but it was very close to 30 deep territory. And Kelvin Watts, was he associated with a gang? Yes, the Inglewood family was. On that same day, was there a shooting at 193 Hendrick? Yes. And who was associated with Hendrick Avenue? Kenneth Copeland's family, his brother. And again, same Kenneth Copeland as above? Yes. YSL? Yes. And then on February 19, 2015, was there a shooting involving Kenneth Copeland and his child's mother?
I'm going to object to leading, Your Honor.
Sustained.
What, if anything, occurred on February 19, 2015?
Object to leading, Your Honor.
Overruled.
If that's the one over at, Villages of Carver, whenever, Chief Copeland was at his, girlfriend's house, he, was walking out with his baby. and-
She's legitimately sitting on the floor writing. Y'all pray for this.
Do you know who the writers?
This is not.
Yes,
Chart papers into the chat again.
I'll have to look at the report refresh my memory, but I remember,
I'm not gonna do this. This is ridiculous. Is she sitting on the floor? Is she squatting?
It was, yeah, Beyonce Fleetwood.
Oh my
it was
gosh.
Josiah Johnson. And I never think of the last guy's name, but it was his girlfriend's car that they showed up in. The reason why we was able to solve the crime. Octavia's.
I can see this. But you don't have to have poor handwriting. You can just put this on chart paper. You already knew you were going to do this. This is not new. You knew you were going to do this.
Now.
And Simone Hilton is tall too, by the way. Right down the street, around the corner, go to Kinko's.
Now, within the first 6 months of 2015, did there ever come a point in which it appeared that the shootings kind of died down within the early portions of 2015?
Yes, around after those incidents in February, I think March was pretty quiet for us.
Given the fact that she has no reports in front of her, how is she saying this?
You said March was pretty quiet.
Yes.
Right.
There's nothing in front of her. How is she making these statements about March 2015?
Did it pick back up again at some point?
April.
Okay.
How do you know that?
As a part of your familiarity with Operation Planners and what was happening in 2015, was there a shooting on April 12th involving an individual by the name of
Objection, Your Honor, repeating.
I can rephrase. Are you aware of a shooting that occurred on April 12th, 2015?
Yes.
Who was the victim in that case?
Was that the one on 490 Glen? Or?
Let me ask you a better question.
Right.
Are you familiar with an individual by the name of Dexter Montgomery?
Yes.
Okay. And were you familiar with a shooting involving a Dexter Montgomery?
Yes.
Did that occur in April of 2015?
Yes.
Also, are you familiar with the individual that goes by the name of Dwayne Carter or Little Wayne?
Yes.
Were you familiar with a shooting of his that occurred in April of 2015?
I do. I am.
How does she just know these numbers and addresses?
Were those two shootings considered a part of the Operation Planters?
They were.
Were those two shootings particularly determined part of the gang war between YFN and If Gang?
Yes.
Relevance.
Sustained.
Now, I want to take you specifically to April 28th, 2015.
I got no problem with you preparing a witness, but why doesn't your witness at least have some paper in front of him, of her, to pretend like she?
A report.
Lord, she is not doing another one.
0288.
Yes.
Y'all, come on. These people, you are not doing this again.
And do you recall?
I think I have one of those easels downstairs too.
Location that incident was?
I don't recall by case number. If you give me the location, I can probably tell you what happened there.
Was there an incident at Club Crucial?
Yes.
What occurred at Club Crucial?
It was a shootout.
Yes, say, Your Honor.
A shootout at Club Crucial.
Objection,
Sign me up.
cumulative.
They messing with her.
Just a little leeway.
It's
Just
all been
get the
cumulative,
facts on
Your
the
Honor.
paper. Overruled.
I'm going to show you what's been admitted as 1JJ.
What is the?
Looking at State Exhibit 1JJ, do you see?
Thank you.
The incident number for 1JJ?
Yes.
What is that incident number?
151180288.
And where is that location?
2517 Donald Lee Hollowell, which would be Club Crucial.
Club Crucial.
Can you also show me what's been admitted as 2 Tango Tango?
What in the world is this picture pages going on? I don't think so, Filipino girl. You can, I think you can probably follow along with us. The the examination and cross-examination of Sprinkle was kind of interesting because Brian Steele, I'll take that back. Brian Steele did, he did violate
And while we're
Sprinkle.
waiting for that to come up, was there an incident at 1903 Jew Drive?
Yes.
Was there also an incident that morning at 1428 Adele?
Yes.
And was there also an incident at 2900?
Yes.
She's trying her best to make up for yesterday. Yesterday was a dumpster fire. She is trying her best.
Of course, it goes along. While we're waiting, the incident at Club Crucial, who was involved in that incident?
Objection cumulative.
I'll ask again.
Yet again.
Was the individual a YSL associate?
Yes.
Yep. Oh my gosh.
Yes.
Okay. I'm not trying to just be mean, but this is looking so, again, if you were a classroom teacher and you knew that you were going to be doing charts in class during a observation, it would be a pox upon you to not have those charts done ahead of time. There's no reason. Now, sure, you can still, if you were, I don't know, if you were in front of your class doing a language arts lesson and you ask your second graders, give me words that start with a hard C sound. Cat, catch. Okay, got you. And you're writing those up there. That makes sense. Or even have the kids come up there and write it on the board. That's fine. But if you're going to do something that would be akin to an anchor chart, and an anchor chart is one that if you go to your class, most of us, when you were little, your teacher would have these professionally made posters in class. And it could be about language arts or math or science or whatever. And those transitioned to now teacher made charts, and they're called anchor charts. So they're just anchoring you down to a topic. So for example, if we're talking about the scientific method. So I'll do an anchor chart about the scientific method. So in one part of the classroom, that's where I hang all the science charts. So you could always go back over there as a little person and kind of look at them and, remember and all that kind of good jazz like that. Got it. The jury is going to be doing that same thing. So this chart that she's making is going to be useful because the jury is not keeping track of all this. So being able to say, oh, there's a chart, let me look at it. That's useful. Why not write it in English? It looks like she's writing in tongues, for crying out loud. I'm not trying to be mean and ugly about it, but my goodness, in the morning, have the wherewithal. Again, if you're going to put these men in jail for the rest of their lives, at least go to Kinko's and get a chart made, at least a modicum of professionally. That's it. It makes no sense. I got a ton of chart paper in my classroom, in my garage. You could reach out to me and I will not make you any charts, but at least I know that you reached out to me. That's okay, Simone. It's all good. Go to Kinko's, go to the kids store. I mean, Lakeshore. They'll make the charts for you, for crying out loud. But this right here is just embarrassing. It's just embarrassing. And the thing is that the jury is going to need this in the deliberation. I hope they don't. I hope they just slap it down and say this is bogus and it takes them 10 minutes. But if they need it, at least they're going to have it. And this is ridiculous. I'm sorry. There's no way that this is professional. And don't you dare come to me. Don't you waste your time. Big screen. Don't you waste your time telling me that these are lawyers. Don't you dare tell me, oh, these are lawyers. They don't have to do this stuff. Then dang it, then don't put somebody in jail for 100,000 years. If you can't do your job effectively enough to, if you can't do your job effectively enough to at least give these people something reasonable to go over, then don't put them in jail then. Go do something else. Man, if they can't afford some anchor charts, this chart paper I got over here costs all of like
I'm gonna show you
$7.
what's that 4 kilo.
It costs about $7. Now this ain't the one with the sticky notes on the back, but and it's got
And
this
what
was a good one
incident is
too. It's got like
4?
100
What
sheets on it.
incident number is 4 kilo?
151180462.
Lord, this woman's still writing.
And what's that incident location?
I'm about to crash out. I gotta go
1428
I gotta go
Dale
walk around
Avenue,
in a circle.
Southwest.
And then I'm gonna show you 2 Lima.
Papa.
What is that incident number?
Incident number 151180588.
And what's that incident location?
1903 Drew Drive, Northwest. Apartment 1, no, thought it was apartment, no, B110. Yeah, apartment 1122.
And then on that same day, was there a incident at 2900 Landrum Drive?
Yes,
And do you know that case number sitting here today?
I don't know it by heart.
I'm going to, Commissioner Cochran, I'm going to show you what's been marked for identification only as 600 YYR. We're looking at the help refresher memory as to what the incident number was for 2900 Landrum.
Okay.
What is that incident number?
It's 151180531.
She on the flow. How would they expect her to actually remember this actually from 10 years ago? Like she's giving her numbers, expect like she remembers them.
Looking at the first, would this have been in chronological order? Yes.
You got that on chart paper already.
For 0588, was that the location where the Mikian, something happened to the Mikian Garland?
Yes, he was shot at the club.
And Mikian Garland, who did he associate with?
YSL.
Now, 1428 Adele Avenue, where was that location?
That was Underwood family gang member Darren Mills' address.
And what occurred at that location?
No, dog.
Yes, the house was shot up. And I think,
No, dog. She could have did this in a very creative way that the jury would be able to take that sheet and be able to extract that information and make a good deliberation. This writing up in here, writing in a foreign language in unknown tongues is just dumb. I'm sorry. I'm sorry. There's no excuse for this. I'm not giving any quarter for this. And not just because I don't, no, there's no quarter for that. There's no excuse for what we're watching. None whatsoever.
that was
Catch me outside.
Philip Collins' girlfriend's apartment.
It's a Philo or Philip?
Philip Collins, aka Philo. His nickname is Philo.
And was he white?
He was Underwood family.
So on April 28, 2015, there was an incident involving a YSL gang member at the club getting beat up.
Yes.
And then right after that, there was a shooting at.
Actions of leading, competitive.
That's Nancy.
Sustained.
Is this what occurred on that day?
Yes.
Now, looking at what happened in April 28th, 2015.
Lord, she flipping pages now. Lord have mercy, please have mercy. And she tore it or folded it.
And January 26, 2015, was that the kind of example of the back and forth that was happening over the course of those first 6 months of 2015?
Yeah, I object to the example if they want to prove it individually, otherwise I object to the characterization of the example.
In your opinion,
Go ahead.
in your opinion, was that the back and forth that was happening based on police reports in January 25th, January through June
That
25th?
doesn't call for opinion testimony. I object.
Sustained.
Was this what was happening?
Yes.
Was it a lot of back and forth?
Yes.
All right. Now, as a part of your investigation, I want to take you to September of 2015. Were there any incidents involving an individual by the name of Shannon Stillwell as a part of your operation planners?
Yes.
And I want to specifically talk about September 26, 2015. Was there an incident involving also a woman by the name of Tierra Jones?
Yes.
And the individuals, were you aware of the individuals who were charged in that incident?
Yes, they were Inglewood.
This is cumulative. And it's also, in my opinion, my humble opinion, and it's also hearsay, and the expert is using as a conduit, is being used as a conduit for hearsay at this point.
Your Honor, this case was
Experts can testify based on hearsay. Overruled.
the individuals who were charged. Are you aware of an individual by the name of Dominique Carter?
Yes.
Does he have a nickname?
Stewie.
What about an individual by the name of Bobby Hardy?
Yes.
Is his nickname Smoke?
Yes.
How does she
Is that
know
the same
this?
Bobby Hardy that we discussed for the incident that occurred February 19, 2015?
Yes.
And then it was an individual who goes by the nickname of Merrill.
Yes.
His name Jamal Ward.
Yes.
Were those individuals ultimately charged for what happened on 9/26/2015?
They were.
And were those individuals a part of If Gang as well?
Yes.
Now, taking you to about 4 days after that, on September 30th, 2015, were you, as a part of your investigation, did you learn of an incident that occurred at Magic City Adult Entertainment Center?
Yes.
And what occurred at that location?
You're saying you're on a confrontation clause.
Was there a surveillance video? Were you able to observe a surveillance video at that location?
Yes.
And did you observe that surveillance video in preparation for court today?
Yes.
And Your Honor, may I approach?
Yes.
I'm going to show you what's been marked as State's Exhibit 543Y. Do you recognize State's Exhibit 543Y?
Yes.
How do you recognize it?
It's a video that I initialed, it's a CD rather of a video from Magic City that I initialed today.
And does that video contain an incident involving a person by the name of Martinez Arnold?
Yes.
To foundation. Can't use the exhibit, of course, in evidence. I object to foundation.
Does that show an incident that occurred at Magic City nightclub in September 2015?
Yes.
Same objection.
So you're saying what it is before it's been
Have you,
admitted.
were you aware of an incident at Magic City?
Yes.
I asked that earlier.
Right.
Okay. And have you seen a video regarding an incident that occurred at Magic City?
Yes.
Was that a fair and accurate depiction of the video of what you understand occurred at Magic City back?
Excuse me, I apologize. I will object to foundation. There's no foundation for this issue of this exhibit.
How were you aware of the incident that occurred at Magic City?
I was aware because it was YSL member that was jumped inside of the club. And so,
Hearsay and.
Okay, I think we're gonna break for the day. We'll sort this out. And I know that
I knew
somebody
it.
needed to leave early today anyway, so it seems like a good place to stop. I'm gonna see y'all all on Monday, and I'm wondering, y'all come up here for a second. Y'all can go ahead and be gathering your stuff, but I may have y'all come in at 9:30 instead of 9, but I need to consult on some scheduling first, so don't leave before you get the show up time for Monday. Remember, don't talk to anybody about the case. Don't let anybody talk to you about the case. Do not view, read, observe any kind of media or social media or news or anything about the case or anybody involved in it.
Contrary to popular belief,
So
all
y'all can go out to the jury room and I'll give y'all the show up time soon.
all jurors are welcome in this chat. Welcome all jurors. Yo, I gotta pull this up real quick. Let me pull this up real quick. Shout out to whoever said this on Twitter. It said, "Hey Paige, I watched every episode of Law and Order. Can I be a lawyer?" All right, let's bring this back.
And 66. I don't know that the motion to reconsider is really gonna, I think it might be mooted. Well, to the extent I'm gonna need to entertain that, we'll have to deal with that as well. So I don't know that we can do that in 30 minutes. Do y'all think so? All of those things? I mean, maybe, but instead of having them show up at 9 and not reach them until 9:30 or 10.
What are, Your Honor, 64, 65, and 66, subsequent order.
What?
I just don't know off the top of my head.
I mean, I don't know. They're the last 3 motions in limine that Mr. Steele filed that we never reached because we've been in court all day. I mean, all week. Oh, yes, thanks. But you don't know what time to be back either, but they'll let you know. Sorry. And I'm going to get y'all's responses sometime today. They're due today.
Yes, Your Honor.
And of course, they will as well.
I was going to update the court in terms of scheduling Monday. Me and Ms. D. Williams have been talking extensively about the remaining objections for Act 79 through 81.
Okay.
We're going to speak again after court today.
Okay.
There may be a very brief disagreement on the remainder,
Okay.
but we expect it would be quite brief and similar to the arguments that we've discussed previously. I just wanted to.
All right, well, great. Then that could be something we can finalize.
Yes, Your Honor.
Monday morning. I'm just going to tell them 9:30 and tell y'all 8:30. And I think we can get through those things in an hour, but I don't think we could get through them in a half an hour. Okay. Laura, do you mind letting them know that? What?
Okay. Your Honor, I would just humbly ask that if the state could provide us with an updated roadmap of what witnesses.
Yeah, they're
Yeah.
supposed to be doing that. And did y'all say you had already emailed it?
No, not yet, Your Honor. We will email that today.
Thank you.
Okay.
Is this from,
For next week.
we'll definitely have, I think, for Monday, and we're trying to just confirm some other things, but we'll definitely have the witnesses for Monday.
Okay, so it needs to be for next week, and if some of them are, we're not sure about this person, then just put a little note, we're not sure about this person, or it may be this group, if not, it's gonna be that group, okay? But that needs to be done today for the whole week. All right, if there's nothing else, I'll see everybody at 8:30 on Monday.
You said today 11:59 is okay?
I didn't actually give y'all a time, but I mean,
was a bad joke.
Yeah. I'm sure that for the witness list, everybody would like it before then. For the responses, 11:59 is fine if y'all don't have them ready yet.
Thank you.
All right, I'm going to take a, all right, so we're adjourned for the day.
Thank you.
For this.
Sorry about that. They be killing that camera quick. They ain't playing. Let me see real quick if we can shout out to all the jurors that just jumped in. We got 632 people in here. I saw it jump up a few people. I know the jury jumped in. I know y'all up in here. Y'all, this thing is ridiculous. This is ridiculous. And I'm going to say it again. I know people don't like me saying it, but I think it is totally inappropriate for a legal expert who wants to be taken seriously to be writing handwritten notes on I'm trying to find Sledge. That's what I've been trying to find. I don't see that it's being streamed. I'm trying to find where it is. If of course, if you got it, please email it to me or hit me up on Twitter or shoot me a direct message in Discord. But I think it's every bit as disingenuous to show that you're not serious, you're not intentional. 11 Live is a feed up. Thank you so much. Thank you so much. We're going to watch that real quick. Okay. Is this the... No, this is the original. This is what we just watched. Let me see. I don't see Moontunk stream. I'm looking. I don't see it. I don't know who will be represented. I don't know if it's going to be 11 Alive. I'm on 11 Alive right now, my friend. I don't see it. Because the stream right now is the case that we just got done watching. Let me just look at Atlanta news first. Yeah, everything has been it's not 4 yet, but I didn't know if it would even be. I want to make sure it's going to be streamed. If they're going to have it available, I want to make sure. Yeah, and there was a lot of leading that witness. There was a lot of leading, and I'm like, how would she know? How can she tell you emphatically this happened on January 15th, 2015? How does she know that? No, at least if she has some notes in front of her with the whole, can I read, kind of look at my report? All right, let's see. Let's see what we got. Okay, I'm looking just to see where. All right, I did not see it over yet. Jump on law crime real quick. Checking my email, going to my email right now. Going to my email. Thank y'all so much. This has been a lot of fun. I have to say, this was a little bit more fun than I thought it would be today. All right, thank you so much. I got the. But this is another streamer. But where is he? Where's this stream coming from? I see Classy C is going to be streaming it, but where is he getting it from? That's so, because I want to just be ready and have it ready All right. I saw your email. I got Classy C ready, but I just don't know where he's getting it from. Rome, jump in, my brother. Rome, jump in. All right. If you got a moment, Rome, jump in. Monica, same thing. All right. Looking like see, I don't know. That's why I've been looking. I've been wondering. I don't know if it's going to be streamed. So that was what I was wondering about. So I don't actually know the answer to your question, Whitney. But I'll just keep looking. We're gonna keep looking. We're gonna get Rome or Monica to jump in with me as well. And we'll just talk it up a little bit. But I thought that was a good exchange today. I really did enjoy Brian Steele. I think it's interesting the contrast between the prosecution and the defense. And I'm looking forward to when the defense has a case in chief. I do think that's going to be super interesting. So we're going to see how it all pans out. I like it. I like it. Mm. Okay, looking through, searching through. No, and that was very interesting as well that Sprinkle said that in his report, he said that he didn't think that Thug had anything to do with it. And the people that they mentioned all have gotten some kind of plea deal or are not in that courtroom. I'm sorry, one person was in that courtroom. So I got to go back and listen to it. So I think that's going to be interesting. I like it. I like it. Yeah, I see everybody has it ready. I just don't know where they're getting the actual stream from. I've been on Law and Crime, I've been on there. Yeah, everybody's waiting for it to start at 4 o'clock, but they don't actually. Nobody's saying where they're getting the stream from, which is going to be interesting if it starts at 4 o'clock and there's no stream. That's what I'm trying to avoid. Fox 5 Atlanta jumped over there. Let's go. Okay, this one actually is moving. And it says the trial hearing of Antonio Moontoon Sledge. So I'm going to go with this one actually being it. So let's pull this in. I'm gonna go on a limb and say this one might be it. So this is on Fox 5 and it's moving. So when it's moving, that means it's grooving. So things is happening over there. So let's see. Hopefully we'll get a chance to hear Lady. Drop myself out. Hear Lady Merchant today. All right. So I'm on Fox 5. It looks like we got it. Yeah, I think we got it. Yeah, there's somebody walking around. So just refreshing it, making sure we got the newest and truest. I'm gonna leave this right here. We are ready to go. I'm gonna give him a little like real quick. Shout out to Fox Atlanta. Make sure I jump in there and say hello. All right, so producer Jason, he be struggling sometimes, but I appreciate the very kind words. Thank y'all so much. Ashley Merchant. Oh yeah, why did I say Ashley Merchant? You're right. We're not hearing Ashley Merchant today. It should be Mr. I think his last name. I think his name's Anthony Wright or Patrick Wright. Last name is Wright. We got my brother from another. How are you, friend?
Hey, brother, how you doing?
Quite well, thank you. All right, you ready to parse through this? We're gonna figure it out.
Absolutely. You know, I just came in late today, so I'm still downtown, but I can follow along.
Love it, love it. Thug case that we're going to be over at 4:00. Oh, I see some zooming in. Okay. Thug's case was supposed to be over at 4:00 today. Okay, we're golden. Let's go.
Well, Felicia, I'm here because I'm the down bad expert. So I gotta let you guys know how down bad people are.
Right. There we go. And I'm the Adidas expert. Got to teach. Got to make sure y'all know what Adidas are about, man. Come on.
You know somebody gonna make an old joke soon about that.
What? Oh, bruh. I make no qualms about it. I love Adidas.
Okay, there go Atkins fade. Okay.
That does look like Atkins. Okay, I thought it was me. Rome's cheerleading squad.
I know that
is in the
fade
building.
anywhere. That's the family. I appreciate the love from the family.
Absolutely. Hey man, Rome, do you realize, man, we have 320 plus members in the DWC Rico gang?
Look,
My man.
it's cases on everybody.
There's cases on cases on cases up in here, man. I'm telling you, man,
Cases
in a minute.
on everybody. Bro, someone said they subscribe. Look, don't try to blow my head up, Mo. Don't do me like that.
Oh no, I've heard people say this, man. I sent you a picture. Somebody said that earlier.
Look,
Yeah,
those are bots. I don't believe it. I don't believe it.
I sent you the screenshot. I sent you the screenshot. Look in Discord. I sent you the screenshot, man.
Let's see.
They got Whitaker.
Let's hope they don't bring up another chart.
Oh my gosh, bro.
Let's hope they don't bring up another chart. And
yeah, I don't need to crash out.
that's the only thing I'm wishing for right now. Maybe they saw our live when I had my rant about their Excel spreadsheet that looked like it was put together in like 2 minutes.
Man, they could just make that look so much more professional. Because it goes with the scrambling and scraping motif. That's the problem. Like if they just brought a chart, imagine if they brought a chart, all their charts were just done really well, some form of uniformity, so on and so forth. That would probably change what most people think about this court. Is that fair?
I mean this respectfully. I really do. And I said, this is like Max would say, this is my humble opinion. Since when has professional and Fulton DA went together?
Going in the same sentence? I don't know. That's fair. But
we're talking about the people who work under Fannie. Let's be honest.
Right. My opinion is it adds it. It would if they were polished in one area, it would help you to look at them differently. But they continue to be unprofessional. They continue.
They
to
are
be
polished in one area. They are polished in one area.
Failure.
Deception.
Well, there's that too. There's that as well.
The deception does lead to the failure. It's the root of the cause. Like Most of the
Yeah,
stuff that
that's
they
right.
got kicked out came in by deception.
That's a good point. Shout out to look at Republic Tea Room. Thank you
Shout
so
out to
much.
Republic. Look,
Absolutely, man. Y'all, if y'all got a gifted membership today,
look,
please make sure you say thank you.
that's an extra felony warrant.
Right, that's extra 10
That's an
months on
extra
your
felony warrant
probation.
for Republic.
Yeah, absolutely.
Yo,
Well, how long? How many months was that dude on probation? How many years did he have, Quandarius? Zachary? It's like
I think it was like 10, what was it, 20? 10 or
it was
20?
something ridiculous. It was like 180 months
It's
probation.
look, look, whatever they give them with that probation, the probation is the catch and release trap. It's always been like that in Fulton.
I'm right here. We're right
35
here,
days.
Joanna. We're right here. Let me hit refresh. Make sure they ain't tricking me.
But yeah, if you get any type of deal where probation is over 5 years, they're expecting you to go back. That's not really a
Hmm.
deal.
Yeah, we're right here, Joanna. We're ready. I'm on Fox 5 right now. I'm on Fox 5 right now. Let me jump
Moontunk
over.
is
Let me look at
30.
11 Alive real quick
Felicia,
as
are you
well.
serious?
Say again?
30 months or 30 years?
It was something ridiculous, though. It was a ridiculous number, that's for sure.
But if it's 30 years, look, now that's down bad. I can give my expert
That's down
opinion on
bad.
that.
Right,
Yeah.
right. See, yeah, 11 Alive is doing the same thing. Instead of putting the seal up, they just have this big 11 Alive coverage will begin
Oh
soon.
my. Yeah, they're
Countdown.
confirming the 30 years. Oh my. Oh my.
Yo, that's crazy.
That's a slave contract if I've ever seen one.
Bruh, that's insane.
30 years. 30 years in the gang infested territory of Fulton.
Right.
And you know it comes with stipulations, so he probably can't travel.
Oh, yeah. That
Probably
was part of it. He couldn't travel without permission.
that is a
It was
trap
everything you
if
could
I've
think
ever
of.
seen it. That is a trap if I've ever seen it. So you're kind of forced to hang around your old buddies because
It got you
you
into
can't
trouble in the
go,
first place.
can't get a job.
Can't get a job. Man. But
Oh man,
but
they're
you're in the hood
remorseless
where
in
they know
Fulton.
you.
Oh my. And they just seen you on court testifying.
Correct.
Oh, they're dirty. And it
She
can
said 30
Kiana says it can be
years.
up to 35 years if
Dude,
he
that's
violates.
man, this is insane. Okay, camera's moving. Let's go. Oops. Just they're zooming in on the seal. Oh my goodness.
You remember I said this after he got done testifying, this would happen
Yeah,
because of
I
how Miss
remember.
Love was acting. Yep.
Oh yeah, we knew it. You good,
When
babe?
he
Hold on
tried
one
to
second.
apologize to her face to face before he got off the stand, he looked her in the eyes. He's like, "I'm sorry, Miss Love." She turned her head. I was like, "Yep, that's a warrant. That's gonna be a warrant, buddy." Yeah, that's what I was saying too, O'Neal. Anything if you ever get a deal where it's over 5 years on probation, that's a look. You might as well fight it in trial. I'll be honest with you because that's kind of like a catch-22 right there. Especially if you're not used to living in better conditions.
Yeah, I don't. They got us. They got folk counting the dots on the seal.
Well, they got
That's how you
some
know.
good eyesight.
Yeah, my eyesight is not like that. My eyesight is built differently.
I ain't got my glasses on right now, but that's some solid eyesight, gambler.
For sure.
I know not to play cards with you, buddy.
Absolutely. You be out there counting them cards, man. That's how. Look, we can't be going to Vegas with you, man. You be card counting. You gonna get us in trouble. Hold on one second. One second. One second.
Gambler photo on the little wanted screen over there in Vegas. I heard about him. 30 years probation is unconstitutional. Look, first sunflower. I don't. I'm gonna say this again respectfully and in my humble opinion. Fulton County doesn't believe That ain't gonna happen. That is not gonna happen. Yeah, I'm in agreement with that, Hollywood. 30 years and you're stuck in the conditions where you just came from, and then you got to show up in court and make a statement. So it makes further difficulty for you to just live. So it's not just about getting the job. Um, there are many, many difficult things on that because you can't travel, so you can't move without permission, which they won't give you. Um, oh, okay, my bad, Republic. Can you hear me now? Can I get a 1 in the chat?
We're back. We're back. We're back. We're back. Oh, that poll is going crazy. My poll is going crazy. Let's see what my poll is saying. All right, let's see. Oh, man. It's a 50-50.
I don't
Oh,
think
no.
Whitaker will do it. To be honest with you, I don't think Whitaker will. Look, we say a lot about Paige, but I don't think she has it in her to. I can see if it was a few years, but this is a
Yeah, it's like it's
this
gonna
is
be
a
8-10
brick.
years.
This is a life-changing break just for a misinterpretation of testimony.
Absolutely. I don't know if she's got it in her heart though, Joseph. I don't think she does. I don't think so. But we're gonna find out in a minute.
Because if she does this, I just feel like it'll be a very crazy look for the case, even more crazy. I can see them sanctioning him in other ways, but for them to revoke it and kind of just, oh, that's tough. That's tough.
Yeah.
It is Fulton, so anything can happen.
A whole bunch of anything, but yeah, I agree. Thank you to everybody who's been adding to the next. I already have 3 submissions for the new Jeopardy game. I don't know if you saw it,
Y'all out of
Rome King.
pocket. Y'all out of pocket.
Rome, the Jeopardy game is insane. But wait, so I ask everybody to just submit a funny video segment, like a short or a GIF from the trial. And I already got 3 of them, and they're pretty nice. So I think we're actually gonna have 2 games tomorrow. So we're gonna have the original Jeopardy game. I don't know if you saw the one I sent for you guys to look at this morning, but I'm gonna make another one tonight because I think it's
Is it
gonna
on
be.
Discord?
It was on Discord. Yeah, I'll send it out again. But
Okay, I gotta check it.
Yeah, but I'm gonna make another one with. I mean, because some of the pictures and videos that have already come in have been amazing. So if we can do that, was it 25 more
David.
times? David
David
Taylor?
wanted to
David Taylor?
know how is it not witness intimidation for future witnesses? It's just not. They're gonna try to make the argument as far as like they got him on the stand for a reason, for a deal that wasn't, committed to. This is the thing. That's my only foresight of why the judge may not revoke it per se. A lot of the testimony in this case has been kind of negligent or kind of just like even if he would have committed to it, I don't think it would have had too much difference on the case if he would have testified the way they wanted him to anyway.
Negligible, yeah.
So
I'm with you.
I can see if he was like a slam dunk witness that was just like, yeah, he had the gun, he shot him. I seen him sell 5 bricks of product.
Yeah.
Let me. All he was there to say was YSL is supposed to be a gang, and I was in the car with some people.
I mean, I hope they do it. I hope they do it, Escar. I really do.
Look, the way the Fulton County voting system set up, I don't have too much faith. I'm not gonna lie to you.
I got you. I
Not
understand.
gonna lie. They probably got some electoral stuff here that we don't even know about.
Shadiness.
Brittany, his testimony tracks with the evidence way more than the plea does. If anybody is inconsistent, it's the state. That's the other hang up that I had about it too, because the state did physically write him his testimony on
Yes,
his plea
yes,
agreement.
yes.
So he didn't proffer it or anything like that. They just basically took it upon themselves to tell him, this is what you said to us. Sign off on it.
Sign off on this. This is what you said. This is wild. All right, ladies and
Monica,
gentlemen,
I'm
we got
betting there
movement.
at the bench. Well,
We got
okay, there
movement.
we go.
Oh, it's in Charlie. It's in one Charlie.
Here we go.
There's Montunk right there. Come
All
on,
right,
let's go, Mr.
Mr. Sledge.
Sledge. I don't know about that patchwork jacket, but I'm
Look,
okay with it.
look,
I'm okay with it.
look. He going out in style. If he go out,
He said
God
going
forbid
out.
it don't happen. He said
Right.
he gonna go out a real winner either way. I just don't. Let's see how Miss Page sounds. Let's see how Miss Whitaker sounds.
Absolutely praying for Mr. Sledge. Absolutely.
Absolutely.
Don't hold your breath. Just praying, and things are gonna go how they should go. Absolutely.
Leave it in God's hand.
There you go. You got a clean cut. You ready to go? Let's go. I agree with you, Monica. Let's go. I got my text message ready to send him. I already got it ready. All right. All right. Okay, here we go.
I can feel the tension and the volume not even on. I can feel the
The volume not
tension
even
and
on.
the
Right,
volume
right.
not even on, man.
That's such a great
Oh,
question, Joanna. Why are we all like sitting here like this?
look,
This is
everybody
wild.
can feel it. Everybody can feel it.
This is wild, man. It's dope though. It's dope that so many people are interested in seeing this guy prevail in this regard. And it's just dope to see the support, man. Hopefully it'll
I mean,
prayerfully.
our chat has always had a heart. That's why I love the community right
Yeah.
here. You know, even though the members who showed up for that show last night, it just shows a lot of people here have a good amount of empathy, and
Yeah.
I really like that.
I agree 100%. No argument. Here we go. Here we go. Pages in the building, ladies and gentlemen. Court reporters in the building. Hit the mic. Let's do it. She just gave
No
up.
sound.
No sound. We can't hear you, Paige. She's killing us. You killing me, Smalls. I'm double checking, make sure it's not me. It's not me. Oh, they got a Bati in here too. Oh, come on.
Oh my God. I'm sorry. I can't use the G word.
Oh my goodness. Oh my goodness.
As soon as I saw the hair, I said, "Oh man."
Oh no. Here, let me check the other ones to make sure anybody else has
She
sound.
going for the neck.
Yes, she is.
She holds grudges. This is the worst DA you want on a revocation.
All right.
Can you hear? One in the
Yes,
chat
sir.
if you can hear.
This is a probation revocation matter.
One in the chat if you can hear. Let's go.
Yes, Judge. State filed a notice of a probation revocation for the defendant as to his violation of the special or a special condition within the sentence that he received from Judge Glanville on December 8th of 2023 as it relates to his reviewing, acknowledging that the factual acknowledgments that were a part reviewing, acknowledging that the factual acknowledgments that were a part of the plea agreement in which he entered into on December 8th of 2023. I have a certified copy of the conviction for your honor with a certified copy of the indictment, as well as a copy of the transcript of the plea that was taken on December 8th of 2023. An exhibit within that plea transcript is the plea agreement, which includes the sections, I believe it's sections 4 and sections 5 of the plea agreement as it relates to the factual acknowledgments that the defendant swore under oath during the plea that he had reviewed, then initialed each one of the factual acknowledgments, and then signed that he, again, understood and had reviewed each one of the acknowledgments that he initialed as part of the special conditions of his plea, that when called to testify, if called to testify, that the specific factual acknowledgments within the plea agreement were true and accurate statements, and that would be the testimony that he would provide as it relates to his witness testimony during the trial of this case. So I would present to the court State's Exhibits 1 and 2, as well as a USB drive of the defendant's testimony on day 124, 125, 126, and I think 127, Your Honor, but all of the defendant's testimony can be found on State's Exhibit 3. As everyone is aware, Your Honor witnessed it and can take judicial notice of everything that occurred during the testimony in which Mr. Sledge did testify. And I believe the court during, I think it was day 125, helped direct the defendant to sections 4 and 5 of the plea agreement during the testimony for him to focus on and read and to go one by one and acknowledge or disavow is the only word I could really think as to being no longer true and testifying under oath that he was violating the special conditions of his probation, Your Honor. So this time I would tender State's Exhibits 1, 2, and 3 for the court.
All right, I'm not quite sure I understand what 3 is.
3 is a USB drive with all of the testimony of the defendant. If Your Honor wants to preview it or wants to be part of the record.
Is that from the official transcript?
Well, it's the YouTube link, the live stream of all of the.
Okay, I'll just take judicial notice of it. I mean, if you want to make an exhibit, that's fine, but I'm not going to be relying on that. Since, as you know, it's only the official transcript that is the official transcript anyway, but I was here and witnessed it, so I will take judicial notice of it.
Yes, I'm very much aware of that. The transcript obviously is not ready as we're still in the midst of the trial.
Right.
I didn't want to overwhelm the court reporter who has been doing nothing but probably working hardest out of everyone in the courtroom. So I knew Your Honor,
right.
people could take judicial notice.
Thank you.
Can I approach this?
You may. And can you try to use a mic, please?
Yes, Your Honor.
Can they go to the court reporter?
Nothing further from the state at this time, Your Honor.
All right. Mr. Wright,
Your Honor, may I remain seated or?
it's probably easy. You can. It's probably easier to hear you that way.
Okay, I think I'm on. Your Honor, if it'll please the court, I believe, and I already sent to the court defendants 1 through 6. Defendants 1 through 5, I believe, were already, I think my emails between myself and Ms. Love came into evidence during our testimony.
Came into evidence in the trial of the defendants that are on trial right now.
Yes, Your Honor.
Yes.
So those are sort of resubmissions
Okay.
of those, but I do think they're already before the court, or the court can potentially take judicial notice of that.
What is your exhibit 6? I think I
Well,
only got 5.
exhibit 6 is the one thing, and that's just a listing of my emails in December between
Oh,
myself
that's
and
this
Ms.
one
Love.
page?
Yes.
Okay, it didn't have an exhibit marker on it.
I'm sorry,
So
Judge.
that's fine.
So succinctly, I thought it best to submit these exhibits. When you look at exhibits 1,
And those are admitted for purposes of this record, which is the probation revocation matter.
thank you, Judge. When you look at exhibits 1 and 2, what you see going on is plea negotiations in this case started on December 27th between myself and Ms. Love. You can see it's in the evening hours. And that's one reason I wanted to make sure that the sort of the cover page along with the attachment are part of these exhibits. At approximately 4:57 p.m. is when the email first comes in from Ms. Love. You see that a second one, defendants 2, comes in at 5:06 p.m. And at some point I respond. Those are the only 2 exhibits or the 2 drafts which occur on the 27th. However, it's important to note that when you see the response that I send to the email at 5:06, I send that response at 8:42. And I point out specific issues with the draft that need to be revised.
Right. Yeah, and
Now,
I recall we discussed this during the trial of this, the ongoing trial as well.
yes, Your Honor. And the point I won't belabor it is these revisions you actually see being put into the drafts. So by the time you see defendants 3 and defendants 4, they note that there's attachments updated to. You see that those very revisions that we requested are being put into the actual drafts. And ultimately, it was defendant's exhibit 4 that if you look on defendant 6, when the email comes in, it says, use this one. That is the agreement that we thought we were executing on the 28th. And remind you, on the 28th, we're in court. This isn't where I'm at my office. I can print it out, look at it, take it to the client like we did on the 27th. On the 28th.
On the 28th, both you and Mr. Sledge are in person in this courthouse, right?
Correct. So the emails, if you notice, I never respond because I'm here. I'm in person.
Right.
So we would get it and via phone, or if they would give me a draft, to take to him, I would literally go from the conference room back to the holding area. We would go through it, go over it. But the one that we thought was going to be the executed final was the same one that they said on defendants 4, use this one.
But are you testifying now, or are you just recalling
Well,
for me the testimony from previously during this ongoing trial?
I am asking the court to take judicial notice.
I will take judicial notice of what both you and Mr. Sledge testified to in the trial. I recall it.
Understood. So ultimately, the last thing that I think we mentioned in our testimony was where we did take issue with some things. We said he'll have a chance to answer the question and to explain. Now, there was a big problem, and I noted in my testimony that number 8 on that version that got signed had been taken out, removed. All of a sudden it reappears and it's there. My client initialed it. Yes, it was tendered. But ultimately, here's the problem. My client has always said he does not know who's responsible for shooting the victim, who he never was a participant or heard about planning the murder of the victim. And therefore, number 8 was put into evidence by Ms. Love to the court when it was a knowing statement. She knew that statement was false. That is,
I'm not sure about that. That may be your contention.
Well, we would contend to the court that where my actual email defendants 2 clearly denoted that.
It does not. It is up for debate what that denotes.
It is removed from all the drafts and then ends up back in.
That is true.
So.
But your response on your defendant's exhibit to item, what is then item number 4, does not definitively state anything like what you just said. He said he did not know, as we discussed at the time of the ongoing trial, could have been interpreted in several different ways. But I understand what you're saying.
And just so
You maintain that the two of you both missed the fact that you signed, or your client signed, a factual acknowledgement that included item number 8.
Correct.
And then when Ms. Love read it out orally in the court, and Mr. Sledge, one by one, said, yes, I acknowledge that somehow that didn't occur to you at that point in time either. So I understand what the assertion is. Here's the thing. You seem to be focused almost wholly, if not wholly, on, well, maybe there was a mistake with regard to factual assertion number 8. The issue that I see is that the state has not limited their petition to revoke probation to, he contradicted or he refused to acknowledge during the trial that item number 8. It is the entirety of disavowing factual acknowledgments, etc. And what got disavowed under oath in this trial was far more than just item number 8. It was item number 3, item number 4, item number 5, item number 6, item number 7, item number 8, item number 9, item number 16, and then the part 5, sentencing acknowledgments, number 1, number 2, number 3, number 4, number 5, number 6, and the paragraph underneath asserting that he's read and that they're true and that he understands that he's had an opportunity to discuss it and he voluntarily enters into it, et cetera, et cetera. So even if we entirely disregard item number 8 of the factual acknowledgments, there are still however many other ones that added up to that the state is still relying upon. And I don't see how you get around, and maybe you have a way to get around the rest of it, and I'm certainly willing to listen, but that one thing is sworn to in open court on December 28th of 2022, and then something diametrically opposite of that is sworn to under oath back on September 5th of this year.
I understand your concerns, Judge. One of the things that we traveled on after taking the plea was he would be able to explain his answers if he had issues.
Can I ask you a question about that? Is there anywhere in the guilty plea agreement in sentencing of your client in December of 2022 where you reserve that, where anybody, the state, the defense, or the court puts on the record that that's part of the understanding?
It is not in the written plea agreement, no.
All right.
However, in evaluating my client for the purpose of this hearing, I don't think the state is denying that that is something that it was understood, understanding it's not in the written plea agreement, but it was understood. And the other thing to also take note of, my client, when asked to make himself available, to meet with the state, to be prepared by the state, at all times would show up and do that. He was never provided or questioned it with any details such as, here, let's go over your plea agreement, these factual allegations, what questions may be asked. In other words, what you saw at trial was someone who was now after, what was that, December of 22, was now for the first time being drilled or asked questions rather as to the specifics of all the things that he had allocated, all the questions that were going to be asked. There was no preparation of him. So what you saw was probably frustration on his part at times and shutting down at times on his part. But it was also part of the manifestation of what happens when a witness who's not a lawyer, who's not someone used to this, is getting questions fired at them. And at some point, I think the court can take note that he literally shut down. And some of what the court saw may be more of a manifestation of being overwhelmed as opposed to trying to purposely change or diametrically say something different than what ultimately he allocated initially. So I, in retrospect, wish the state had actually, more than general questions, actually prepped him like you would normally see a witness be prepared and prepped. That did not happen. So you saw a very raw witness recounting things that happened quite some time ago and did not necessarily say things consistent with what he said before. But it wasn't simply for a malicious intent or an intent to deceive. There were several factors, is all I'm indicating, that may well explain why it was so difficult during his testimony.
All right, anything else you want to present?
Your Honor, not at this time. No.
All right. Can the state give me a quick rundown of what this defendant's prior history is, including any prior probation violations? And then I guess I know that the probation officer is on here, so I'd probably need to at some point ask that officer if they would like to be heard as well.
Your Honor, we would defer to probation as it relates to, I know they have a full account of his history. As
All
it
right,
relates.
you know what, I think I'm still on Zoom. Yeah. And what's the officer's name? John. Oh, it's my regular probation officer from long ago, whom I haven't seen in the last 2.5 months because I've been otherwise occupied.
Hello, Judge Whitaker.
Hello, I'm trying to, oops. Okay, I'm trying to get myself on video. Ah, I know. So that it's not a disembodied voice. Hang on. All right. Hello, Officer Jolly.
Hello, Judge.
All right. What is probation's? Can you give me a rundown of Mr. Sledge's criminal history? And I'm sure you heard the question I just asked, as well as any prior probation violations.
Well, currently, he'd used his first offender twice, one for DeKalb County, one for Fulton County.
Well, that's lucky.
The DeKalb,
Since you're only supposed to get to use it once. Okay.
yes, so the DeKalb County case, 04 CR 24799, that was theft by receiving stolen property, felon, and a obstruction of law enforcement officer, which was a misdemeanor. That was May 19th, 2005. I'm sorry.
Okay.
He used his first offender. The second case, 04 SC 23883, that's Fulton County. He used his first offender. That was possession of cocaine, as well as a possession with the intent to distribute cocaine. That was December 10th, 2004. The possession with intent to distribute cocaine in Fulton County was January 3rd, 2014. Again, both times, all three times, he used his first offender. The next case is 15 SC 138994. That is a Fulton County case. That is the gang participation, aggravated sex battery, attempted aggravated sex battery, aggravated battery, aggravated assault, criminal damage first degree, criminal damage second degree, and possession with the firearm by a convicted felon. That was January 10th, 2018.
All right, so given the fact that he had at that point a possession of a firearm by a convicted felon, does that indicate that at least one of those first offenders was not successfully completed?
One
Or are we
moment.
missing a felony?
One moment. That would be correct, Your Honor. In addition, of course, the current case that he is currently on probation on. As far as previous revocations,
So hang on, so the 15 SC and then this 22 SC case, right? Is there anything
Correct.
between the two of them?
there's nothing in between the two of them, no.
Okay. Are you looking about prior revocations or prior violations?
Yes, at this present time, I don't see any prior revocations. There was one documentation. It's a little bit, I guess, I'm having a hard time understanding what they meant by it. One moment.
Judge, while she's pulling that up, there is a 13 SC 123423 out of Fulton County. It's a BGCSA, possession of cocaine with the intent to distribute, where the defendant received 5 years probation on January 7th, 2014, which would be the predicate or basis for the possession of a firearm by a convicted felon of the
I
15
figured
SC.
there had to be something else there. Okay,
Sorry, I should have spoken sooner. I apologize.
appreciate it.
Yeah, the only documentation that I have regarding a revocation just said revoke closed July 16, 2008. Doesn't really show any actual time served or any time being revoked or continued on probation back in 2008.
Okay.
So I'm unsure if that's an actual revocation that was completed.
Okay, well, yeah, it sounds like maybe it was revoked, but it was just wrapped up in something else is how I would take that. I don't know, but, or that that a violation was found, but we don't know what that was or anything like that. All right, so does probation have a recommendation in this case?
Due to the last minute notification of this probation revocation, I will leave that up to the courts to make that decision.
Okay. All right. Well, I find there to have been a violation as alleged. And again, even discounting the item number 8. What is the state's recommendation?
Who cares what the state thinks? Sorry.
In full candor to the court, Your Honor, I'm going to leave it. The state is going to leave it in the full discretion of the court. Your Honor
Okay,
is
that's
fully
good.
aware of the conditions. Your Honor witnessed the testimony and how it affected the trial of the case. And I'm going to let Your Honor be the full steward of deciding what the penalty should be as it relates to all of the time that Mr. Sledge still has remaining on probation.
All right. Well, I know that at least I believe in the petition for revocation, the request is that the entire 30 years be revoked. Is that right?
It's not the
Or
request.
is, Oh, you're just telling me that's what he has at this point, although it can't be all of it, right? I mean, he's been on probation for at least a couple of years, and did he serve it? What's left?
He just started on December 8th of 2023. I think he got credit for the time. I think he was in for 2 years. So he would have 26 and change or 25 and change.
Come on. That's crazy.
I'm sorry, correct, 22.
My bad.
No, fix it.
The exact number.
Jump in, right? Help him, man. Do the right thing, right? You need to stand up and say something.
That would be 27 years, 7 months, and 8 days.
All right.
That's crazy.
All right, thank you. Anything else from either side?
Come on, right?
No,
Say
Your Honor,
something.
nothing further from the state.
Your Honor, if it please the court, I understand the court's ruling that there is a violation. Ultimately, I guess to some degree, while it's not clearly akin to a substantive versus technical violation of probation, it is a non-violent, non-new offense kind of violation. And I would say if the court is going to violate my client, it would be more germane to treat it as a technical violation. We have expressed to the court different thoughts and reasons for the way the testimony came out. We don't know what effect, if any, one way good or one way bad, that has had. But in terms of his violation, I would ask the court treat it more as a technical. He has one grandchild on the way, one that just came early this year with Ms. Jaquila Freeman. So the point is, he has been staying out of the way. He's been complying with probation. I would ask the court to maybe consider if you want to put more restrictions and make his probation much more of a, not just something he's on, but something that now has more teeth to it.
Community
because
service.
he's been working, he's been taking care of his family, he's staying out of trouble. He's turned that corner. And literally, it was always our hope he wouldn't have to come in and testify. And there was a reason the state allowed this plea to go forward so that he could step away. And in doing so, if you recall, you may have remember from his testimony, by no fault of his, he was a victim of a crime where he was shot multiple times and had to recover from that. So we would ask the court to consider some restrictions first, as opposed to custody. And if you do go with custody, we would ask to consider it as a technical type of violation, not a substantive violation in which you would be authorized to give him an even greater sentence. So we would leave it in the discretion of the court, but we're asking again for a non-custodial revocation punishment.
Okay, well, I don't view it as a technical violation or akin to a technical violation, considering the solemn oath that he took when he said that he understood every term within the plea agreement, factual acknowledgements, and sentencing acknowledgements, and understood and, in fact, orally answered that he understood when both asked by the prosecutor and the court at his plea hearing that failure to abide by any of the terms would constitute a violation of the agreement, and he was notified that the entirety of his probation could be revoked. I do appreciate the fact that this particular violation is a non-violent violation. But I also appreciate the fact that some of the why this could have occurred include the fact that there is just not a proper regard for the judicial system and the seriousness with
Wow.
which an oath in court needs to be taken. I actually view this much more akin to perjury, frankly, than
Oh my
a technical
gosh.
violation. And the sentence for perjury is up to 10 years. I am going to revoke 5 years of Mr. Sledge's probation. And Mr. Sledge, I am sympathetic to the fact that you have generally stayed out of trouble, and I want to commend you for that. And I really hope that this revocation doesn't set you back. But we've got to take seriously the court system. So
Wow.
that's the sentence of the court. I find there to have been that violation. I'm revoking 5 years.
And he will be continued on probation, Your Honor?
Yeah, and reinstate the balance.
Thank you.
Might I ask, is it possible for my client to turn himself in to make arrangements?
I think y'all knew when you came in here that this was a strong
Wow.
possibility. So, no, I'm sorry. All right, court is adjourned.
Wow.
Well, I'm gonna be honest, I expected it to go worse.
Thank you. Good to see you. All right.
The only person we could hear was Miss Jolly, so the only person we could hear was Miss Jolly.
Oh, wow.
Wow.
Yeah, I was expecting it to be worse.
I was expecting it to be worse too. Go on and hit the mic, Paige. You usually turn the mic off quick. Just go ahead and kill it.
I looked at you, I said, I thought she said she won't come down here.
Man, that's
After I conclude my reviews.
that's a gut punch.
We need the order from Miss Jolly.
Big one.
No.
Wow.
Hate to see it. And this is what I was saying earlier, that anything over 5 years is a trap.
Yeah, there's no way to, not no way, but yeah, I agree with you 100%. I mean, 20 years of probation, dude, that's insane.
And then if you violate 30.
Yeah, that's just bananas.
For cocaine violation. Like,
I mean, word, good gracious. All right, so that was it. All right.
yeah, that was a
Yeah, let me
tough one.
drop
I
this. Hold
know.
on. Okay. Go ahead. What'd you say, brother?
I know that's a tough one for the family to see, but that's how it works in Fulton.
Yeah, man, that was
It's important to see things like this because it can be happening in your city, in your town, and this is just
Sure.
because it's televised. So this doesn't just happen to just him. Ultimately, in my opinion, like I said earlier, it's going to fall on the lawyer at all times whenever you make deals to speak in your best interest. The way that he conducted himself, the attorney he trusted him because he'd known him for a long time.
Yeah.
Like a super long time, but that doesn't mean he's a good attorney per se, and I mean that respectfully. It's certain attorneys that can be good for misdemeanors or low grade felonies. He needed someone serious for this type of deal, and it showed. It showed now. You can't have all these mistakes from your attorney of all people because it's going to fall back on you as the client at the end of the day when it's in criminal court. He can misread something. He can skip a form. And it will always fall right back down to Mr. Sledge.
Right. Because the attorney's not going to jail. They didn't lock him up.
Bingo.
Right. So man, that's wow. That was.
And if we wanted to be technical, all of it fell on the attorney because even when he tried to explain how things were snuck in, these are things he was supposed to see and catch and make petitions of in the moment. And he wasn't. I get that he had some health conditions at the time, but that's no excuse when you have somebody's life in your hand. You take that retainer and you promise them that you can get them the best deal for their best interest, but he didn't. I would never tell a client take a possible 30-year cliffhanger,
Yeah.
especially with a history where every 5 or 7 years he may, get into a little riffraff.
Hmm.
It was a trap. The state knew his history, they knew his record. I just can't see that being something that was positive for his outcome to begin with.
Yeah. Wow. All right, man. That was definitely did not see that coming like that. Definitely did not see it going like that. But wow.
Oh, I'm not saying that his attorney. Let me go down. Uh, Demetria. I'm not saying that his attorney was bad. I'm just saying that he wasn't suited for this type of case.
Correct. Yeah. It's just and I think also let's also point out what you mean by that is the agreement, that initial agreement, he needed a different lawyer right then.
Yeah, you need a
So
more serious, more
when he
more
was pleading
dedicated
and
attorney.
right and getting those factual agreements, if you go back and read Martinez Arnold's factual agreements and then go read Montoon's Antonio Sledge's factual agreements, you'll see that they're night and day different.
Yep.
There's a lot of difference in there, and the attorney that fought for Martinez Arnold made sure that there's certain words that are not in there. So he could sit on the stand and say yes and amen to that. But
If you
go ahead.
if you review, I think it was like my second time on your live calling in, and I broke this down to pretty much to the T. Um, Specific attorneys are great in specific areas,
Yeah.
and you have to know this as you being a citizen. So I'm trying to find a silver lining, and the silver lining in this for the community is this is a prime example of you can trust an attorney for, felonies that are low grade. The fact that he even got a first offenders act twice was crazy to me.
You're crazy. It sounded like it read like 3 times though, but definitely twice. Yeah.
It was twice.
It was twice. Okay.
And you're only supposed to get that once in your life.
Right.
But so a lot of that goes to his attorney. So he had the ability to maneuver tricks of the trade for those lower grade felonies, but this is a indictment for it has murders on it, it has drive-by. He's testifying to a serious case,
Hmm.
a serious one where the head DA takes notice if something is out of place. And when you have to testify on something like that, you need somebody like Ashley, you need somebody like Steele, you need somebody like Doug, you need someone that is suited in that type of tense environment as an attorney. His attorney knew it. He was out of his depths, and that I'm saying that respectfully as I can. It
Right.
just wasn't in his tool shed.
Man. Pretty wild. All right. Well, we saw it. We know it.
Yeah, Republic Room. Yeah, that's what I was saying. 5 is excellent because he could have got the 27 that his PO read back.
Right.
Because it was a violation. She could have gave him the full amount, or at least for the perjury she wanted, he could have got 10. I get. I'm not saying everybody's rich. I am, lady. I'm just saying
Right.
these are the
Uh,
expectations you can have for uh, normal citizens. These are the expectations. I make this point every time we speak about Jeffrey. I'm like, everybody doesn't have steel attorney type money.
yeah, yeah.
So if you don't have that, you're looking identical to Mr. Sledge. They can railroad you, they can jack you up, they can push you around. That's what makes this trial so important to watch. A lot of people don't get to see that this stark reality of things happening in your own backyard that can happen to anybody at any time just
For
for
sure.
being around older friends or bad areas, or you can go to the club one night. Stuff can go sideways. You can get
In the
jumped,
club, we know it. Goodness.
and you could be right. God forbid, you can be in them shoes. Um, the top attorneys are expensive for that is correct, Greg. And they capitalize on pricing for top attorneys in Atlanta. I'll tell you that right now.
Get it, dude.
He also had
Yeah.
less than
All right.
24 hours
Just
to review the plea deal, which is wild to me. Once again, that all of that falls back to his attorney to make petitions of the court. So he can't just wait until a violation pops up, then says, "Yeah, by the way, we found this out the day before."
mm,
You gotta speak then and there. He was afraid that they were gonna toss the deal altogether, so he kept his mouth shut. But you can't have those type of fears when you got that type of time hanging on your over your head. How David Taylor, how do you find this type of corruption in your own area? You can sit in the open court. It happens every day, sadly. If you're in a major city, you will see this happen quite frequently.
yeah.
It'll be the first cases that are read before anybody gets to actually start the trial calendar or the hearing. They say who all has revocation hearing. They will say who violated, and they will be the first people up to be heard. And you'll see Miss Page was quite lenient compared to other Fulton County judges. I'll say that.
Wild.
I knew it was glorious that I knew they were gonna revoke her. I knew it was gonna fall to her. I was just praying she had some deeper humanity to kind of sit there and see the case from a citizen's perspective.
Right.
Uh, but she takes high offense to anybody embarrassing the state.
But why is that though?
We've noticed why that they
Why is it that she
so
doesn't? Because
so
she's saying stuff like this is serious, but you're watching the state not be serious. Like that's the
look,
part. Go ahead. I'm sorry.
you have to start seeing it in the light as I hate to say it, they're they're basically on the same team, no matter how you look at it. She's there to keep criminals off the street. DA's there to get criminals off the street. In her eyesight, she's thinking like, their goals are aligned. The court and the state goals are aligned.
Yeah.
So if they fall, she falls short. So when he does that on the stand, perjury, it makes her job fall short in front of the public. Even though we are the public and we know that we don't look at it that way, for her political mind, it's saying I'm getting a criminal off the street for lying. That's her political mindset.
But what about the criminal that's sitting in court lying to you?
Look,
Okay, I'm sorry. I'm sorry. I'm just like,
look,
okay, if she
look.
had the same heat, watch this. If she had the same smoke for Adrian in all of the instances that, I mean, yesterday was probably the most aggressive we've seen Judge Whitaker in a minute with throwing out Dennis. But it was Dennis did something boneheaded.
Most said it was the flagrant disregard for the law that I believe he was judged with. I get
I'm
that,
sorry.
but you gotta. I'm saying it to this degree. You have a case this sloppy, this poorly put together. It's so many factors you can put in there and be like, look, y'all only did this to him just to get him to say something in court that was probably strong armed anyway.
Right.
Um, but again, I don't think it was fragrant because when they broke down this man education, his upbringing, I wish more people could have seen the live we saw that we did last night.
Yeah. We'll have to,
I wish
but
they could. We did a live about Woody. Woody gave a little breakdown about his life, and it's an aspect of people that I wanted to see for the witnesses that they brought on the case because you begin to get a very good sense of how they get in trouble, why they get in trouble, what was their mindset. 9 times out of 10 is not as wild as you would think. It's not like they have total disregard or no conscience. They have poor impulse control. They have poor decision making skills because they grew up too fast. So when you get on the stand and you're snapping and yelling at this man, she knew he was going to do something out the way.
oh
That's the
yeah.
best way I put it. She knew it. She knew he wasn't educated like that. She knew she could belittle him to a fact of where he would snap or get out of character whenever she didn't hear something that she wanted to hear. it's certain aspects that they play a dirty game with, and like I said, that falls back to once you sign your name on that agreement that your attorney said is the best for you,
Yeah.
it goes left.
I think, well, one, I think the attorney should have stood up. I don't know what his health issues are. I don't, that's not my argument. But I think he should have stood up. And I do think he should have made a much more throw myself at the mercy of the court type of his plea was his argumentation to the judge to consider him as a grandfather. He should have pointed out that he's a dad. He's working. His family's going to be is going to be put in a bind. He could have made a much better plea instead of just what he did, which I think. And then immediately said, "Well, hey, can you just not throw him on the bus when you throw him in jail?" Like he should have went in there like, "You're not going to throw him in jail because of this. This is why you're not going to throw him in jail." Sure, he did wrong, but I think he could have made a better argument. A lot of people were not impressed with him, and nor
I'm
was
I'm,
I.
I'm
But
not either. I'm not
respectfully,
gonna lie to you, but that's why I'm trying to be respectful.
no,
It's it's, it's hard to see something like that. I know it's hard for the people that watch us to see it because I know they're like I said earlier. It's we have a empathy based community, but stuff like this needs to be seen so it's aware. You have some type of awareness.
yeah. I mean, he said he was a grandfather. I'm sorry, y'all know I'm big on telling stories, painting pictures. He should have painted. He should have been like Picasso up in that joint. He came in there with a smock on, and he's over there just like y'all let Hilton. Don't get me started. Y'all let me stop. Big screen. Y'all let Hilton sit there. Y'all let Hilton sit there today and draw and write like she's in doggone kindergarten on that board. And that's important. That's important, right? There's men that are criminals, bad dudes, right? Then why did you not, Mr. Wright, come in there, guns blazing? I'm coming in there with a full apron on. I got paint, and I'm doing my best doggone Bob. What's the guy name? The white guy with the afro. What was his name? Bob the painter man. I'm doing my best impersonation of that dude. I'm painting a picture. I'm showing you that this guy works. This guy works 40, 50 hours a week. He makes X amount of dollars to take care of his family. These are the bills and the responsibilities that he has. He's a member of the community now. He's been going to church. Look, I'm still, if you let Adrian Love sit there and talk to a donkey's ears fall off, then dag nabbit, I'm going to talk to the ears, get back on. I'm about to leave. And I'm sorry. He should have fought for that man.
Look,
if that was me, I'd be fighting. Look, the deputies would have had to arrest me because I done beat your head off of you because you should have fought for me. I done beat up my own attorney. I'm beating you up on my way out before I get in the right street and get stabbed by somebody, some crackhead. I'm gonna beat your tail. You should have fought for me.
And trust me,
Bob Ross, that's the guy's name. I'm so sorry.
Trust me, it's going to dwell on his attorney's mind. Don't think it
And I
won't.
hope it rots in his. I hope it rots in his conscience. I hope Paige can't sleep tonight. Adrian in that Dookie Brown jacket she rolled up in there. Y'all gotta get off
I
here.
won't say that. I won't say that. Paige gonna sleep just fine. But
I hope she don't.
I'm sorry. She's gonna sleep fine.
That
we got different type of judges. You know that she's gonna sleep just fine.
She gonna sleep fine. But I hope Adrian Love. I hope this kind of foolish. This is ridiculous. And at the end of the day, again, I don't know much about Antonio Sledge. And y'all, I had to delete the text message I was about to send him because I had a congratulations text message ready to go to him. Telling him I want to meet up with him tomorrow.
I want to speak real quick to who was it? Monica and scroll up. Oh, okay. It was someone who said there we go, wigs and wine. I'm sorry, I can't laugh at today. What crime did he commit that got him 20 or 30 years probation in the first place? I believe that was the battery case in 2018, or what was it? So he went to jail for 5 years for it. Got out in 23, and I'm not sure. It was like 4 counts of different battery. But my point is, when we heard his record and they were explaining his history, it was not like I was expecting. That's the best way I'll put it. I was expecting to hear drive-bys. I was expecting to hear all type of different stuff, fighting. Um, it
Yeah.
just sounds like he got to a point in 2018 where he was out of what my name say, down bad. Yeah,
He's just down bad.
he was down bad, and like Mo said he was apparently dropping off people to target random citizens for robbery. I think.
Yeah, I mean, hear me. I'm not saying the dude wasn't a good dude. I'm
I'm
saying
just saying what he
I'm
did
not a
on the
scoundrel.
stand wasn't worth that type of like 27 years. Like
Right, right.
I don't get how you can make that argument, but I get what they're trying to say. He wasn't a saint. But at the
No, by no
same
means.
time, I'm a person that believes if you do something equivalent that deserves time, sure. But because you had a meltdown on the stand during a trial that was forced, that's probably gonna get tossed anyway. And now he has to do 5 years for it. It makes no sense to me personally. In my moral opinion, my legal opinion, I know that's how it is. But my morality is like that's 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 evil.
Yeah.
It's evil. Now you see, it's why I have certain reservations from doing criminal law and why I stepped away from it. I would have to see stuff like that go down weekly. I couldn't sleep at night some nights. I couldn't, do my regular stuff, day-to-day stuff. I wasn't happy.
I gotta get ready to go. What's up, Mandy?
Yeah,
Mandy.
Jason.
Hey, I hope you
I'm
feeling
trying
better,
to see.
sis.
I'm getting there. Thank you. I'm waiting on my moderators, and I'm like, Donna pops in, and I was like, "Where is everybody?" She's like, and I said, "Oh, Jason's still alive, isn't he?"
I'm about to get off. I'm about to get
And
off.
no, no,
I'm
no,
supposed to
no.
go to
And then
school.
I
I'm supposed to be
click
at
on the
school
live
play.
stream, and I hear, "She gonna talk the ears off a dog. You trying to save that man?" I'm talking back home, and I'm like, "Oh."
I mean,
Becky, they might actually house him at their. I hope they don't. At Rice Street. But it's not a substantial sentence, so they might just keep him there.
So what
But if
happened?
I would prefer they not. They revoked Mr. Sledge.
They revoked his parole?
Yeah, for perjury for 5 years. You remember I was saying like Miss Love wasn't gonna
No,
let
they
that
didn't for
go.
perjury. They said that. They said
well,
that
she
man
said
up.
it's akin to perjury. She said she treats it like
She
perjury.
treated like luckily, if she would have did the full revocation on his probation, it could have been
A lot longer.
20 plus 20
Yeah.
plus years. So that was the type of deal he signed up for, and his
But
judge
he was
made
actually talking.
not
But
to
they
what
didn't
he
do that.
agreed to or what he said on the testimony that they wrote for him.
But they didn't do that to Woody.
Woody had immunity. Woody was fine. All he had to do was just show up.
Man.
That's why Ashley is like, look, you're gonna do one or the other here, or we not playing ball. She knows how Fulton is. That's why I was saying earlier before you got on, he didn't have the right lawyer with the right tools for that type of deal.
Wow.
He just didn't. He
Well,
probably couldn't
that
afford it,
is
like
messed
people
up.
in the chat said.
Yeah, and yeah, it's definitely not trying to belittle him and say that because he's broke or he doesn't have money to
Nah,
afford.
look,
No,
a
that's not
lot.
what we're saying at all. I hope nobody's getting that part. We're only saying that you have to realize you can't use the exact same lawyer that you would use to deal with a petty possession if you have something of this
My
magnitude.
my
That's
newest
all. Is that fair, Rome? Is that what you're saying?
my
Is that
newest car is 180K. I would have to sell that, and that would be half the money I would take to get me a good attorney to fight what he was fighting.
wow.
So you would need anywhere 300K plus to actually deal with a 30-year plus type of threat of prison. So it's tough, but
Yeah.
until legislation changes on certain things and certain things are humanized versus legalized, um, it'll look like that.
All right, I got to jump.
Yes, it will. All right. Grace and peace. Take care, friend.
Thank you for showing up.
If you're a moderator, I'll see you in Discord in a minute.
Yeah, jump over there. Jump over there. Okay, I gotta get y'all out of here. I'm
All right,
supposed to
all
be
right.
I'm supposed to be at the school play. So President Firstborn and Secondborn are in the school place. I need to get over there. Y'all, I thank y'all so much. And Rome, maybe we might, who knows? Maybe we'll do like a late night vent session or something tonight.
All right, just let me know. You got my number, bro.
You know where to find me, brothers. Everybody, thank y'all so much. Grace and peace, Rome. Thank you so much. Everybody, thank y'all so much for tapping in. I appreciate everybody who's been in the live chat. You know, hey, we win some, we lose some, but God is going to be glorified no matter what. Even in the midst of something that we see is unjust, Christ is still going to be honored and glorified in that. So that's my rest. That's my hope. I hope that's yours as well. You know where to find me, dearwokesy@gmail.com. I don't think Rome has an actual channel, love. I don't think he actually has a channel, but I'll make sure tonight I don't think he does. He's just a commenter. Yes, I need to get over to this play because my mom is on her way. I'm watching my mom on Life 360. So y'all, I appreciate y'all so much. And until next time, everyone, grace and peace. Take care.
Yo, hit that like for deal with Christian. Yo, for deal with Christian. Smash that bell for the upsy. Yo, smash it. Just smash it. Hit that like for deal with Christian. For deal with Christian. Smash that bell for the upsy. Yo, smash it. Just smash it. Hit that like for deal with Christian.